Before making a submission, I'm supposed to give the memo. I'm supposed to give the memo to them.
Madam, memos movement is the urgency is the memo and details hold up and fresh no. Fresh you have to upload the consent right. Section of the direction in the working. First you go to 80 urgency that not a post in my office of the complaint of post section officer approach money to give the memos to concerned section officer, let them enter and the memos why it is not posted at the enlargement money concerned what are there protect the section officer all fresh memos complaint ಮಾಡಬೇಕು ಆಫೀಸ್ ಇದು ಮೆಮೋಸ್ ಎಲ್ಲ ಫ್ರೆಶ್ಮೆಂಟ್ ಮೆಮೋಸ್ ನೀವೇ ತಗೊಂಡ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಅಂದು ನನಗೆ ಸಂಜೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬಿಡಿ ಕಂಪ್ಲೈಂಟ್ಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇತ್ತು ಅಂದ್ರೆ ನಂಬರ್ ವೈಸ್ ನನಗೊಂದು ಸ್ಲಿಪ್ ಕಳಿಸ್ಬಿಡಿ ಸಂಜೆಗೆ ಮೆಮೋಸ್ ಎಲ್ಲ ನಿಮಗೆ ಕೊಡ್ತಾರೆ ಅಲ್ಲಿ ಇಸ್ಕೊಂಡು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದ ನಂತರ ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ತೀವಿ ಕೊಟ್ಬಿಟ್ಟು ಕಳಿಸ್ಬಿಡಿ ಮೆಮೋಸ್ ನಮಗೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿ ವಾಪಸ್ ಕೊಡ್ತೀವಿ ಎಲ್ಲ ಬರ್ತಾರೆ ನೋಡಿ
Freshman 19673 of 25 madam.
Already March ಬಂದಿದೆ ಅದರ ನಂತರ ಬಂದಿಲ್ಲ ಮೊದಲು ಬರ್ತಿದ್ದೀನಿ ಎರಡು ಕನೆಕ್ಟ್
Number 19673 973.
Your Ladyship, may I please mention a matter, Your Ladyship?
Yes.
Your Ladyship, I'm moving a memo. Your Ladyship, this matter pertains to child custody. And
All the memos to the court officer, no mentioning, call the list.
There's one for being spoken to, my lord.
That also give to the court officer, no exception to any of the memos. Yes.
Page wise adjournment, list number 1, page number 2, serial number 5 to 7, page number 3, serial number 8 to 15.
13, my lords, I need a short accommodation. Other side is also there, I've informed.
Yes, Mr. Smarter, in the month of December. With the request of counsel the petitioner, it is submitted that the same is informed to the counsel for the respondent. Yes.
Page number 4, serial number 16 to 20.
Serial number 18.
17, my lord. Any date next week, my lord, 3rd or 7th or any other date, my lord. The other side has been informed already. This is to.
We have no objection, my lord. However, on the last date, my lord should instructed to keep the children present.
We are ready to keep the children present, my lord. In the late part of the evening, 3 o'clock or 2:30, my lord, it can be done. We'll bring the children. Absolutely no problem.
What was the order on the last occasion?
At 16:4, my lord, to keep the children and the parties present for in chambers or discussion with the honorable court, but by the predecessor, not by the same bench.
List this matter on 26th November in the chambers. Yes,
Serial
My lord,
number
may I
18.
may I request a time, my lord, at
5 o'clock.
5 o'clock. Obliged, much obliged.
Yes.
Serial number 18, my lord. A short accommodation may be granted.
You know objection. List the matter in the month of December at the request of learned counsel of the petition.
List number 2, page number 2, serial number 5 and 6. Page number 3, serial number 7 to 9. Page number 4, serial number 10 to 17. Page number 5, serial number 18 to 25. Page number 6, serial number 26, 27. List number 3, page number 2, serial number 4 and 5.
Serial number 4, memo.
Yes,
They are withdrawing the fee.
what is that? The memo is filed seeking to withdraw the petition. Same is taken on record and dismissed as withdrawn. Yes,
List number 4, page number 3, page number 4, serial number 9 to 16, page number 5, serial number 17 to 26, page number 6, 27 to 36, page number 7, 37 to 45, page number 8, 46 to 40, 46, 47, page number 9, serial number 48, 49, page
I'm applying for in serial number 49, madam. Place a week's time, madam.
for what?
I'm for respondent.
For what?
Since
It's
the
coming up for admission. Why you want time for that? Yes,
page number 10, serial number 50 to 55, page number 11, 56 to 60, page number 12, serial number 61, 62, list 1 for orders matter, serial number 1, Sridhar K. For petitioner, Jai Prakash
I
Rao.
appear for the respondent.
Petition in this matter.
In the last date, it was directed to file the assets and liabilities, Your Lordship. Copy has been served.
coffee?
Copy of the same is, I have to file it. I will file it today in the counter. Assets and liabilities for both the parties.
Kindly have it third, man. We are ready to file the affidavit also ready. We have filed it today itself.
Writ petition of 2022, an interlocutory order,
Yes, ma'am.
and it's pending from the last 3 years.
Yeah, there are last 2 years, this matter has been heard. And on 7/8/2025,
As per the interim order passed by this court on 7/8/2025,
the 7/8,
if the school fees and the maintenance amount is not paid by the petitioner,
Yes.
the stay granted by this court shall stand vacated.
School fee is not yet paid.
kindly
Your
bear the
Lordship.
7/8/2025
School
order,
fee is
please.
not yet paid.
Hmm?
Maintenance is up to 7.
1 minute, sir. Kindly bear the 7/8/2025 order, please.
What will happen to 22/9/2025 order?
No, 7/8/2025, the entire proceeding, the maintenance award has been stayed by this honorable court. Subsequently, the school fee has been paid.
That order has been.
Kindly bear the
vacated, Your Lordship.
7/8/2025 order, my lord. The entire order has been stayed.
Thereafter, this
Lordship,
is a modification to
thereafter-
that.
They filed the vacating application, the
That's
vacating
what I
application.
said, if the school fees and maintenance amount is not paid,
Yes.
then the stay will be vacated.
No,
It is
ma'am,
not
but
paid,
since
Your
till disposed, the still 7/8/2025 regularly paid.
Today, I'll
Yes.
modify that order today.
Yes.
Where is that?
7/8/2025.
Yes, I'll modify that today.
Yes.
And Your Lordship, it may be
50% of
directed
the
to
amount will be
deposit the
paid,
50% of maintenance. It has gone up to 7 lakhs, Your Lordship. Maintenance till now.
Only 1 lakh is paid, my lord. Balance is 1 lakh.
Then counsel for the petitioner submits that in spite of an order passed by the court, whereby the court has passed the order of maintenance and also directed the mother to permit the father for visitation of the children,
Yes.
right from the date of the order till now, the mother has not produced the children.
In the next date of the hearing, we'll produce before the court, Your Lordship. Children's or ಆಚೆ ಇದ್ ಮಾಡಕ್ಕೆ father, they are not willing. We can't force them. Next date for sure.
What
before
is the age of the children?
17 and 9, I guess. I'm not sure.
You're
One is
not
in the
sure what
college,
is the age of the child?
one is in the college, one is in the school. I would just check.
Finally, list this matter on that day. I am not, because the main writ petition is pending. Now all these assets and liabilities, all that I will not look into. I'll pass an order on 12th of November.
Cell number
Whatever
2.
papers you want to, whatever material you want to place on record, you place. No further adjournments.
Kindly have it 3rd of November, please. 3rd mail.
Yes, 3rd of November.
Much.
Cell number 2. Inita
IAP.
PC.
IAP for petitioner. Lordship, the matter has been settled in mediation. In fact, RPFC was referred to the mediation. In that agreement is drawn and wherein this writ petition also mentioned. So it will not survive for consideration.
You have
When
the
we-
memo?
Memo, I have already filed it.
Memo
I
for
filed it
disposal.
on 23rd October 2025.
A memo is filed stating that the parties have also filed RPFC number 115 of 24. And the same was referred to the mediation. And the matter is settled. And they've already filed a petition for mutual divorce as per the mediation agreement. Hence, nothing survives in this petition. Accordingly, this petition is dismissed as infructuous in the light of the settlement arrived at between the parties.
Please.
Cell number 3.
I appear for the petitioner, my lords. The office objection is being complied with, my lords. That was pertaining to restricting to one prayer.
Then why are they mentioning that type neat copy of prayer to be furnished to page number 11? That's the objection.
Please, my lord, that may be dispensed with, my lord. There's some
Why?
urgency. The only reason, my lords, is on the 3rd of November,
No, no.
the matter is
Basing on
listed.
your urgency, office objections will not be dispensed with. What is that page number?
In fact, it is that ink page number.
Let me look at it. What is that page number? 11?
Please, my lords. (34) and 35, my lords. That's the order sheet. On the left-hand portion, my lords, it's written by the court officer.
Yes. Office objections are overruled. Where is the order? Where is the order?
My lords, ink page number 34 and 35. That's annexure E, my lords. In fact, the petition was filed under section 13(1), subsection 3, my lords.
Please read the order. It's
Please,
not
my
order.
lords. It starts at page number 34, my lords. It says, heard both sides, peruse the order sheet. On 25/9/2019, the transferor/previous court allowed the IA number 6 under order 16 rule 1 and 2 of CPC to summon witnesses along with the witness number 3, Dr. Lakshmi V. Pandit. In spite of several opportunities, petitioner failed to secure the witness. Such being the case, after transfer of this matter to this court, petitioner filed similar application to summon the doctor on 17/11/2023 without disclosing the previous order passed by this court on similar application summoning the doctor.
What do you say?
My lords, two humble submissions for that, my lords. Earlier, the matter was listed before the Honorable Court at Mandya, my lords. Subsequently, the application was filed before the Honorable Court at Mandya under Order 16, Rule 1 and 2 to seek the doctor to come before the trial court for witness, as a witness, my lords. Because the petition was filed under Order Section 13(1), subsection 3, my lords. That's the only ground, my lords. Mental disorder is what the petitioner claims as a sole ground for divorce, my lords. The application came to be allowed by the trial court. But subsequently, there was COVID, my lords, and an application was pending before the trial court at Mandya for video conferencing, which had not been adjudicated upon, my lords. And immediately upon which, the matter got transferred to the Bangalore court, my lords.
So why another application is required now?
Unfortunately, I had not known about that, my lords. We are the new counsels in the Bangalore court. We were not informed about what had happened in Mandya court, my lords. Therefore, that application came to be filed.
You are right and court is also right.
My lords, the thing is this, my lords. If this application is not considered, though the application is already allowed, but if the application is not considered further, my lords, my case
Court
itself
notice.
would,
Court notice.
my lords, the matter is in the trial court on the 3rd, and they're proceeding with the matter without the evidence of the doctor.
No, we can take it up on 3rd itself.
Why
This
not?
matter on 3rd. Then counsel the petitioner should take out hand summons on the counsel appearing for the respondent and file a memo to that effect by 30th, by 31st. If it is filed, list this matter on 3rd.
Please, madam.
4,
Achha.
cell number 4, Abhishek Madla.
For the respondent in this case, my lords, on the previous date, my lords,
Yes.
the respondent was instructed to put.
What are your instructions?
Yeah, with respect to clarification, on 22/9/25, my lords, they are challenging the order which was passed on 29/9.
No, what I asked you
Yes,
is
with respect to,
order dated 22.
my lords was of the opinion that they are challenging 22/9 order.
I am not of that opinion.
Yes,
I asked 22/9/2025, some
Yes.
application
Yes,
is
madam.
filed under order 9, under order 18, rule 17.
Yes.
Who filed this? And
It
what
was
are the
filed by
documents?
the RW1.
That is
Now,
the
during
wife.
the, yes, just before that, my lords, in page number 12, if I may be permitted to read. On 15/9, both counsels and their parties are present. RW1 is further cross-examined. Exhibit P1, 159 and 160 are marked. Time is spread for further cross. That means the wife has been cross-examined further by the husband, who is the petitioner now. On 19/9, both counsels and their parties are present. RW1 is further cross-examined fully. Counsel for respondent seeks, that is, I seek time to examine witnesses, if any, from my side. So on the next day, there were certain allegations which were made during the cross-examination that I have done certain fraud, FIR has been registered against me by my previous employer. So keeping that in mind, I had to place certain documents on record. So on 22/9, we file an application to recall, reopen, recall, as well as to give further. That was allowed.
What are the documents?
The documents is part of here, my lords.
So these documents have come on record for the first time?
Yes, my lords.
On 22/9/2025?
Yes. So, my lords, on 23, what happens? They say we want to file objections. On 22/9, they take time to file objections. Next day, they come and say that counsel submit no objections. So that gets allowed and that gets marked. And again, they are fully cross-examined and that. That was the last cross-examination which has happened on 23/9/25. So including this cross-examination is completed in all respect. Now, my lords, on this application 11 and 12 has been filed. It says reopen enabling filing of list of witness. My lords, I am not even aware. What is the list of witness? Yes, my lord.
What are the documents that you want to file now? Produce before the
Not the
court?
documents, my lords. I want to summon the witness, my lords.
Who are the witnesses?
Witness.
Let's see your IA.
This is the Kannada. In that, my lords, exhibit number 31 to 33 are some photographs, my lords.
No. Please come to that 31 to 33 are long back there on record.
No, my lords. It is. She had produced certain photographs, my lords.
That no photos are produced recently.
It is, my lords, 31 and 33.
No, please understand. What has been produced is 159 and 160.
No, my lords. The
Latest one.
wife has produced certain photographs, my
When
lords.
was it produced?
23/9, my lords.
Yes. After that, you have cross-examined her at length.
Please, my lords. In that, I had cross-examined her. In the contents of those documents, my lords, are at dispute, my lords. And when I cross-examined regarding the photos,
But R12 to 35 are marked on 23/9. How many times the court will permit like this? Yes, comes with the respondent.
my lords, here, it is not even the, is a file witness list. Please grant permission to list, filing the witness list, not even the witness list. The part,
No.
it is,
No,
the
please look
list
at
of
it.
witness is
No,
also
no.
not here. Yes, my lords. My lords,
29,
one submission, my lords.
23/9/2025.
Yes, my lords.
Exhibit R12 to 35 are marked again.
Yes, my lords. That is been by them, by way of confrontation they have marked. That is, I have admitted. Certain things I have not admitted. No, my lords. She has marked it, my lords.
Who is the petitioner? Who is the respondent?
I am the respondent
Then
wife here.
R12 to 35 means what?
R12, it has been, she has not marked anything. The marking has happened like, that is by way of respondent, he has, by way of confrontation, it has been marked by showing certain photographs. So she has admitted certain things she has not admitted. Those admission, it is not even the documents.
It is marked on behalf of the petitioner or on behalf of the respondent?
On petition, now it shows that it is on behalf of R12, but actually it is the petitioner who has filed it because it is my cross-examination. How can I file it? I have already finished filing it.
No, that answer,
Yes.
that question court can't answer. You have to question the court.
Yes.
Why you are there?
My lords,
RW to R35.
I beg your pardon. My lords, I beg your pardon. I beg your pardon. In fact, R12 to R35 are those documents which has been marked. After no objection from their end.
He says photographs.
No photographs has been marked on that day.
R31 to 35
That is the
are
documents, my lords.
photographs.
The documents is before your lordship.
This is the chief examination, my lords.
No documents,
it's in Kannada,
no
my
photographs,
lords.
my lords. It has been marked.
Referring to?
31, I am not having the copy of that, my lords.
Please,
31
I'll
to 35 and 34 is the CD, my lords. What she has done is she has refused to answer and she has denied certain. My lords, when I put a question regarding 31 to 35, my lords, she has denied. So that's why the reason why, my lords, I want to witness a person.
My lords,
who
I
is in
have
that
marked the
photograph, my lords.
documents. Question of me not, denying that does not arise. I have marked it.
I want to.
How do I deny that?
I want to recall the person who is in that photographs, my lords, because she has denied the.
My lords, I have admitted.
Contents of that photographs, my lords.
What is the content of that photograph?
My lords, it's in Kannada, my lords, the cross examination. ನಿಶಾನೆ R31 ರಿಂದ 33ರವರೆಗೆ ಭಾವಚಿತ್ರಗಳನ್ನು ಕಾಣುವಂತೆ ಬೆಳ್ಳಿಯ ಸಾಮಾನುಗಳನ್ನು ಅರ್ಜಿದಾರರು ಆ ಸಮಯದಲ್ಲಿ ಕೇವಲ ನಿಮ್ಮ ಇಚ್ಛೆಯಂತೆ ತೋರಿಕೆಗಾಗಿ ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಭಾವಚಿತ್ರಗಳನ್ನು ವಸ್ತುಗಳನ್ನು ನೀಡುತ್ತಿದ್ದ ನನ್ನ ಸಹೋದರ ಮಾವ ಮತ್ತು ಸಹೋದರ ಅತ್ತೆಯರೆಂದರೆ ನಿಜ. ಆ ಭಾವಚಿತ್ರಗಳಲ್ಲಿ ಅವರ ಚಿಕ್ಕಪ್ಪ ಹಾಗೂ ಒಬ್ಬ ದಿವ್ಯಾನಂದ ಎನ್ನುವವರಿದ್ದಾರೆಂದರೆ ನಿಜ. ನಿಶಾನೆ R32 ರಲ್ಲಿ ತೋಡಿಸುತ್ತಿದ್ದ ಉಂಗುರ ಅರ್ಜಿದಾರರು ಸ್ನೇಹಿತರು ಕೊಟ್ಟಿದ್ದು ನನ್ನ ಸಹೋದರರು ತೋರಿಸಿಕೊಂಡು ಬರುತ್ತೇನೆಂದು ತೆಗೆದುಕೊಂಡು ಹೋದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. 2 ಉಂಗುರಗಳ ಪೈಕಿ 1 ಉಂಗುರಗಳನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ವಾಪಸ್ ಕೊಡಲೇ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆ ಉಂಗುರ ನನ್ನ ಬಳಿಯೇ ಇದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. R31
If you read the entire one, how will I understand? Read two
what
lines
what
and
she has
explain to the
she has
court.
when a specific question was put, my lords, regarding the contents of those photos, saying that the gold ring which was given by my brother and not by you, she has denied that. That's the reason, my lords.
So now whether the gold ring is given or not, basing on that the divorce will be granted.
No, my lords, because there are certain serious allegations regarding the ornaments which were produced by her, my lords. She says which is hers.
My lords, the petitioner is by way of restitution of conjugal rights. The grounds is taken is like I need a divorce, that I have done something wrong. So there is a contradiction. He cannot blow hot and cold together at the same
She
time.
has filed a divorce petition and she has claimed alimony, my lords. There is both the petitions are clubbed together, and the question of alimony is also involved in this, my lords.
The list of witness, my lords. Order 16 Rule 1 says, on or before such date as the court may appoint and not later than 15 days after the date on which the issues are settled. The party shall, my lords, just a minute, my lords.
Because
My lords, please.
You can't, 1 minute, you can't afford to read all that with the kind of applications you have filed and with the
I have not filed, my lords.
No.
It is they have come challenging their application. Their application has been dismissed, my lords.
What
Their
about the previous applications?
My lord, they have said no objection. Because
So-
of that, it is
so
allowed.
the
And
rule-
that documents is nowhere
What
connected.
I expect from the advocates is when the court is asking a question.
Yes.
Unless and until you understand and answer to it, there is no purpose of arguing.
Yes, my lord, please.
So
Apology. Yes.
you are reading a provision which runs contrary to what has happened previously.
Yes.
So you can't take shelter under that
My
provision.
lords, I have not brought list of witness. I have brought in additional
And
documents.
even this is also not permitted, what is done on 23/9/2025 and 22/9/2025.
My lords, I am not on that, my lord. My lords, I am saying you need permission to file list of witness.
Yes.
My lords,
So the only purpose is whether that gold ring is given or not. For that purpose, now you want to examine
not
another
only
witness.
those gold rings, every question put forward regarding her own photograph, she has
Every
denied, my
question.
lords.
What
That's
is
the
it?
reason why I want to summon the very same witness who is present in that photograph, my lords.
IA should contain the reasons why you are filing an application.
That there is a
Then
in my part.
what
There
you
may be-
want, you don't know.
For a better application, if I'm permitted, on the very same day I'll
Please come.
file. That is the reason, my lords.
Agreed with orders passed in. I number 11 and 12.
Restricting for I number 12.
Huh?
I have restricted my prayer for I number 12.
Dated 8/10. 2025, whereby the court had rejected the application that is filed by the petitioner under section 151 CPC, seeking to reopen the case. Whereby the petitioner has sought to furnish the witness list. The husband has filed MC number 420 of 2022 seeking restitution of conjugal rights, and the wife had filed MC number 719 of 2023 seeking divorce. Both the matters were clubbed together and the common evidence was let in. After the evidence of the husband on 22/9/2025, the wife filed an IA under 151 CPC seeking to reopen the case, and also filed IA number 9 under Order 18 Rule 17 seeking to recall RW1 for further evidence, and IA number 10 under Order 8 Rule 1 CPC to produce the documents along with the list. Initially, the petitioner husband has sought for time. Later, on 23/9/2025, it is submitted that the petitioner has no objection to IA number 8 to 10. Hence, IA number 8 to 10 are allowed. Then the RW1 the wife is further examined and cross-examined fully. And Exhibit R 12 to 35 are marked. Respondent side evidence is closed, and the case is posted for final argument on 25/9/2025. When the matter is posted for final argument on 25/9/2025, now the petitioner has filed I number 11 and section 151 CPC seeking to reopen the case, and IA number 12 under Order 16 Rule 1 CPC by furnishing witnesses list to lead further evidence of petitioner, which came to be dismissed by order impugned. While dismissing the same, the court has observed that the evidence from the husband side has been concluded long back on 1/7/2025, on which date the husband himself got closed his side evidence. Furthermore, till the conclusion of the evidence of RW1, that is the wife, no attempt was made by the husband to examine the witnesses, when the stage was already set down for evidence of witnesses, if any, from his side, which he has not availed. The court has come to the conclusion that under such circumstances, the parties cannot be permitted to adduce the evidence of the witnesses in order to overcome the lacuna crept in their case during the course of the trial. The admission or denial by the witness during their cross-examination will not automatically entitle the parties to examine some third persons as witnesses, which is not permissible under law. If such practice were to be allowed, then there will not be any end to the trial. The court had considered the judgment of the Apex Court in Mrs. Bagai Constructions versus Ms. Gupta Building Material Store, reported in AR 2013 AC 11849. The Land Council appearing for the petitioner submits that when the IA that's filed by the wife is allowed on 23/9/2025, in that Exhibit R12 to R35, certain documents are there, certain photographs are there, which are denied by her. It is suggested that a gold ring is presented, and the same is denied. As such, the petitioner husband wants to call for the said witness for examination to elicit the fact which is denied by the wife. It is submitted that unless until an opportunity is given, it would prejudice the case of the petitioner husband. Next para, Land Council appearing for the respondent wife submits that when the matter is posted for arguments and when RW1 was cross-examined at length, that is RW1 wife, at this stage, question of reopening the case or examining a third party would not arise. And the court had rightly dismissed the application. Next, for having at the counsels on the side, there is a material on record. The MC that is filed with the husband for restitution is of the year 2022. 2022. And the wife's divorce petition is of the year 23. The court had given enough opportunities to both the parties, and even earlier, when on the request of the wife, when the case is reopened, as the husband had no objection, the court had allowed the said application as on 23/9/2025 and posted the matter for final arguments on 25/9/2025. The IA that is filed by the petitioner on what exactly he wants and on what purpose he filed this application, the IA is absolutely silent. When an application is filed, it's the duty of the applicant to state the reasons for filing such an application. As rightly observed with the learned judge, if after examining the witness, after the evidence is concluded, whatever the lacuna in the evidence, for that purpose, every time an application comes to be filed to reopen the case and to adduce further evidence, there is no end to the litigation. Court had rightly considered and dismissed. This court finds no reasons to interfere. Accordingly, dismissed.
Hearing on into third application, cell number 5, Rajesh Singh for petitioner. T. Sheshgiri Rao.
My lord, I had filed this petition challenging the order passed by the learned trial judge, where I had sought for modification.
When it was directed to be listed for dismissal, why it is listed? Why you were not present?
My lord, yesterday.
How many times you have to be you are supposed to be invited to the court?
My lord, day before yesterday when the matter was listed, I was present, my lord, and I had argued the matter also. Yesterday, my lord, I could not appear because I.
Morning you were not there, afternoon you were not there.
My lord, morning when the matter had been called out, I was not there.
Again, it was posted to afternoon. Yes.
Sorry, my lord, this petition has been filed, my lord, challenging an order.
Impugned order.
Lord, impugned order is at page 23 onwards, my lord. The operative portion of the impugned order, my lord, it is 29.
Yes.
The order that was passed, my lord, was on an application that I had filed seeking modification of an earlier order that was passed, where certain visitation rights had been granted to me to see my daughter. My lord, I had sought for modification of the order as I wanted visitation rights.
What was the earlier order?
My lord, the earlier order that was passed was on IA number 1, my lord. This is in.
Where is that order?
Yes, my lord. Order on IA number 1 is page number 42, my lord.
Yes. Yes.
The operative portion is in 41 and 42, my lord.
Please read.
Yes, my lord.
You're for the father.
I am for the father. Yes, my lord. My application that was filed, IA number 1, was under section 12, my lord, seeking interim custody. However, I'll read it out, my lord. IA number 1 filed under section 12 of the Guardian and Wards Act 1890, seeking interim absolute custody of the minor child is rejected. However, the petitioner is entitled visitation right in the following manner. The petitioner is entitled to see the child during weekends, particularly during her birth dates and festival days, if he is willing, by visiting the house of the respondent. The petitioner shall give prior intimation to the respondent about his visit to see the child, and his visit shall not be before 10 a.m. and after 8 p.m. on a particular day. He has no right to take away the child outside the house of respondent. The respondent mother should not prevent the petitioner father from coming to her home to see the child during weekends and also during birthday dates and festival dates. The respondent should make necessary arrangements for the petitioner in her father's house to meet his child on such occasions.
What is the modification you want now?
My lord, the modification that I wanted was Kindly see my IA number 6, my lord.
Page number?
IA number 6 is on page number 10. Page number 96, my lord. I'm sorry.
Yes.
Page number 96. That for the reasons sworn to in the accompanying affidavit, this honorable court may be pleased to modify the earlier order dated 17/11/2020, passed by the honorable court on I number 1, and grant visitation rights of the minor child, namely Diya Ritansi Amit Reddy, from Friday to Saturday from 10 a.m. to 7 p.m. every week, and also grant 30 minutes of video call with the child every day in terms of the guidelines laid down with this honorable court and so and so. This is
How
what.
is it possible to give a visitation from Friday to Sunday from 10 a.m. to 7 p.m.? What about the mother?
My lord.
Is she working?
No, my lord. She's not working, my lord. Mother is not working, my lord. She's at home.
What is the age of the child?
The child must be around 6 years normally. Must be around 5 or 6
What did the
years.
court do? Let's see.
My lord, so initially, my lord, there was an interim order that was passed, wherein I was granted visitation rights. Page number 109, my lord.
Yes.
Page number 109. Further, as per the order passed by my learned predecessor, now the respondent mother is directed to produce the child before Dodda Gobi Park opposite to DS Max apartment, Bangalore, as per the timings mentioned by my learned predecessor on every Saturday and Sunday for first 3 weeks of every month in the said park. Further, on the last Saturday and Sunday of every month, respondent is hereby permitted to produce a child before.
Please come to this order.
My lord?
Please come to this order. Reasoning part of this.
The reasoning part of the order. Of the impugned order, my lord. Page 24 onwards, that is the order, my lord, the impugned order. The applicant petitioner has filed this petition under section 151 of CPC requesting the court to modify the earlier orders passed on 17/11/2020 till disposal
Why
of
he is not appearing before the court, Mr. Seshagiri?
I don't know. I'm not aware of that. My lord, probably, I'm not sure, my lord. I can only say that since the parties are already talking for settling the matter, and as of now, the interim arrangement that had been ordered, that the petitioner be allowed to see the child every weekend, that the respondent bring the child, that is continuing, my lord, without any
That is
glitch.
the now which you have read it 101.
Yes, my lord. So that is in continuance as of now, and that is going on without any
Where
glitch,
is
my
that?
lord.
You said it is at page number 100?
Page number 109, my lord.
Hmm.
So this is being done. In fact, the parties are also talking to file. They're also in talks to file a mutual petition on mutually agreed terms, and we've also shared a draft of it. And perhaps for that reason, they may not be appearing, my lord. However, my
What
lord,
we'll do is let this arrangement go on.
let this arrangement go on, my lord.
And we'll, in the light of that, this order has to go.
Yes, my lord. My lord, the only difference, my lord, is that in this particular interim arrangement that was made, there was a particular place that was mentioned, Dodda Gobi Park, and so and so. As of now, my lord, the daughter comes home to the petitioner's home, to the father's home. The respondent brings the daughter home to the home of the petitioner.
She'll also come.
She also comes, and she obviously she brings the daughter, and the child stays with the father during weekends and also on birthdays and other festival occasions, my lord. So except for the place that is mentioned here, my lord, otherwise the arrangement is as per the interim order itself.
So on first and third week of every month, Saturday and Sunday, or first and third week of every month, what is the time?
My lord, this was the first 3 weeks of every month, the first, second, and third week. This was for meeting the child in the park on the first 3 weekends. And subsequent, the last Saturday, last Sunday, it was to be at a particular place, the hospital, my lord. This is what had been ordered in this particular, in the interim order. But as
why this hospital?
My lord, because this is the hospital where the child was born, and the respondent was also at that point of time comfortable bringing the child to the hospital as a neutral venue. So as of that point of time,
So on all the weeks, the first 3 weeks of the month and the last also at your home, the
yes,
visitation is going on.
she's bringing it to the home. Yes, my lord. She's been bringing it to the home, and they have been meeting every weekend. The child meets the father and spends quality time with the father as well.
Please come. Where is that first order?
The very first order, my lord. This is in
IA number 1 order.
IA number 1, page 30, my lord. The operative portion is 41 and 42, my lord.
No, not about this.
Yes, ma'am.
The first order, IA number 5, no, whatever is the IA.
The impugned order, my
Initial
lord.
order, initial order.
Yes, my lord. Initial order is
41.
yes, my lord.
The petitioner for the
41, yes.
is agreed with the rejection of IA number 4. That's filed seeking modification of the order. That is
my lord, IA number
in
6, my lord. I'm
orders
sorry.
passed.
IA number 6, my lord.
IA number 4 filed under section 153. That is
IA number 4 was for review of the order passed in on IA number 1. That got dismissed, my lord. However, room was left open for me to seek modification of the order passed on IA number 1.
that is where
On my lord.
that is where
Yeah,
that
yes,
order.
my lord. Now, 75, my lord. 75 is the order passed on the review application, and the operative portion is page 95, my lord. Page 94, in fact, paragraph 18. Paragraph 18, the learner trials, it says, according to petitioner terms of visitation, if the petitioner feels that the
So
terms
coming back to 95, 95 is IA number 4.
yes, my lord, this is IA number 4, where they asked, where they gave room for the petitioner to seek modification of the order that was passed in IA number 1. Based on that, I filed IA number 6, seeking
Where is that?
modification. IA number 6, my lord, is page 96. On this, the impugned order was passed, my lord. And this is where I sought for the modification.
Initially, the petitioner has filed IA number 1, seeking interim absolute custody of the minor child. That came to be dismissed by order dated
4 to 2000, no.
17th November
17 November
2020,
20.
whereby the court had rejected the request for the absolute custody and granted visitation to the father on the child's birthday at the mother's place, and also made it clear that he can see the child. He shall not see the child. He shall not visit the mother's place before 10 a.m. and after 8 p.m. And the child shall not be taken out of the mother's house. And during weekends and also during birthdays, also the father can visit the child. And the mother shall make necessary arrangements for the father to meet his child on such occasions. And the mother shall also not prevent the father from giving any gift to the child during his visit. Then the father has filed I number 4, seeking a review of the said order. That came to be rejected by order dated
5/4/2021, my lord.
5/4/2024,
21.
21. Thereafter, the petitioner has filed. Where is that IA? 6?
My lord, IA 6 at page 96, my lord.
Thereafter, petition has filed I number 6 to modify the order dated 17/11/2020 and grant visitation of the minor child from Friday to Sunday from 10 a.m. to 7 p.m. every week, and also grant 30 minutes of video call with the child every day in terms of the guidelines laid down by the High Court of Karnataka in the judgment dated 9th August 2021. During the pendency of the said application, the court has passed an order on 22/4.
6/6/2022, my lord. The interim order, page 109. This, my lordship, if your lordship is talking about the interim arrangement, my lord. Yeah, page 109, my lord, 6/6/2022.
No, the order that is dismissed is in the year 2024.
My lord?
No, the order which you are speaking about is 2024.
Yes, my lord. That is 20. I stand corrected, my lord.
Then where is the arrangement, or that interim arrangement after this?
My lord, the interim arrangement was during the pendency of the IA number 6, and that continued even after dismissal of this IA, my lord.
IA number 6 is filed in which year?
My lord, IA number was filed on 2022, 4/3/2022. And on 6/6/2022, this interim order was passed, which is at page 109, my lord.
Come to page 95. What is the date of order?
My lord, this is the order which was passed on IA number 4, dismissing my application to review.
Here is that.
My lord, this was passed in 2021, 5th of April 2021, my lord.
That's 5/4/2020.
5/4/2021.
Not 24. It is 5/4.
21.
2021.
Yes, ma'am.
Thereafter, IA number 5 is 5.
6, my lord.
6
IA
is
number
filed.
6.
Seeking the same as it is. In that, an interim arrangement is made. The mother is directed to produce a child before Dr. Gubi Park, opposite to DS Max apartment, Bangalore, as per the timings mentioned by the predecessor, on every Saturday and Sunday for first 3 weeks of every month in the said park. Further, on the last Saturday and Sunday of every month, the mother is permitted to produce a child before OVM Hospital, HRBR Layout, Bangalore, till the hearing on IA number 6. Thereafter, where is the present order?
Page 23, my lord.
Thereafter, the final order is passed. And IA number 6 came to be dismissed. This matter came up before this court on a couple of occasions, and there was no representation on behalf of the respondent. When counsel appearing for the petitioner submits that the matter, the parties are settling the matter. Further, as per the interim order that was in the year 2022, pending disposal of I number 6, that is dated 22/4/2022. The parties are continuing with the said arrangement, and in fact, on every date, the wife is coming. Wife is getting the child to the mother's place, to the father's place, and the father is exercising the visitation. Then counsel submits that as there is no objection to the mother, and as the arrangement is going on, from the year 2022. And in the light of the fact that the parties are settling the dispute, the writ petition may be disposed of by making this arrangement of 6/6/2022 absolute by setting aside the order impugned and accept the place of exercising the visitation. Next one. Though the matter, in spite of repeated opportunities given to the respondent mother, there was no representation on her behalf. Hence, this court is inclined to consider this application on the considering the submissions made by the then counsel for the petitioner and on the material on record. Next part. Having heard the counsel for the petitioner present material on record. The petitioner father is exercising the visitation from the year from the date of from the year 2021. It is a submission that the interim arrangement dated 6/6/2022 is going on comfortably and peacefully. The child is comfortable, but the place is at the father's place, considering the fact that as per the submission of the land counsel for the petitioner, that the child is comfortable with the father, and also mother is comfortable getting the child to the house of the father. This court deems it appropriate to pass the following order. The order impugned dated 4/2/2023. Is it 3?
Yes, my lord. 4/2/2023. Yes, ma'am.
4/2/2023 passed in I number 6 in JNWC number 21 of 2019 is set aside, and the father is permitted to exercise the visitation as per the order dated 6/6/2022 passed by the family court. However, the place of visitation shall be at the father's place. Accordingly, the writ petition is disposed of.
Cell number
Yes.
6.
Grateful, ma'am.
Syed Salil Pasha, for petitioner. A. Gunasekaran.
Yes. Where is the order?
Order, my lord.
When the trial court awarded 30,000 rupees to the two children of the petitioner. Each
Page
getting
number
15,000.
29, my lord.
The husband is directed to pay monthly interim maintenance of 30,000 to both the children.
Both the
Yes,
children
10,000
while rejecting the claim of the wife that
One
she is
minute.
working and having.
For their educational expenses.
Yes. My lordship, please kindly see
For
the
one-time litigation expenses of 10,000. What is the salary of the husband?
1,82,000.
Salary of the husband.
1,20,000 presently take home, my lord.
Then what
Lordship,
is the
please kindly see
difficulty?
the page number 32 of the counter affidavit filed by my learned friend. Separate booklet is there, my lord. Counter application filed by the respondent, page number 32, my lord.
Counter application means
That's, objection is filed by the respondent.
objections to the, yes.
Yes, sir. Both the children became major, my lord, as per the application filed by my learned friend in page number 32.
It's
My
filed
lordship,
under which provision?
my lord,
It is filed in MC
24,
proceedings.
my lord.
MC petition. Yes, my lord. Page number 32. She only admitted, my lord, she
No,
only
They are, the children are,
major.
Major, they are studying now.
Srinidhi, who is working now, as per my knowledge,
daughter or son?
son, no, my lord, daughter. Srinidhi is a daughter.
Daughter
She born on
Complete.
23/12/2002.
Huh?
2002, 23/12/2002, my lord.
She became major.
Major, 24 year now. And she has selected, campus selection agide. She is now serving in the multinational company.
Hmm.
And my wife also earning more than 1,40,000 rupees per month. And one more, my son, my lord, is complete major,
When this MC is filed in the year 2022,
22.
where this order is passed on 2024.
4.
When the girl has become major.
Before the order is passed, my lord.
Hmm.
Prior to the passing of this order, my lord,
Hmm.
she became major. And also now my son became major also. My wife is earning 1,40,000 rupees per month as per their admission only, my lord. Page number 19. 19.
When he became major.
My lord, prior to the passing of the order, my lord, she became a major, my lord, in the year 23.
Daughter.
Yes, my lord.
Son.
Son now, recently, my lord, 3 months completed, my lord. 21, 23, 7, 25, he became major. 23, 7, 25, my lord.
Hmm. Yes. Yes.
Yes, my contention, my lord, that my wife is earning, my daughter is also earning. And the order is passed by the trial court is not seen this particular aspect, my lord. In spite of that, my lord, that the court is passed the order. I have paid entire arrears of, my lord, the direction of the trial court, my lord. I have completed the direction of the court. Now both are became major, and my wife is earning 1,40,000 rupees per month, and they are not entitled to any maintenance from me, my lord.
My lord, the fact is that both the children have attained majority. I don't deny the fact, but both are studying. The daughter completed her BE, and she has applied for her post-graduation in Germany. I have produced the document to show. In my counter, I have produced the documents where I have made application to German University for a seat for post-graduation. That is also accepted. Now she is likely to fly to Germany somewhere in the end of this year or beginning of the year, depending on the opening of the university there. She has attained majority, no doubt, but she's still studying. Now the son is doing his BCom. He is also not earning. Daughter is also not earning. Daughter is expected to go for post-graduation to the German university.
All that has to be decided in an MC that's filed for maintenance.
It will be decided by the family.
No. I mean, the maintenance pertaining to the daughter and son for their further studies who are major, and that shall be granted by the family court in an application under 24.
That was granted under section 24 only. Because
You please place some judgment to show to the court that
I'll
all
place
these,
the judgment.
all these
Please, my lord,
huge,
I'll place the judgment.
yes.
There's
In
a
fact, I
judgment
have
of-
passed an order.
There's a judgment of the Supreme Court where it says when the children are studying, the father has to maintain the children till they complete their studies and go for work.
So,
I'll
for
produce the
example,
judgment.
if the children are studying till their age of 30, 40.
That will
still
not
the-
be done. I will give an undertaking, my lord, that will not be
No, 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 not about your undertaking. I'm asking you
I need the assistance of the father only for 2 years.
No, is
Maximum I need-
how is he compelled to do it? After,
I'll produce
after
the
the age
judgment
of 21?
I'll produce the judgment of the Supreme Court, my lord.
Yes.
Please, my lord.
This
Next
is
week.
matter as part heard on 11th of November at the request of Lund Council respond.
Interim order, my kindly.
Interim order earlier granted is extended. Yes, next.
Cell number 7, N. Kumar, for petitioner. Nishant Devi.
What is this extension of stay?
My lord, it was discontinued for one hearing, my lord. I was not able before the court for one hearing, my lord.
So why
I was
should
not-
we do it now?
No, I was not keeping well, my lord. For that reason, my lord, I was not able to appear. Otherwise, I was very punctual before the court.
12/8/2025, no representation. 23/9/2025, no representation.
No,
Not on one occasion.
no, only one
That
occasion, my lord.
right from no, you were not, there is no representation on 12/8 also.
No, my lord. I think, my
There's
lord.
no representation on 12.
And again, when the matter came up before this court on 23/9, no representation.
No, only on 17/4, my lord, this order of interim maintenance, my lord.
No,
Order of
no.
interim stay, my
From
lord.
12/8, you don't have an interim order.
Plus, on 17/4, my lord, there was an interim order. 17/4,
12/8, it is not extended because there was no representation before the
Only,
court.
no, it is not extended on 12/8/2025, my lord.
Huh?
Only on 12/8/2025, it's not extended, my lord. My lord, the
Then
order of
23/9/2025 also, it is not extended. The matter is directed to be posted after that.
29/3, there was no interim order, my lord. Interim order was granted only on 17/4/2025.
What is interim order?
Interim order, but staying the proceeding before the trial court, my lord.
Huh?
Proceedings before the trial court, my lord.
I
My lord.
passed.
Yes.
I have passed the order.
No, my lord.
This court has passed.
No, this could not this court, my lord.
We will hear the matter, that stay of proceedings.
No, my lord.
Before the trial court, we will
Only
not.
5 minutes, my lord. I will argue on merits.
Yes,
my lord.
that's what I'm saying. You argue on merits, we will decide.
Yes, my lord.
Yes.
My lord, the respondent being a grandparents, my lord, they have filed a section 9 application seeking custody of their grandchildren, my lord, before Hassan family court, my lord. I question the jurisdiction, my lord, by filing an application contending
You are
that
for the father.
I am for the father.
Hmm.
My lord, what happened, my lord? Mother was died in Goa, my lord, while they were raped, my lord, due to bronchial asthma, my lord. Thereafter, the children were
Which year is that?
My lord,
Where is
2024.
that?
2024, my lord.
Hmm.
Thereafter, my lord, the children were with me in Mandya district, my lord, and they are admitted to school in Nagunhalli, Mandya, my lord. Though they are studying in Mandya, though they are with father, my lord, the grandparents have filed an application, a petition before the Hassan court, my lord. I challenge before the Hassan court, my lord.
No. After the death of the mother, the children are staying with the grandmother.
No, not grandmother, it's father.
Father stays where?
Stays in Mandya.
Hmm.
And also he admitted, both are admitted to school.
What is the age of the children?
7 years, 5 years, my lord.
They were in school by that time.
Yes, my lord.
In Mandya.
Not in their objection, my lord, they admitted, my lord. Kindly see their objections, my lord.
No, let's understand. Yes.
It has not been objected, my lord. Their contention is, my lord, that the previous year, 2023-24.
So as of now, the custody of the children continues with the father?
Father is. Yes, my lord.
Hmm.
With the father, it is not be disputed, my lord.
What did the court say?
My lord, kindly see, impugned order, my lord. Though there is a finding saying that at
Page number?
page number is not forthcoming, my lord.
Internal page number 5,
Impugned
my
order.
lord.
Page number?
Page number 5, my lord. Impugned order, page number 5. Merit, my lord. Reasons.
Impugned order is page number 37.
Yes, my lord. 37. Internal page.
Yes.
May I read reasons, my lord?
Read the reasoning part.
There is no dispute regarding the relationship between the parties. Late Anupama M.R. born in the year 1995 to the petitioner's herein was a BE graduate and was married to the respondent herein on 27/4/2004. She gave birth to 2 children, namely Charvi Gopal female so-and-so and Keshav Gopal male so-and-so. As per the pleadings in the petition, the respondent was subjecting the deceased Anupama to cruelty and torture, and hence late Anupama
What submission you made is contrary.
No, my lord.
They say that they are at a Hassan.
No, earlier, my lord. Earlier, my lord, till 2023-24, they were in Hassan, my lord.
Along with the grandparents.
Please, ma'am.
No, my lord. With the mother and father is also staying with them, my lord.
No, you said that.
My lord, after the death of mother, my lord.
So the usual residence of the children is at Hassan,
No,
right
my
from
lord.
the beginning.
No, my lord. That's what I'm submitting, my lord. My lord, can you see the judgment of this court bench, my lord, where this
Judgment is not required. Facts are required. Please read.
As per the pleadings in the petition, the respondent was subjecting the accused Anupama cruelty and torture, and hence the late Anupama had left her children in the custody of the petitioners at Hassan. It is further pleaded that petitioners were looking after their grandchildren and had admitted to them in babysitting at grade school Hassan. In this regard, the petitioners have produced copy of the fee receipt. Further, it is pleaded that the respondent, on the pretext of spending vacation, took place Anupama and her children to Goa on 16/3/2024, and that on 17/3/2024, the petitioner were shocked to hear the news of death of their daughter. The petitioners have given a complaint to the Goa police against the respondent and others.
Any documents are placed before the court with regard to the school and other things?
Please, my lords.
Well, I only
my
put
statement of objections,
petition
my
copy,
lords.
my lord.
My lords, may kindly take my statement of objection, my lords.
Well, kindly see my petition copy, my lord. Wherein I put all the document, my lord. Kindly see at page number 16, my lord, annexure B and C.
Act, guardianship and what? Yes.
Annexure B and C, page number 16, my lord. The Charvi Gopal, she admitted to Nagunhalli Gate, Srirangpatna, for the year, my lord, admission number 821/24/25.
Hassan.
No, Mandya.
No, 2022-23, they were studying in Hassan.
Earlier, my lord. My lord, after the death, they are with the father, my lord. They are living with father.
That will not make it their ordinary place of residence.
No, my lord. Here the question is, my lord, the grandfather is a habitual offender, my lord. I put the document along with this, my lord. Kindly see, my lord.
Whatever it is, let it be decided by the court.
No, my lord, kindly see, my lord. But kindly allow me to.
You also admit that till the mother died, they were in Hassan. And after that, you brought them to Mandya. And you joined them.
No, my
and
lord, kindly see judgment, my lord.
Take that. There are so many judgments. If you want, I can give you.
Can you see para number 11, my lord?
Yes. Yes, this judgment has been. There are counter judgments in Supreme Court.
My lord, he is a natural guardian, my lord. The thing is, my lord, but kindly see the memo I
We are
produced.
now on the point of the jurisdiction of the court.
Yes, my lord.
Now,
My lord,
prima facie, we will only look at the material. And as per that, the ordinary place of residence of the minor
Can you see the
is
judgment?
at Hassan.
My
No, nobody is denying that, whether the father is a natural guardian or not. Now you have sought, now when the application is filed and the material on record discloses that the children were residing in Hassan till the application is filed by you, filed by them.
No, at the
then
time of
we
filing
can-
application, they were studying at Chenakpatna, my lord.
When was, please give the dates. When the mother died.
Mother did, my lord, on
Where are the other
17/3/2024,
judgments of
my lord.
that guardianship J&W matters? There were judgments here. Take note from this. Yes.
17/3/2024, my lord. Mother died.
17/3/2024.
10/6/2024. The children have been admitted to the school at Srirangpatna, Mandya district. my
So
lord.
according to you, till 17/3/2024, and as on the date when the mother died, they were still in Hassan.
Yes, my lord.
So,
But at the time of filing
so
petition, no.
only 20 after for the academic year 2024, you have joined them in
Yes, my lord.
that what is that Mandya.
Mandya.
Hmm.
Mainly similar. The respondents have filed a petition on 9/7/2024, my lord. By that
Yes.
time, they were studying in the Srirangpatna along with.
As per it is not the ordinary. It can't be termed as an ordinary course of residence of
Can you see
the.
the judgment, my lord? Wherein
I will read the judgment. Please tell.
Can you, Sir number 16 or 11 onwards, my lord.
Yes. Yes.
In the light of the judgment of the Supreme Court as referred to above, if the meaning of expression ordinarily resides can be expanded, it can be said that it does not connote past residence. Ordinarily, an adverb qualifying the verb reside takes its natural and common meaning that one should be resident of a particular place with an intention to live there for a certain number of years, though not permanently. In connection with one's occupation or employment, in the case of a school-going child, its ordinary place of residence is that place where it goes to school and leaves its parents, but this meaning cannot be fastened if the child is studying in a boarding school. Its ordinary place of residence in such a situation is the place where its parents reside. Residence connote living at one's house, whether owned or rented. If, if one lives at a place, it obviously implies a meaning that there must be an intention to live at that particular place, treating that the place as place of residence, and it may also be in a connection with one's business, employment, etc. Given this meaning, here the ordinary place of residence of the son of the petitioner and respondent is Belgavi only. In that case also, my lord, the child was residing in Belgavi.
Yes.
It is true that in Ruchi Maju's case, as has been argued by the learned counsel for the respondent, an inquiry has to be held. But the inquiry contemplated here is by the court where the petition for the custody of child is made. Without filing this transfer petition, if the jurisdiction of the family court at Bengaluru is questioned, it can be said that said court should have been held an inquiry to arrive at a conclusion that whether it has jurisdiction or not. Since this issue has arisen in the transfer petition, this court can take a decision based on the materials available record. It is submitted.
In a transfer petition that is passed, it's a court has a restriction. When you are instituting a petition, the jurisdiction has to be properly stated. For any reason, if somebody files a transfer petition, the parameters to consider the transfer of a case is altogether different.
No, my
Not
lord.
necessary that, no.
Here the court.
Not necessary that. There might be some discussion in that. But while considering a transfer petition, the High Court can consider, and if the court feels that in the interest that can be transferred, can be transferred.
No, well, here the issue is, my lord, earlier paragraph, my lord, kindly see, my lord, they discuss some judgment, para number 5 onwards, my lord. Kindly see, may I read, my lord. Para number 6, my lord. The petitioner's counsel argued that the court having jurisdiction to decide the custody of child is the court at Belgavi. It is the place when the child is presently residing with his father and grandparents. The petitioner
But
has
the Supreme Court judgments are contrary to that. You come to a place And because you're residing here now, you cannot call it as an ordinary residence of the minor. He was ordinarily residing in Hassan.
Apart from that, my kindly see, I filed a memo, my lord, where that grandparent, the grandfather, my lord, Ramegoda, he is a habitual offender. He was on bail, my lord, by assaulting somebody. He was in judicial custody for
That
7
the court will decide while
That's
granting
what, my lord.
custody.
My lord, if that being a case, my lord, I will examine the judgment, my lord. I will come with next, kindly have next week. I want to see the other judgments also.
What judgment? It's a settled law. There won't be any judgments contrary to that.
Then I'm relying on this judgment, my lord.
That is not a judgment on a child custody. It is a transfer petition you're reading.
My lord, because my lord, the issue that similar issue has been
I
discussed.
already told you, Mr. Counsel, on a transfer petition, their parameters are different.
Okay, next week,
And
my lord.
when it
Kindly
comes to the
I want short date, my
jurisdiction,
lord. I want short date. I will come with some other.
I will
judgment.
not grant any
lord,
stay.
really,
Two
short date, my
occasions,
lord.
the matter
My lord.
was argued.
Let's this matter on.
My lords, the matter was heard on the 2-3 occasions, my lords.
That's what I know. This matter as part heard on 12th of November. No further time will be granted.
Please.
Bill number 8. JNCR for
Appearing for the petitioner, Your Lordship, as per the respondent.
I appear for the respondent, my lord.
Your Lordship, the respondent has referred mediation on the last occasion, which was held on 9/10/2025, Your Lordship, and the matter has been settled. And for further exchange of jewels and everything, the date has been again fixed on 6th November 2020.
This is smart. It is submitted that the parties have entered into a compromise, and for almost matter is going to be settled. This is matter on 18th of November.
Grateful, Your Lordship.
Bill number 9, preliminary hearing.
Respondent,
Venkatami Reddy.
As ordered by the Lordship as ordered, I have produced the document to show that I have spent the amount from date of IA to passing the order on this.
My lords, I need to give some clarification regarding the statements, I mean, the receipts which have been produced. Not all are from the time from the date of the application to the date of the order. Like document number 1 is dated 24/4/22, Your Honor. This is prior to the date of the application.
What is the order?
The order
impugned.
Application was allowed and maintenance was awarded at the tune of rupees
So 50,000 per month.
50,000 per month. I'm
What
not
is your
disputing.
salary?
I'm not disputing the quantum of this maintenance.
What are you disputing?
The second portion of the operating. The petitioner is entitled for interim maintenance of rupees 30,000 per month from the date of this application till today, that is 16/6/2020. So that interim period, Millard, I have paid all the expenses of my child. It is undisputed fact that child is under joint custody.
the law with the ladyship kindly-
Subsequent to filing of the MC petition, after 1.5 years, she has filed the application.
As far as this is concerned, let both of you file your memo before the trial court. Trial court decide all this.
Please. And
Till
the
then,
ladyship
let
kindly.
them not to precipitate to recover the said amount. I have no objection.
Your
for that.
ladyship's kind leave. The child is a special child suffering from ASD, autistic special spectrum syndrome.
He is continuing to pay 50,000.
Please, but
Whatever are the arrears are concerned,
please.
I'll direct the court to decide it within 15 days.
Please.
Let it decide. Because
Already,
all these things.
already evidence
because
has
it's
commenced in the.
expensive.
As far as this issue, it has to be considered separately. As far as this is concerned,
please.
Both of you file your memo within 1 week from the date of receipt of the copy of the
Please.
order. Within 15 days from there on, the court shall decide it. As far as the expenses that are borne by him during the pendency of the application. And
Kindly
50,000,
many-
I am not interfering with that.
All are paid by cash. They say that receipt
So
from
if he
the
is not
child's
able to
name is
prove,
mentioned.
no,
Yes.
no, if
These
he
are the
is not able,
receipts.
please wait. If he is not able to prove that he has paid any amount,
Please.
that 30,000 will continue.
Please. Please.
Please come. The presented petition is filed. Agreed with the order passed in I number 3 in MC number 4041 of 2021, dated 16 June 2023, whereby the court had granted maintenance of an amount of rupees 50,000 per month to the respondent is the child or the mother?
Mother.
To the mother from the date of the order. And she is entitled from the date of the impugned order. And it is also held that the mother is entitled for interim maintenance of rupees 30,000 per month from the date of the application till 16/6/2023. When counsel appearing for the petitioner submits that he has no objection to pay an amount of rupees 50,000 towards the maintenance. However, it is submitted that in the second limb of the order, it is mentioned that the interim maintenance of rupees 30,000 is from the date of the application. Of 30,000 is no, he is directed to pay maintenance from the application till 16/6/2023 at the rate of 30,000. Land council submits that he has paid lot of amounts in between, the same in between, and that has to be deducted. And he cannot be directed to pay the amount where substantial amounts are already transferred by him. And as per the order passed by this court, he has also filed before this court. What you have filed, documents or
Documents to show receipts and all.
the receipts to show that he had paid certain amounts. Learned counsel appearing for the respondent submits that the respondent is not accepting the same, and he is showing that some of them are paid by way of
the
cash
respondent, please.
without there being any evidence, and hence they cannot be
And
considered.
some are predated, Your Ladyship.
And some are predated and they cannot be considered. Next, having heard so and so, having heard the counsel on the side, there is some material on record. As far as 50,000 maintenance, that is from the date of order, it is not disputed, and this court need not go into the said issue. The second issue is with regard to the maintenance that is directed to be paid at rupees 30,000 from the date of application till 16/6/2023. There is a dispute between the parties. According to the petitioner, he had paid certain amounts. According to the respondent, he has not paid, and there is no evidence in that regard. These questions, this court cannot consider, this court cannot decide before this court. Hence, this court deems it appropriate to pass the following order. The matter is remanded to the order as far as maintenance of 50,000 is affirmed. As far as the 30,000 maintenance is concerned, the parties, that order is also affirmed. However, with regard to the payments that are already made, both the parties shall, the petitioner within 1 week from the date of order has to file his statement before the court, his memo before the court, what are all the amounts that are paid. And within 1 week from there on, the respondent shall file her objections, if any, and after 15 days, within 15 days, 15 days from there on, the family court shall decide this aspect, and basing on that, the petitioner shall pay the amount. Yes, accordingly disposed of.
Much obliged.
Till number 10, Ajit N for petitioner.
Kindly pass over the matter, my lords.
What is this matter?
Yes, so my colleague will come. My senior will come, my lords. Kindly pass. My senior will come, my lords. Kindly pass over.
Let me just see. All these family matters, seniors' presence is not required. That too at the admission stage. It's a case of maintenance?
Yes, my lords.
How much is about it?
5,000, my lords.
5,000. What is the income of the petitioner?
30,000.
Huh?
30,000.
Why he won't pay 5,000 to the wife?
That's in 5,000 for wife, 3,000 for another application filed before the trial court.
So let's take it 8,000.
8,000, my lords.
8,000. Your salary is 30,000.
30,000, my lords. But I have so many debts for ill health of my mother and.
Tell your senior, even if your senior comes, I'm not going to interfere. Yes.
My lords, kindly pass.
Pass over.
11, Manchandra Amrit Suresh.
Husband petition challenging interim order where he is directed to give access of a software application to his wife. He has filed he's directed to give a software application. It's a MyGate application. He's directed to give access to his wife. He has filed divorce petition. In his divorce petition, wife has filed application under DV Act, Section 19, seeking residence order. It's a 2 BHK. I am the owner of the flat.
Let me look at the impugned order.
41, page number 41.
Provide MyGate app access to the respondent without any hindrance for her free access to the apartment, also for any other convenience pending disposal of the petition. To do needful to active MyGate app in the name of the respondent along with her mobile number. What is this? This apartment belongs to whom?
It belongs to me, husband.
Then what is
there is a software application which is exclusively meant for the owners.
That I understand. MyGate, this thing.
I'm approving all her entries. Her entry is not restricted. Now she wants access to that application. I have already received a complaint against her. I'm getting complaints against her from the society management. On one of the incidents, I was asked to apologize for her misconduct. Kindly see page number 44. Page number 44.
No, before going into that, where is the wife staying?
She's staying in my flat. Me and my parents, we were forced to leave our own flat because she forced us.
So she is staying in the apartment.
Yes.
And then if she is staying in the apartment, there is no access for MyGate.
There is an access.
Every
It
time
is
she'll
not.
call you.
It is not in her entire application. Nowhere she said that I'm not approving her access. Every access is in.
Why should you approve every time when she is residing there?
Lordship, because that is one of the feature of that application.
Not that. If in the family, if there are 4 people, or 4 will have the access. Not that for every family member, every time the other family member has to accept the access.
Lordship, I'm ready. Even at midnight, she's coming at 2 p.m.
It is not. Why should every time to enter into the house where she is residing, she has to ask the access from you?
Lordship, that application, that is the only application. I'm ready to give a letter to the society management not to restrict her access. That she will have a free access every time. But this application, I don't want to give her. Lordship, she can distort. There's voting polls permitted in that application. That members can broadcast messages. Because of her misconduct, she's already, every day I'm getting complaint from the society management. If she's posting something there, if she's distorting poll, I'll be responsible.
I think you're mixing 2 different issues. She being a part of so-and-so is a different aspect. And access to the MyGate app.
MyGate application itself, this is approving access is just one of the feature of that application. There are multiple features of that application.
She is residing in that apartment. You cannot restrict any of her activities in that apartment because you are the owner of for example, she is a tenant.
Yes.
You are the owner. If tenant does something, because tenant is doing something, will you stop the access to the tenant?
Lordship, because of her conduct, I'm getting.
The husband is taking it to.
Lordship, that is my flat. I want to reside in my flat.
Get it recovered from her. If it is if that's what you want.
Lordship, I'm not going to restrict her application is restricted just to entry exit. I'll ensure that her entry exit is, but giving access to this application, this is going to
happen. Nothing will happen. Please come.
Lordship, it has already happened. Kindly see page number 44. That
it happened. Now you cannot restrict any of it, whatever or the facilities, whatever are there in respect of that.
Lordship, no, Lordship, I'm staying in Moodbidri where my parents are staying, and she's staying in my flat. No prudent man will leave his own flat and live 375 kilometers. Husband is working in Bangalore. He has to come here, rent a hotel, and he's attending his meetings.
No,
because of her.
Those are not the issues. That is which has to be settled by the wife and the husband. If you want to you say that it's my apartment, I want to stay. You have your own means to, seek a legal remedy.
I've threats from her and her family members.
But in the process of it, because the wife is staying, like you have an access, you will stop the electricity, you stop that, I will stop this. This is one of it. No, this is the latest.
Lordship, I'm ready to give a letter permitting her access.
I number 3. in MC number 4304 of 2024, where the court has allowed the application that is filed by the wife.
Actually, I would like to withdraw.
Yes. Dismissed as withdrawn.
Cell number preliminary hearing, B group cell number 12, Anand Muttalli, for
Respondent
petitioner,
in this.
K.S. Bhimaya.
I'm appearing for the petition in this matter, Your Honor. I believe the Niman's report has been submitted. I'm not aware of the content. We have been taking the child for counseling at Niman's. In fact, as on last week also, there was a
1
counseling
minute, let me
session.
look at it. So you attended on 6/10, 9/10, 16/10, 23/10,
As on last week also, I've attended, yes.
30/10 is today.
Today is 30.
Today, and there is one more on 6/11.
Yes, Your Worship.
The team will carry out their respective evaluations and therapeutic interventions on these dates. We request that Ms. Anona C., her mother and father attend all scheduled sessions without fail. Their consistent participation is essential to ensure continuity of care and to enable the multidisciplinary team to complete the assessment and therapeutic process in accordance with the directives of the court. A report summarizing the evaluation and therapeutic progress will be submitted to the court by November 10, 2025. Please come. As per the order passed for this court, the report is placed before the court dated 29/2025 by Nimhans. It is stated that the sessions have been scheduled on 10/6/10/2025, 9/10/2025, 6/10/2025, 23/10/2025, 30/10/2025, and 6/11/2025. It is requested that the child, mother, and the father, if they appear for the assessment, the doctors will be able to place the report before this court. Then counsel appearing for both the petitioner and the respondent submits, both the mother and the father submits that as per the dates for as per the advice of the doctors, they have been undergoing they were appearing as outpatients before the doctors, and the doctors are assessing the assessment is going on. List this matter on 17th of November.
What?
Cell number 13 adjourned, cell number 14, Ushani Kumar, for petitioner, Vivek Holla.
I'm sorry, my lord, I could not file the way that the petitioner has to pay the arrears of arrears. I could not prevail over him.
We will clear this matter.
Yes, ma'am.
Please argue.
Yes, ma'am. In this matter, my lord, your lordship gets the impugned order at page number 90. Last para, if your lordship reads that.
The respondent is ordained and directed to pay interim maintenance of 15,000.
Per month to the petitioner from the date of the application.
What is the interim order of this court?
This court directed me to deposit 2 lakhs, my lord. I got it done. Then also there was an order directing us to deposit 30,000. That also, but he has not paid from December to January to April.
What is the income of the husband?
Yes, my lord.
Income of the husband.
Income of the husband, nowhere he has stated, my lord, because he has not even filed in this. It is relevant to note at that.
No, how can you say when you're appearing for the husband?
Yes, my lord, that's the main
You have to
problem.
tell the
my
court
lord.
that what is
He is getting now around 1 lakh, but he is not in a consistent job. That's the main problem.
First of all, he has not.
He was in Texas, my lord. After this, he came down.
He has not filed his statement of assets and liabilities.
Yes, my
Nor
lord.
he is clear before this court what is his income. So on that, whatever is the amount that is awarded by the family court will confirm. Please come. The agree with orders passed in I number 2. Agree with the orders passed in an application under section 125 1A of CRPC in criminal miscellaneous number 334 of 2019 dated 29/9/2023, whereby the court has granted 15,000 as maintenance. The husband is before this court. Land counsel appearing for the husband submits that the court, without considering any of the aspects, had granted maintenance of an amount of rupees 15,000, which is on the higher side. Land counsel appearing for the respondent submits that the petitioner has approached this court by filing a writ petition the year 2024, and from 2024 till now he has paid 1,30,000. He has paid.
He's paid 2 lakhs, my lord.
2,30,000.
2,30,000.
2,30,000. It is submitted that when the husband is getting substantial amounts, it is submitted that the husband has not filed his statement of assets and liabilities, and the liabilities, and in fact, he's earning more than 1 lakh, and the wife is entitled for the amount of maintenance that is awarded by the tribunal is not reasonable. Next, for having heard the counsels on either side, there is a material on record. The court has, while granting the order, the court has observed that the assets and liabilities furnished by the wife shows that she is a homemaker and unemployed. According to her, husband is a mechanical engineer and also a partner in the leading company, and she is not aware of the income of the husband. The respondent has failed to file his statement of assets and liabilities. The conduct of the husband is sufficient to draw adverse inference and granted 15,000 rupees. Having perused the order of the court, this court finds that there is no interference is called for with the order impugned. As for the judgment of the apex court in Rajesh versus Neha, when the parties are supposed to file their statement of assets and liabilities for the best reasons known to the husband, neither he has filed before the family court nor before this court. All this and the family court had rightly taken an adverse inference and granted an amount of rupees 15,000, and this court finds no reasons to interfere. However, deducting the amount of rupees 2,30,000 that is paid, the remaining arrears shall be paid within a period of 2 months from the date of receipt of the copy of this order.
Much
obliged.
Yes.
Going for the response.
Yes.
Lordship, settlement is going on in this matter. Settlement talks are running. I've been instructed to request for 4 weeks of.
I have taken time several occasions. I told them that to inform to the court, but I cannot plead time and again.
Finally, I'll give a date. By the time nothing happens, we'll decide this matter.
Okay.
This matter on December 9th. By the time, if no settlement is reported, the matter will be decided on the merits of it.
Subsisting interim order may be granted.
Interim order earlier granted is extended till then. Is 16?
They appear for the petition, my lord.
Yes.
My lords, impugned order by the annexure A regarding the maintenance, my lords. Wife's application for maintenance to herself and a minor child. Interim maintenance to the wife has been rejected and rupees 25,000 only granted to the minor child, my lords. 25,000 per month. Along with the litigation expenses of 35,000 only awarded to the minor child, my lords. If your lordship comes to that impugned order, my lords, the reasoning given by the trial court, my lords. Annexure A,
How the parties have filed their respective statement of assets and liabilities,
yes, my lord.
both the parties,
Both
before the
the parties
trial
has
court.
filed. And even modified affidavit of assets and also been filed by the parties before the family court recently, my lords. Even in that, one more account of the husband has
What is
been
the stage of the proceedings before the family court?
cross-examination of the respondent number 1, RW1.
We'll do whatever is the interim arrangement that is made. Let it continue with regard to the
As
maintenance.
of now, the interim arrangement what has been made by this honorable court is that, my lord, only 10,000 rupees to the minor child for the year from the year 2024 plus educational expenses, my lord. So this year 2025, when the fees has to be paid, he was claiming that it was only for that particular year and I won't be paid. Then after an assurance by the learned counsel, before senior counsel before this court, that amount has been paid for this year also. But
What
there
we'll
is
do is, whatever is the educational, whatever are the educational expenses and 10,000 pertaining to the child, interim arrangement that is made, without expressing anything on the merits of the matter. No, the entire evidence is before the family court.
But the previous years, whatever the educational expenses incurred by the mother for the.
That's what, let the court decide that whatever are they, whether you are entitled for it or not, whether he has a capacity to pay or not, basing on the evidence, let the family court decide.
My lord, so his own affidavit of assets and liabilities, it will reveal everything, my lords. He was into the business, he has created almost 8 to 9 commercial properties are in his name. All the properties has
That's what,
been.
now that is also at the pagan, that the pending proceedings.
And one more reason, the reasoning given by the trial
No,
court.
please
my lord.
understand, now any of the order that would be passed by the court, without considering all that volume and all that record, what you're saying, that's not for this court to consider. Let the family court consider this interim arrangement of paying the educational expenses, 10,000 per month, continue. And I will also record that I am not expressing anything on the merits of the matter with regard to the educational expenses for the previous years, the maintenance to the wife, maintenance to the children, everything basing on assets and liabilities, the court shall decide.
So that will not be stayed. She can always claim for the previous year's arrears. That will not be stayed.
It will not be?
My lord, as per your lordship has expressed now, previous arrears of that child's maintenance, educational expenses and all.
No, about that entitlement, let the court decide.
My lord, so then it will be difficult for her also. No maintenance has been awarded to her also. And the
Then
main
the court
reasoning.
decide it now. That will relate back to the date of order.
Okay. Also,
date of the application.
yes, my lords. Also, one more submission, my lords. The serious allegation against the respondent while rejecting the maintenance, any maintenance to her is that at the para 16 of the order, my lords. May kindly look into that, my lords.
Where is the order?
At annexure A. Ink page 27, my lords.
Yes. Read.
May I read? As for the income tax return verification forms produced in this case for the assessment year 16, 17, 17, 18, 18, 19, 19, 20, 2021, the gross total income of the respondent was 4,18,300, 4,50,000, 56,110, 67,000.
Are you reading paragraph number?
16, my lords. And 3,92,930 respectively. Respondent has produced her statement of account maintained in HDFC account Virajpet branch. On 12/6/2018 and 26/2019, a sum of 23 lakhs owed and 20 lakhs owed respectively were in the said account. And on 26/8/2009, she withdrew the aforesaid entire amount of 20 lakhs. So in the said account, in the column statement of summary, it is mentioned that total debits and creditors are about 78 lakhs, my lords. Hence, it is clear that after filing this application, the respondent has withdrawn the entire amount in the said account for the reason best known to her. As per the said statement of account, said account was opened on 4/4/2018. That is relevant, my lords, and closed on 26/8/2019.
What are these transactions?
This is while furnishing the affidavit of assets and liabilities. This one particular account at HDFC Virajpet branch, she has not produced, my lords. Only because of the reason, simply because of the reason that it is a joint account with her mother, who is a senior citizen, and her father had expired. Subsequent to which she has to open that account in her mother's account in a joint format for conducting that father's business. I have produced along with the memo, death certificate of the father, opening date and everything.
So
Here,
now
the finding.
she's taking care of the father's business. Her mother is staying with her.
Yes, my lords.
So she's
what-
not getting in, no, she's only simply,
My lords,
managing
no,
the business.
As per the said statement, account was opened. This is the impression what has been created by the trial court, my lords. As per the statement, said account was opened on 4/4/2018 and closed on 26/8/2019. Hence, it is clear that within a period of 1 year, 4 months, there was total transaction of 78 lakhs in the said. At this stage, I am of the opinion that this huge money transaction within a short period of
Wait,
1 year,
what
4
happened to that
months
money?
shows the financial condition of the respondent. My lords, if your lordship looks into my application date, it is 1/1/2018. I have filed the application under section 24 and 26, my lords, on 1/1/2018. If I have opened this account on 4/4/2018.
When did you open it?
4/4/2018. Subsequent to which this only, because of the death of my father only. If my impression was, the contention of the finding of the trial court is that since this account is huge withdrawal is there, or huge transactions are there, it is concealment of her financial transaction in there. It's not like that, my lords. It's opened on 4/4/2018, subsequent to the file. If it is opened before and closed subsequent filing of this application, that observation.
When did you file the application?
1/1/2018, my lords.
1/1/2018. When did you file the IA?
That's what, my lords. Application IA filed on 1/1/2018.
18. When was the statement of assets and liabilities were filed?
That is filed of late in the year 2022-21, my lords. But this details of this account
When
is.
you are
of-
filing into 2021, when you're
That
supposed
this-
to file last 3 years, this should have also been placed before the court.
It's not concerned with her. It's a joint account with.
Even
her
if it's a
mother
joint
and
account, you are also, you are one of the party that you are, that is
only
also in
for
your
her
name.
own purpose. Only she is not taking
No,
any money
Rajesh
from
Mr.
that.
Sneha says all that, your account, joint account, all accounts you have to file.
Whatever at the point of time I have revealed, except this account only because it
By
is a joint
20,
account.
as you said, in the year 2021, you have filed your statement of assets and liabilities. 3 years prior to that, or prior to 3 years from the date of your
2019,
application,
2021,
you were
everything
having
has
these
been
accounts.
produced.
That account was there subsisting. You should have placed it before the court. The same thing you would have told the court that, it is not, that money doesn't belong to me, it is my mother's money. But you can't suppress it.
Now, in my appeal, I have pleaded everything, my lords, in this case. So this 4
So all this you have not pleaded before the trial court, that's a trial court, the family court has given that.
So that even otherwise also, since this account is opened off late, my lords, and
That's
closed.
what I said, all these things. Now, I will set aside this order. I will, whatever is the interim arrangement, let that continue till you're looking at all your assets and liabilities. Let the trial court decide everything along with the main application.
For the mother, my lords?
For everything, for whether the entitlement of mother is there, the child, the educational expenses, whether in for the previous years and all, whether you're entitled or not. If entitled, what is the amount to be paid? What is the financial capacity of the father? What are the educational expenses that you are spending for the child? Whether the father will be able to pay the same or not, all will be decided.
Now, even the ideas of all the years not produced by
That's what I'm
both parties,
saying.
my
Now,
lords.
whatever that are supposed, if somebody, either you or he, withhold any document which are supposed to be filed, as per the judgment, that also I'll record. The statement of assets and liabilities shall include all the documents as per the judgment. Even if one document is withheld by any of the party, court shall draw an adverse inference. So the consequences will follow. Yes, please come.
I have only one submission. The assets and liability statement was bald as bald. I had to move this court on 3 occasions to compel them.
No, let's not go into that, Mr.
Very well,
Raju.
very well. I'll leave it.
I will
I've understood.
I will record this. I will
I've
record
understood.
that all the parties shall file their fresh statements of assets and liabilities within a specified time. And it is for the parties to decide whether to file or not file. If they don't file, they'll be inviting something at their.
Since from the year 2018, this
Whatever it
application
is,
has been
2000
pending and no amount has been paid. by
Because
him so far.
2018, but the assets and liabilities are filed in 21.
It was not there, my lords, of late since the matter
And
has
it
been
is from,
dragged
I
and
understand,
came into
but it
existence.
is.
And if your lordship looking into his financial status also, my lords, it's a huge, it's not that He was having turnover of, for the assessment year 2014,
The court
15,
has found that
4
she has-
crores,
she has-
54 lakhs,
Read with the order passed
94,337.
in I number 4 in MC number 1780 of 2017 dated 10th June 2024. Both the wife and husband are before this court.
Even let the main case also be disposed of within a time.
Which
frame
year
of-
is that?
Almost
17
8 years,
yes.
8 years
Eight.
pending, Miller.
Because 2017 matter, I'm already issuing directions to dispose of by December 15th. Wife's petition is WP number 17612 of 2024, and the husband's petition is WP 17245 of 2024. By order impugned, the court had granted interim monthly maintenance of an amount of rupees 25,000 to the daughter from 2/1/2018 till the disposal of the petition. And the father is directed to pay rupees 35,000 as one-time expenses, as the litigation expenses. When the matters came up before this court, considering the submission of the mother that no maintenance is paid, and the submission of the father that the father could never see had no opportunity to see the child till now. This court, balancing the interests of both the parties, has passed an order The first order is when? On 7/8?
Yes.
Is it?
Yes, ma'am.
7/8/2024.
On 7/8/2024, this court passed the following order, extract. Then on 38/2025, the following order is passed. This is where the 10,000 has come.
Yes, madam. 2024, madam.
38/2024, this court has passed an order. As per the orders, the father has to pay the educational expenses of the child, is paying the educational expenses of the child, and also paying 10,000 per month. Land counsel appearing for the mother submits that he has been paying the educational expenses from the date the orders were passed by this court. Prior to that, the mother has spent huge amounts. Father is financially sound, and he has to reimburse the mother the educational expenses which are already borne by her. It is submitted that the court, considering an account, a joint account that is there on the name of the joint account that is maintained by the petitioner with the mother after the death of the father, as when that account is closed in the year 2019, the court has come to a conclusion that there is suppression and misrepresentation on behalf of the wife. It is submitted that wife has nothing to do with the said amount. After she lost her father, she has been taking care of the same only in the interest of the mother. It is submitted that the wife is entitled for the maintenance, looking at the financial capacity of the husband. Next one. Land counsel appearing for the father submits that the mother is financially sound, and as per the judgment of the apex court, all the relevant documents are not filed by the wife, and the same is observed by the family court in the order impugned. It is submitted that the schools in which the mother has joined the child, that's beyond the financial capacity of the father to pay the amounts. It is submitted that the interim arrangement that is made by this court of paying 10,000 and the educational expenses of the child, the father is continuing to pay, and that may be made absolute. Shall record that?
That
That
can
may
be
be,
confirmed.
that may be made absolute, and the petitions may be disposed of. Next part. Having heard the counsels on either side, there is a material on record. The first issue is with regard to the entitlement of the wife. The second is about reimbursement of the educational expenses that are already borne by the father, and what is the amount of maintenance both the wife and the daughter are entitled to. Both the mother and the daughter are entitled to. The statement of assets and liabilities, it appears from the record that the entire documents are not before the court. As per the judgment of the apex court in Rashish versus Neha, what are the documents to be filed? The judgment is very clear. If any party fails to place all the documents, as per the judgment, an adverse inference needs to be drawn. In this case, considering the respective stance taken by both the parties with regard to the income of the parties, this court deems it appropriate to set aside the order impugned and remand the matter back for fresh consideration. It is submitted that the matter is at the stage of arguments
Cross-examination of RW1.
of the respondent.
Yes, ma'am.
Respondent, wife.
RW1, no, husband, my lord.
Respondent,
Sorry.
husband. The matter is coming.
PW1, sorry,
Huh?
my lords. PW1, cross-examination of PW1.
Who is the
Husband,
petitioner?
husband's petition.
The matter is coming up for the cross-examination of PW1. This is MC of 2017. This court has already passed direction and several directions to the family court, directing them to dispose of the matters till 2019 by December 15. As this is one of that matter, the parties within 15 days from today, from the date of order, shall file their respective statement of assets and liabilities before the one. This is one. Shall file their respective statements of assets and liabilities. If any of the relevant documents are withheld by any of the party, the court shall draw an adverse inference. The court afresh shall decide about the entitlement of the parties along with the main application. Number 3, the order, the interim arrangement with regard to 10,000 and the educational expenses of the children shall be continued pending disposal of the petition.
My lord, there are two other connected matters, all are clubbed, my lord. All of them can be disposed of.
Yes.
At one sentence maybe.
What are the other matters?
My lord, GNWC and criminal mess, I'll just give.
Which year are they?
That is in the
My lord, all,
beginning
pardon me?
stage only.
Which year?
They are 23 and 24, my lord, but they are clubbed. my
Cannot
lord.
be. MC only
Only
2017
17
matter.
things
my
only
lords.
they'll do. It
Yes.
can be done later. Yes. Disposed. Yes, next.
Serial number 17 and 18 and serial number 19.
My lord, serial number 19, I appear for the petitioner husband, ex-husband. Yes, my lord. May I seek a very short accommodation? I have viral fever today. It may be taken up on.
Object to any adjournment, my lord.
Stays there.
There is
My
no stay.
lord, the reason why I am asking is I'm
They
not well.
keep
Otherwise, I
making
would have been.
assumption that the High Court is seized of the matter. Executing court keeps.
By the executing court, what is the executing court's understanding? The learned counsel for the petitioner.
My lord, the executive court has passed an order to give educational expenses.
As a writ petition is filed before this court, the executing court is not going forward with the execution. This
No,
has
my
made
lord.
it clear that there are no interim orders in this writ petition. It's open for the executing court to
My
pass
lord.
orders. Is this matter
Tuesday, my
on,
lord, short date.
on 18th of November?
Much obliged.
Yes.
Your Lordship, here the petitioner had filed an application for interim custody of the child in the Honorable Lower Court. And the child, I will go to the relevant part of the impugned order, Your Lordship. Impugned
My
order,
lord-
the relevant portion, I will go. It is in page number 35, Your
Yes.
Lordship.
My lords, on the last date of hearing, this court had ordered
permitted the petitioner counsel to serve the papers on the counsel appearing before the trial court, my lords. However, I'm not the, we have been instructed by the respondent to appear in this matter, my lords. If a week's time is granted, we will file wakalat and the statement of objections, my lords.
If you come to the court, she will serve the papers. Where shall she serve now?
No, my lords, we will get the papers, my lords. We are just asking for an adjournment, my lords.
Does this matter?
Your lordship.
Let them
last-
come, there is no urgency. Let the list matter on
Your lordship,
12th of
only
November.
one small submission, your lordship.
Yes.
From the date of the order till today, the.
We will see on that day. Now, every matter is not urgent. Yes.
Much obliged.
My lords, appearing for the petitioner, my lords, petitioner advocate received a medical emergency call, my lords, hence he has left to Bhopal, my lords. Kindly have it on Tuesday or Wednesday, my lords.
This matter on, and it is made clear that this court has the roster.
Please, my
Deal with
lords.
this case. Tell your senior.
Yes.
My lords, in writ petition 20193, your lordship had directed the matter will be listed on 10/11.
Because all the three, there was a direction, that's how it has come. One, when do you want?
Tuesday or Wednesday, my
When
lords.
was your case?
10/11, my lords.
Why such a long date is appearing? Your
My lords,
Mr. Ravi Shankar.
My lords, after 1:30 is not, he'll be in VC, my lords. After that, he'll be traveling until 5th, my lords.
In fact, my lord, the
10/11, all the matters can be heard.
compilation of judgment as well as my lord synopsis, I filed my lord for all three matters together. It can be taken, my lord, together, my lord, all the three matters can be heard.
All the three matters on 10th.
Much obliged. Interim order may be.
No further adjournments. Look at it. Any interim order is there in any of the matters, extend it.
Much obliged.
My lord, kindly pass over the matter.
Why you have not complied with the office objections?
So already office objections were complied. However, if it is there, it will be complied.
However, it has to be there. And first of all, let's not entertain any of the petitions where there are office objections. Non-compliance of office objections, what are they? Siraj Ahmad to be made as party to this risk petition as per annexure R1. WP to be paginated correctly after 177. These are all the basic, the very required objections that has to be clarified. Without that, how will we grant an order?
Please,
You have already an interim order in this.
no interim order, no interim order.
The petition shall comply with the office objections.
Submission,
Finally-
When the office objections are complied, then
My
list the
lord.
matter.
One submission, my lord. The petitioners herein have filed 3 essays on the same relief before the DRT. And the
Have
petition,
they stated so in the writ petition?
Please, my lord, it is stated.
one submission,
Kindly,
petition number 1 and petition number 2, they have filed one writ petition, one essay. Petition number 3 have made petitioner number 1 and petition number 2 as a respondent. Petitioner number 4 has filed one writ petition, means an essay.
Pass over, we'll hear it.
please, please.
Yes, 3.
Last occasion, my lord, this honorable court directed me to serve a copy, my lord, copy, no, my lord, not furnished.
They have not served the copy.
I'm not received. I'm not received.
When counsel for the respondent submits that the copy is not served on him, counsel for the petition shall serve the copy. Does this matter on 6th of November?
I'm sorry, Your Worship. I'm
Yes.
sorry.
Waiting for petition.
What are these office objections? As many as 7. List this matter after office objections are complied with. Yes. As this, what about the respondent? Give that. Messrs. Fullerton India Home Finance Company. The petitioner is permitted to take out hand summons. List this matter after the office objections are complied with, oblique, after the no memo is filed before the court. Yes.
And the serial number 5, my lord, I'm appearing for the respondent bank, my lord. My lord, they have challenged the question notice. My lord, they are not complied with the office.
List this matter on Monday for dismissal.
Please.
It's the same matter, my lord, wherein, my lord, the central enactment and state, my lord, state KPAD and my lord, SURFACE. This honorable, my lord, I am not able to, my lord, may pass necessary order. It's the same matter, my lord, this matter heard at length. And my lord,
Somebody argued in that matter.
Please, my lord, please, my lord. My lord, I beg to appeal for respondent, my lords.
The Supreme Court judgment is not binding on us. And my lord, this honorable court said, Supreme Court said, my lord, state enactment will prevail. My lord,
What happened to that matter?
That is disposed of, my lords. Now I just made some examination. There's a review petition that is filed in the
No, oh, this is the same matter
Same
I heard
matter.
the other day.
Please, my lord.
So
What happened to that?
Review petition has been filed. It has been pending is what.
As of now,
With regard to the, which one prevailed?
Exactly, my lord. The judgment that is passed by the honorable.
This is Bela Trivedi.
That matter has been under review now. So that is review.
We'll adjourn this matter. Unnecessarily, like, we have to say now that.
My only submission is that refund of amount I'll press. A date may be fixed. I'll take instructions from the client and I'll at least, because I'll exit from the property, they may continue because bank will have any interest over the property.
My lord, may I make one humble submission, my lord? May I make one humble submission? My lords, the filing of a review may not be a ground, my lords, on which, my lords, my learned friends can seek an adjournment. For this reason, that, my lord, the review petition may come up, may not come up, or it may come up, my lords, after an indefinite period of time. So the Honorable Supreme Court, my lords,
Then we have to dismiss this writ petition.
My lord, sir, at least insofar as my petition is concerned.
No, considering his arguments, this writ petition, in the light of the judgment has to go now.
20 minutes.
Because the state enactment, what is it, KPID?
KPID and SURFACE
will prevail.
My lords, insofar as their petition, definitely, my lords, it may have to be dismissed. Insofar as my petition is concerned, I'm an auction purchaser. I'll seek for refund at least from the bank, my lords, because bank is also respondent in my petition. And I'll exit from the because now there is no title for them to give any title to me in that.
Then what is the position on that?
They have to refund the amount.
No, my lord.
When you are when you are not in a position to execute confirm the sale, you have to give it back to them.
That is the reason, my lord. Other day, my lord, I have pointed out before this honorable court that judgment is passed by the, my lord, FX court in the, my lord, that NSCL judgment, wherein, my lord, there are certain, my lord, it is not, my lord, similar to this set of facts. That is the argument which I canvass before this honorable court. However, my lord, I am not able to convince this honorable court, and I am not able to procure any more judgments on that account. My lord may pass necessary order in both the writ petition. My lord will accept.
No. 6.1, I'm asking you, what is your stand in 6.1?
My lord, my instruction, my lord, I may not able to concede to refund the money because I may require to take up before the Supreme Court because there are two enactment. My enactment is central enactment. Their enactment
What
is.
I'm saying, when once this writ, the first writ
Then
petition is allowed.
my lord, the difficulty which I'm going to face, I may not able to go to Supreme Court because the relief itself, my lord, become infectious. The moment the sale will go, or my lord will pass an order to refund it, then, my lord, I may not able to go to, my lord, the honorable FX court. That is
you can't go.
My lord, I may.
Or you can't go to Supreme Court. You can question the
sale,
Supreme
Court. There are two relief which I sought before this honorable. One, direct the, my lord, jurisdictional SR to register the property and lift the attachment made by the KPAD. That's a two, my lord, relief, my lord, which I sought before this honorable. Pursuant to, my lord, auction took place, and, my lord, auction, my lord, concluded in the favor of, my lord, sale certificate issued in favor of the petitioner, the petitioner. Therefore, my lord, the relief which I sought is based on the sale. The sale itself, my lord, if he is taking back the money, then sale will.
No. Once you say that this is binding, then you will go to the Supreme Court questioning it. So that along with that, his matter will also go.
I have to drag
So
my
the consistent view should be if your writ petition is dismissed, his writ petition should be allowed. And what about the interest and all?
No, interest, my lord, in this section, my lord, I may not able to pay it. The reason is, my lord, I
don't plead anything. Don't plead anything. I'll pass orders. I'm saying about what is the interest part.
May make one submission.
Their relief, I think, the
amount
interest
which I have paid as sale consideration, I have taken a loan from their same bank. So they have charged me interest on that amount.
How much interest they have charged?
They, whatever lending rate, about 11 or 12% of interest they have charged. So same interest, maybe I'll be satisfied. It's just my bad luck. I got into a bad property. I may have to exit.
Yes, both the writ petitions are resolved.
Grateful, my lord. Deeply.
I'll just make one submission. They may point out one thing. I have not sought for a prayer for refund of amount. I may be permitted to amend the writ petition. It may be posted on day of I have the
List both the matters day after tomorrow.
I'll file an appeal necessary. Just
Great.
to avoid technical.
Deeply.
Yes. Yes, 7.
I appear for the petitioner, my lord.
I appear for the respondent number 3, bank, my lord.
This,
There's
my lord,
a
I
stay
filed-
operating in my, again.
I'll make my submission.
Yes.
My lord, this petition is filed by the union of workmen who are working with the fourth respondent, my lord. The fourth respondent is the company. This,
Please come to the impugned order
please,
first.
my lords. What I have challenged is a sale notice that has been issued by the third respondent bank, where they have sought for this annexure P, my lords. Annexure P, my lords could see page 62.
Page 62.
Yes.
Your writ petition runs into 50,
13 pages. I'm sorry, the annexure P is at page 62. My lords has it?
Yes.
Please. And at page 64 is the sale notice for the sale of the property. May I request my lords to see page 64? This is the property that belongs to the fourth respondent. The amount outstanding insofar in page 64 of my lord has, the amount outstanding is rupees 8 crores 89 lakhs. The aggregate reserve price as per that sale, as per that notice is 15 crores 61 lakhs. The reason that the petitioners are before this court, the petitioner is a union of the workmen. There are 156 workmen who are working with the fourth respondent company. 2022, the company illegally lays off the workmen. At that point of time, I raise an industrial dispute before the Assistant Labour Commissioner. That dispute, the management does not come. It's referred to the Labour Court. There are various cases that are pending in respect of the workmen's dues are concerned. From minimum wages to Provident Fund dues to ESI dues to the payment of wages. In fact, there is an order that has been passed by the Payment of Wages Authority for one period at Annexure J, which is for the period from 4th March 2022 to 30th November 2022, where for that one period, 65 lakhs has been directed to be paid by the fourth respondent. When my dues were pending, my lords, this sale notice was issued. That's the reason I have come before this court. They have filed an application seeking for vacating the interim order on the ground that I'll have, go before the DRT. Now, insofar as the question of whether DRT can look into workers' dues, the Honorable Apex Court has said that workers' dues cannot be looked into by the DRT.
By even this court.
I'm sorry,
also.
Miller?
Even by this court also.
So ultimately, what has happened? It's not that I'm saying there should be no sale. My concern is that if there is a sale, that's the only property that's owned by the fourth respondent. The dues of the workmen which is running, and I've in fact given a breakup of the dues. May I request my lords to just for a moment, just see my writ petition where I've given the breakup of the dues at page 8. May I request my lord to just see this page 8 for a moment.
Yes.
The dues, there's a table at page 8. That 156 workmen are due the following amounts. The total amount, not including the bonus amount that is payable, the amount that is payable insofar as PF and ESI are concerned, it comes to 6 crores 92 lakhs. There is an order that has been passed by the Assistant Labour Commissioner, who's the authority under the Payment of Wages Act for 67 lakhs. Other proceedings are presently due. These amounts that are due to the workman, that will not become ultimately, my lord, if the only property of the respondent number 4 is this property which they seek to sell. If that is sold and that the money is used in entirety over there, workmen are ultimately preferential payers, so that once the workmen's dues are preferential payments, the amounts that are due to them will have to be considered. Without that, for them to sell this property would result in the workman having no rights whatsoever, even though all of these dues are become payable. That is the reason I have before this court. I have also sought, my second prayer may just be seen at page 13. I have challenged this annexure P, and at page 13 I have also sought.
Yes.
a direction to the fifth respondent, who's the Deputy Commissioner, to act on the communication dated 27th August 2024, places annexed K, to initiate proceedings for recovery of the amounts due to the workmen. I've also sought for a direction to the first, second, and fifth respondent as a state and the Deputy Commissioner to take steps to ensure the recovery of the amounts due to the workmen represented by the petitioner. Now, my lords, this is why I'm before this court. There are dues. The fact that there are dues are not disputed. Those amounts have to be ultimately made payable to me. The only property owned by the fourth respondent is this property. That's the reason I'm before this court. Even if my lord sees why I pointed out at Annexure P, the total amount, the reserve price that they have fixed is 15 crores, 61 lakhs. There, the amount that is of the loan is 8 crores, 89 lakhs. So ultimately, at least that balance payment will have to be made to me. And I stand on the same footing. I'm relying on certain judgments, my lords, to submit that the debt recovery tribunal does not have the jurisdiction in these matters.
No, that there is absolutely no this thing on that. Neither
Please.
the debt recovery tribunal nor this court has jurisdiction to do all this. Now,
Please.
understand
Please.
there are certain amounts due to the workman.
Please.
But which judgment or which law, which provision says,
please,
when there is when an obligation, a mortgage between your employer,
please,
and the bank,
please,
they on what basis they will give the amount to you, and on what basis this court can say whatever from the sale proceeds you give the amount to the employer.
Please.
When the when the third respondent gets the money, you have your own mechanism to execute the order that is already passed.
Please.
This court cannot pass.
My lord, my request would be this. From 2022, these workmen have been laid off.
I understand that the certain amounts are due. It's an injustice to the work. But when you have to pass an order, we have to pass an order and we have to do it in accordance with law.
Please.
If you tell the court like this is the way they are entitled and this is the way this court can direct the bank to give the money to you without giving it to the third respondent,
Please.
then this court will pass order.
Please,
But
my lord.
such a law, such it is not permissible because they cannot give. They cannot give the money to you, and what they can't do it, how can the court tell them to do it contrary to the Securitization Act, contrary to the rules?
Please, my lords, if I may just respond to what my lords have
Yes.
asked me. One is that the workmen stand on the same footing as secured creditors, as the bank, because the dues that are due to the workmen's dues are preferential payments. Even under section 529A of the Companies Act, my lord, the workmen's dues are preferential payments and they stand on par with the secured creditors. So even on that front, the dues that are the workmen are entitled to, that they are required to get. Insofar as
between
two,
the workman,
please.
between the workman
Please.
and the bank,
Yes.
which is a secured creditor.
The bank is a secured creditor, but my lord,
please understand.
Please.
Now, the amount that is due to the bank is 8 crores or 9 crores.
Yes.
In that auction, so and so amount which is in the auction, whatever is the excess amount, you have already an order. You have already an order that so and so amount needs to be paid from some deputy.
Yes, Labour Commissioner.
Commissioner.
Yes.
There is an order.
Yes.
So at that point of time, you should be able to execute the order. No, by stalling this auction, neither it is useful to you nor to them.
My lord, at the very least, my interest should be protected because what has happened?
That's what I'm saying.
Yes, my
The
lord.
court can't
That's the
protect
question that my lords has raised to me, which is what I'm answering. My interest has to be protected. The purpose of this exercise is not to stay this, but it is to protect the interests of the workmen in order to ensure that when their dues are being adjudicated, insofar as one period is concerned, adjudication has taken place. The provident fund that I am entitled to from 2022, I have given complaints and the processes have also started on that front. Even provident fund dues, my lords, this has preferential payments under the PF Act. I have also mentioned specific provisions. So both Provident Fund and the ESI Act provide for preferential payments to be made. If that's the reason I have also sought for the other prayers that has in my petition, where I've sought one insofar as the sale is concerned. The other is that the Deputy Commissioner, once an order has been passed in my favor, admittedly that it has not been appealed, there is no challenge to that order. There are orders that have been passed in my favor.
The third respondent is
And in
obligated
fact, my
to
lords
do
may
it.
see for a moment, I have also approached the civil court. I had approached the civil court and the civil court against my employer, where the civil court has granted a stay,
You've
restraining
not
them.
made me a party in that, my lord. It's very
Yes, I'm
convenient.
not saying that.
That is not, yes.
I'm not saying that. I have filed a suit against my employer, where I have sought for an injunction against them from them selling their machinery and their property. The reason I'm doing all this is to protect my rights. Some of my rights are still under adjudication. Some of my rights have been adjudicated upon. Ultimately, my lord, the rights of the workers also cannot be
In the same-
bypassed.
In the same,
I'll-
in the
please.
same civil suit,
Please.
you can also see that once the auction is conducted, whatever the amount, the excess amount, after it is adjusted to the dues, what is going to be refunded, you seek a direction that that should be paid back to the, that should be paid to the employees from a civil suit, from a.
My lord, my lords may just consider the condition of these workers.
No, we cannot.
My lords, I may just be permitted to, I'll just make my submissions on this front. Because a specific question has come from this court as to how, if there is any provision in respect of protecting the workers and their dues in this case.
Protecting the workers in the securitization.
Yes.
Proceedings under the Surface Act, where a property is mortgaged.
Yes.
By so and so.
Please.
Mortgagor and the mortgagee.
Please.
When there can be a direction from this court.
Yes.
To refund the amount to a third party to whom one of the contracting parties owes amount.
Please. I'll just.
Are they, like, at least can they do it? Can the bank do it?
My lord, if my lord sees my prayer, I have challenged that sale notice. I brought to the attention of this court.
Petition itself is not maintainable. You have no locus to question that.
My lord, the reason
If
I
that
have.
is the case, if
Yes.
this is how the petitions are filed, no surface proceedings can be taken to a logical end.
But other creditor, workmen cannot be placed on par with other creditors. If it is some other creditors, I completely see what my lords is saying. But workmen and the dues of workmen cannot be placed on par with other creditors. In fact, it's placed on par with the secured creditors, which is the reason under even 529A of the Companies Act specifically says there's preferential payment. My lords may just give me. I have certain judgments that I'm relying
Yes,
upon.
please do that. Take the judgment. Yes. Please refer to the particular paragraphs.
Yes. My lord, the first judgment I'll not refer to because my lord has already seen that the workmen's dues cannot be adjudicated before the debt recovery tribunal.
Yes.
Just to point out to my lords, it's at para 63, but it is what the point that my lords has already seen. The question at page 29.
Yes. Yes.
The para 63. The question is whether section 1919 of the 1993 Act clothes DRT with the jurisdiction to determine the workman's claims against the debtor company. We do not think so for more reasons than one.
Yes.
May I? Para 63. The question is whether section.
Anyhow, the law is laid down
very
that
well.
it is not.
On
Yes.
that, I'll not press on that.
Yes. Yes.
The second judgment, my lord, at
page 34.
Page 34. Para 111. 111 is at page 74.
Yes. Yes.
Please. 111. However, what is most significant to be noted is that there is no provision in either of these enactments. That is the DRT Act and the Securitization Act. However, what is most significant to be noted is that there is no provision in either of these enactments by which first charge has been created in favor of banks, financial institutions, or secured creditors for the property of the borrower. Under Section 13(1) of the Securitization Act, limited privacy has been given to the right of the secured creditor to enforce security interest vis-a-vis Section 69 or 69A of the Transfer of Property Act. May I request my lord to see para 114. Yes. By enacting various provisions to subsection 9 of section 13, the legislature has ensured that priority given to the claim of workers of a company in liquidation under section 529A of the Companies Act 1956 vis-a-vis the secured creditors like banks is duly respected. So therefore, my lords,
What is ultimately, what is the ratio that is laid?
Please, the question before the court in this was in respect of, it was looking at at paragraph 2, my lords, the facts have been mentioned. Page 45 may just be seen.
Yes.
Whether section 38C of the Bombay Sales Tax Act and section 26B of the Kerala General Sales Tax Act and similar provisions contained in other state legislations by which first charge has been created on the property of the dealer on other such persons who is liable to pay sales tax, etc., are inconsistent with the provisions contained in the Recovery of Debts due to the Banks and Financial Institutions Act 93 for recovery of debt and the Securitizations Act 2002 for the enforcement of security interest, and whether by virtue of non-obstante clause contained in section 34(1) of the DRT Act and section 35 of the Securitization Act, two central legislations will have primacy over the state legislations. That is the question that has arisen. In the course of what has been considered is in para 111, just prior to para 111 at para 108. The DRT Act and the Securitization Act have been looked into. The DRT Act and the Securitization Act were enacted by Parliament in the backdrop of recommendations made by the expert committees appointed by the central government. And in that context, para 111 may be seen.
Yes.
However, what is most significant to be noticed, there's no provision in either of these enactments by which first charge has been created in favor of the banks. And it is in that context, my lord, that the Honorable Supreme Court says that first charge is not created on the banks.
Because we can't look at the ratio like that. What has been decided in this matter, we have to look at it. Whatever are the passing observations of the court, that's not the ratio different.
Please, my lords, even if my lords were to see that, what has been considered and the reasoning that has been given, two things. One,
you understood actually what is at the mind of the court.
Yes, I have understood what is in the mind of the court.
If you have an answer, please show to the court.
My lord, the reason
what is the jurisdiction of this court to pass such an order, which the law doesn't permit. Under the Securitization Act, can this court tell the secured creditor that after you recover your amount, pay the amount to a third party, but not to the owner of the property? Can such an order be passed? According to me, your cause of action will start the moment they have issued the auction notification. And the amount, whatever is the amount, because 25%, once the bidder pays the 25% of the amount, then you will be knowing what is the amount, how it is knocked down, and basing on that, in the civil suit that is pending, there you make them as a party and ask for it. But not, this court cannot, because what is contrary to law, even understanding the difficulties of the parties, we can only do justice in accordance with law. Here and there, where it is on a humanitarian ground, we can't do anything contrary to law. That would be setting a bad precedent.
Lord, I understand what my lord is saying. My respectful submission is that what we are seeking for is in fact not contrary to law. The reason that we are challenging that sale notice, when there are dues that are payable to...
Not the sale notice.
Yes.
First of all, sale notice you cannot question. That is also contrary to law. Number two, please tell the court, the only issue here is,
yes,
you want a direction from the court, whatever is the remaining amount that should be given to you. Under which provision this court can direct them? Under the surface proceedings.
Please, with respect, my lord.
Under the light of the mortgage that is executed.
Yes.
By your, who appears for the owner?
Employer.
Who appears for the owner? The third respondent.
They are unrepresented.
Milords, I am appearing for the fourth respondent. The fourth respondent is the owner, Milords. Third respondent is the Axis Bank, Milords. I have this only property, Milords. I have nothing else.
I'm sorry,
and that property is taken over by the bank, Milords.
But
so
nothing has been taken over. There is a stay operating since April.
Please. I mean, the surface proceedings are pending before me, Milords. Milords?
You appear for the owner?
I appear for the owner, Milords. Respondent number 4, Milords. Now the property is on with me is only this very property, Milords. I have nothing else to pay the workers, Milords.
For example, the dues are 8. If this property fetches about 20 crores in the auction.
Please, Milords.
Then?
Milords, for that, Milords, I shall file my objections to this writ petition, Milords. I shall take the instruction what is to be done. And I shall file my objections within the period of 4 weeks, Milords.
And when did you enter appearance?
Milords?
When did you enter appearance?
Probably 2 months ago, Milords.
What are you doing for 2 months?
Milords, instructions has to be given by the employer, Milords. By my client.
What is that submission?
My lords, we have been trying our best to procure
No,
the
I'll
objection.
record that no instructions from your employer.
My lords,
From
I
your
may
client,
I may be
not
given
employer, from your
just 2
client.
weeks, my lords. I shall file it.
Yes, anything
Please.
else?
My lords, the other judgment what I'm relying upon.
Please point out.
Yes, yes. My lord, may I make one submission? In light of the fact I stand corrected. I was not aware that the fourth respondent is has entered appearance before this court. In light of the fact that the fourth respondent is before this court, my other two prayers that are there, insofar as recovery of the amount is concerned, where I have sought for a direction against to the first, second, and the fifth respondent, who is the deputy commissioner, to recover these amounts. In light of the fact that the fourth respondent is here, at the very least, my lord, if something were to go forward, then that whatever remaining amount is there, that at least, my lord, may be deposited before this honorable court, my lords may consider, so that the dues of the workmen may be, will not, the effort of the workmen to ensure that their dues are gotten will not go to vain. The reason, firstly, my lord, my submission is that my petition, I have challenged the process itself. But since the notice is for the reserve price is for a period of, is an amount of 15 crores something, and the loan is around 8 crores. At least the balance amount, my lord, my rights may be protected. Since the fourth respondent is also before this court. That's the submission that I made. Secondly, that is not my main prayer. In fact, if my lord sees my main prayer, that I'm not seeking for it. In my main prayer, I have actually sought that the entire amount cannot go to the bank.
So
The other
has not even taken place.
Yes, yes.
Auction has not even taken place.
No, I'm relying
Don't
on the
even
sale
know
notice to
the
say
amount
what
the land will fetch.
I'm only relying on their sale notice. I'm not saying anything. In all probability, it's much more than that. The other judgments.
When was the interim order passed?
Interim order was passed in April.
25/4, my lords, April. My lord.
April.
25th April, 2025. My lord.
On 24th April. 24th April, the interim order has been passed.
Please come.
My lord, may I just, I'm sorry for interrupting, my lords. I'll just point to the other two judgments that I'm relying upon.
Yes.
At page 108, if my lords could see.
Yes.
In this, the Assistant Provident Fund Commissioner had issued a notice in respect of the properties that had been, Lords may just see para 5, page 116.
Yes.
Though the appellant has not given the details of the dues of Provident Fund payable, a reading of the document shows that the Assistant Provident Fund Commissioner passed an order dated 29 September 2003 under Section 7A of the Act, whereby he held the employer liable to pay rupees so and so towards EPF contributions. Para 6, my lords. As the employer failed to comply with that order, the Assistant Provident Fund Commissioner and Recovery Officer issued warrant of attachment dated so and so under Section 8B for recovery of amounts which included 12% income. The warrant of attachment was executed by the enforcement officer on 26 March 2004 by preparing an inventory. The appellant challenged the warrant of attachment and consequential action taken on the ground that in view of the deed of pledge executed by the management of the sugar mills, the sugar bags which were lying under its lock and key could not have been attached. This was the question before the court. At para 25, page 125.
Yes.
An analysis of the para 25, an analysis of the above provisions, this is in respect of the Provident Fund Act, shows that for providing financial benefits to the workers who contribute to the growth of the industry and industrialization of the country, the legislature has made provision for framing of various schemes under Section 5, so and so. Then, my lord, it looks at the provisions of the Provident Fund Act. And the reason I'm pointing to this is Provident Fund dues are also due to me.
Yes.
Section 30, paragraph 30 at page 126. Since the Act is a social welfare legislation intended to protect the interest of a weaker section of the society, that is the workers employed in factories and other establishments, it is imperative for the courts to give a purposive interpretation to the provisions contained therein, keeping in view the directive principles of the state policy embodied in Article 38 and 43 of the Constitution. Para 31, minutes over the page. We shall now consider the question whether the provisions contained in section 11(2) of the Act operates against other debts like mortgage, pledge, etc. Answers to this question is clearly discernible from the plain language of section 11. The priority given to the dues of provident fund, etc. in section 11 is not hedged with any limitation or condition. Rather, a bare reading of the section makes it clear that the amount due is required to be paid in priority to all other debts. Any doubt on the width and scope of section 11 qua other debts is removed by the use of expression all other debts in both the subsections. This would mean that the priority clause enshrined in section 11 will operate against statutory as well as non-statutory and secured as well as unsecured debts, including a mortgage or pledge. Subsection 2 was designedly inserted in the Act for ensuring that the provident fund dues of the workers are not defeated by prior claims of secured or unsecured creditors. This is the reason why the legislature took care to declare that irrespective of time, when a debt is created in respect of the assets of the establishment, the dues payable under the Act would always remain first charge and shall be paid first out of the assets of the establishment, notwithstanding anything contained in any other law for the time being in force. Section 11 of the Act, my lord, specifically mentions this.
What is the mode of execution?
Under section 11 of the
Any
Act.
of the dues that are payable.
My lord, it's through attachment.
So that step you have not taken till now.
My lord, that's the reason the issue that I'm facing is all of this.
No, then the question comes.
Yes.
Now about about the secured creditor, about the Surface Act and section 26. What is section? Give the tag.
34 months. 34 is the one which bars the jurisdiction.
D.
Right of enforcement of security.
It also starts with the non-obstacle.
Please, my lords. In fact, the next judgment that I'm relying upon looks at this the non-obstante clause and says that only operates in that field. My lords may just see page 146.
No, here the issue is you have not done anything with regard to the execution of the order that is passed with the deputy
labor commissioner.
You have not done anything.
I have, my lord.
No. Where is it? Not before this court.
My lords may see. No, not before this court. I have approached the concerned authorities. If I had not done that.
So whatever is the mode, that they have to start, and there is no issue as of now whether this property, whether your dues are first or the secured creditor's interest is first. That's not the issue. You have come before this court interfering with this proceedings initiated under the Surface Act.
Yes.
And you say stop the auction, ask the bank to pay the money. Who is this court to tell the bank to pay the money to you when that is actually payable to the owner, the person property belongs to? So law doesn't permit this court to do all that. In the process of execution, whatever is available to you, you please avail those remedies.
My lord, may I make one submission? I'm not before this court seeking that the balance of the proceeds of the auction be given to me. I only made that submission as a second point, since they said that this is the amount due on the basis of the sale notice. I am not before this court seeking that the bank auction the property and take the money and pay the balance amount to me. That's not what I'm before this court on. I'm before this court saying that given that my dues are preferential payments that are payable, both the wages that are payable to me, my lords may just see for a moment section 529A. The dues that are payable to the workmen they are preferential payments that are payable. The fact that the provident fund dues, they are on first preference, my lord. That's what the law says, and that's what the Honorable Apex Court has said as well.
The judgment which you have read is 2009. This is 2016.
I'm sorry, my lord.
2009, the judgment which you have
read.
This is 26D is, I think, 2016.
Please, but that was looking at the interpretation of the Provident Fund Act, where it looked at what section 11 of the Provident Fund Act, how it protects the rights of the workers in terms of.
Please tell the court, after the deputy commissioner's order is
Yes.
passed, what has happened?
And
what did you do? Except filing the civil suit,
Please.
under the act, what is the mode of execution of the
Please.
order of the deputy commissioner?
My lords may just see Annexure K.
Annexure?
K.
Page number?
Page 42.
Yes.
The amounts that are payable to me are recoverable as arrears of land revenue by the deputy commissioner. The order that has been passed by the labor commissioner under the Payment of Wages Act.
When was this order passed by the deputy commissioner?
The order that was passed by the assistant labor commissioner was passed on 4th July 2024.
Yes.
On 4th July 24, Annexure J. Annexure J is passed.
Yes.
On 27th August 2024.
As per that, it is 80 lakhs 96,000.
That is one portion, my lord. That's what I said. That's precisely what I said. Insofar as some amounts, the adjudication has taken place.
So now the amount that is adjudicated is 80 lakhs 96,356. The remaining amount is yet to be
Is yet to be adjudicated. And in that regard, also the proceedings that have been initiated by
after
me.
that, what was done?
Please, insofar as this amount is concerned, I approached the deputy commissioner because deputy commissioner is required to recover that amount as arrears of land revenue.
Yes.
As per Annexure K, on 27th August 2024, I write to him saying that this order has been passed under the Payment of Wages Act at page 42, my lords.
I've seen that.
Please. So I write to him asking that the amounts are due to me. So please take.
After that, what happened?
They have not taken steps, my lord.
For that, then that you have to pursue that.
Please.
After that. So this is, you're saying this is on 17/12/2024.
Yes.
So from the last 1 year, what has happened?
Lord,
the recovery. If they are not acting upon it,
yes,
then you have your remedies.
My lord, may I make one request? I understand I have taken my lord through some of this, and my lord has a specific question to me on this. Please give me till tomorrow. Let me just look into this question. I'll make my submissions tomorrow, and then my lords may see what is to be done.
My lords, I may be permitted to file my objections, my lords, within 1 week.
Nobody, no, will not give you any time. I'll record that you have not filed.
My lords, it is given on, it is received by us on 1/8, my lords.
Auction is stayed from the last how many months? 6 months.
My lords, we have received this reputation on 1/8, my lords.
Whenever you receive, you should have filed by this
My
time.
lords, it may be 1 week may be granted, my lords.
This matter on Tuesday, by the time whatever you want to file, file, or else I'll record and I'll record that you have no objections to file.
The stay may be
Please, my lords.
vacated, my lord.
My lord,
May I
Tuesday,
take a
I'm asking
vacation
for
of the
tomorrow,
stay?
my lord.
It is like in a matter of this, how can the money of for your 86 lakhs that is determined, an amount of what is the price?
8 crores.
8 crores.
My lord, the
Auction
total,
is stayed.
the reason I showed my lords that table, my lords may consider
And you know,
workers out of job.
You are saying about 8 crores, but determined amount is only 80,000.
But they are all pending, my lord. If I had not done anything,
Till your matter, till all your dues are decided or
Please.
adjudicated, we can't stop the auction.
My lords, I understand what my lords is saying. My only request to my lords is to see 2022 there is a layoff. Those proceedings are initiated by me immediately.
Understand one thing. I think you already understood.
I
what
have
I'm
understood,
saying.
my lords.
But that's not the scope of this writ petition. The issues, problems cannot be addressed everywhere and anywhere. We can only do it in a proper forum.
Please.
And this forum is not the place for your client to adjudicate his grievance. It is somewhere else, and we can't interfere. Already for 6 months, this auction is stayed at the behest of a third party.
My lord,
Let's this matter on Tuesday. No further time. Whatever you want to file,
Please,
file
my
by
lords.
that day.
Please,
Yes.
my lords.
my lord, interim order may be extended till
But
then.
I object
Yes, it
to
will be
the
extended till Tuesday.
Please, grateful.
And only on that day, I
Yes,
want
my lord.
on the point, please, 5 minutes.
Please,
Yes.
grateful.
My lords, appearing for the petition, It's under
What about the
challenge is-
respondent notice?
And summons has been served on the respondent, my lords.
Who is that advocate? The respondent of the trial court not mentioned.
My lords, that is, it's a section 13(2) notice, demand notice that I have challenged. I have served the respondent at the address. The
Oh,
bank.
that is,
Yes, and someone served on the address. my lords.
Which bank is this?
My lords, this is Canara Bank, my lords. Infantry
Where is
Road.
Mr. Shetty? Give papers to him.
Given, my lords, handed over to the respondent.
So only after the invitation you will come. Have instructions?
No, my lord, I'll take care.
Get
My lords,
instructions
my lords,
on
my
Monday?
submission, only one submission, my lords. After filing of this writ petition, section 13(4) notice has also been issued.
Nothing will happen. Why, if we want to set it right, we can do it retrospectively also.
Please.
This is matter on Monday. By that time, get instructions.
Please.
List, print the name of Mr. Vignesh Shetty. Yes.
Appear for the, my lord, the application, my lord, for amendment of the writ petition, because meanwhile, a sale notice has been issued. Therefore, my lord, I have sought for an amendment to question the sale notification also
In this writ petition.
in this writ petition. There is
So
application.
what is the writ petition about?
My lord, the section 14 order is under. The 14 order has been issued to take possession of the premises in question. My lord, as on the date, my lord, only 1,99,000 was due towards EMI. But outstanding due according to them is 46 lakhs. My lord, I am ready and willing to pay whatever the EMI as on today within 2 weeks. And as a matter of fact, my lord, if they are ready, my lord, I am ready to close the entire amount. With 3 months is given.
Then file affidavit, my lords, I'll seek instructions.
If I come up with an
But
affidavit.
physical possession is with the bank.
Physical possession, my lord, they have also locked the premises question.
First of all, you come up with an affidavit, whatever you're saying,
Yes, my lord.
then we'll
Let them serve in
consider
advance, let them serve in advance the affidavit copy. I'll seek instructions and we can positively. we
When can you
proceed.
come back?
Monday, my lord.
We'll take it on Tuesday so that you have to serve on him.
Very well.
Then counsel for the, senior counsel appearing for the petition submits that the petition is ready to settle the amount and pay all the dues within a reasonable time. And in
Within
this
3 months,
regard,
within 3 months, we'll close the entire loan account.
within 3 months. And within 3 months, and some amount will be paid within 2 weeks from today. And in that regard, he'll file an undertaking affidavit before this court. This is matter on Tuesday. By Monday, the affidavit shall be served on the counsel for the respondent bank. Yes. Yes.
I appear for the petition in this matter, my lords.
Hmm.
The matter is related to the execution of a sale certificate beyond the scope of a mortgage. And the property in the survey number.
You're questioning the sales certificate.
Sale certificate, my lords.
Who are you?
My lords, I'm the owner of the property.
Oh.
My lords, the subject matter of the mortgage
Hmm.
is 35 guntas. Out of 35 guntas, 30 guntas are 30 gunta is converted and 5 gunta was not converted. All along, my lords, from sanction letter to the auction notice, I mean demand notice, possession notice and the auction notice, the subject matter of the mortgage was 30 guntas to an extent of 32,670 square
Your
feet.
mortgage is 35 guntas or 30 guntas?
My lords, that is the confusion they have. It is there in the entire sanction letters, demand notice. Mortgage is 30 guntas only, my lords. Because 5 guntas is agricultural land that cannot become the subject matter of the mortgage as per section 31I.
No. Let's forget about the other things. So when you have
30
mortgage, now the entire 35 guntas is one document.
Please, my lords. One document, but before
Mortgage date.
before mortgage, it was converted. 30 guntas was converted. And 30 guntas was given as a mortgage, as could be seen from the sequential
All the documents.
All the documents.
Hmm.
The sold document, the 35 guntas was sold, and subsequently rectification deed
But the
was.
document is mortgage, the entire document is with them, the
Yes,
title
yes,
deeds.
yes. Please.
That pertains to 35 guntas.
35 guntas. So now the question, they issue a sale certificate to the extent of 35 guntas, measuring.
When the sale notice is issued, where is the sale notice?
Lots of sale notice, as could be seen from Annexure A at page 24.
What did it say?
Lots, The typed copy may kindly be seen at page number 25. The description of the property, details of the secured asset. Lots, all that piece and parcel of the converted land and building thereon, survey number 28/6, measuring to an extent of 35 guntas, measuring 32,670
When was the
square.
sale notice is issued on 6/4/2023?
Please, my lords.
Was ever questioned this?
My lords,
notice?
subsequently it was questioned, my lords. It was
When
questioned.
was it questioned?
My lords, the writ order, my lords, first it was questioned on.
No, 13/2 notice, does it refer to 35 guntas?
Please, my lords, 35 guntas, my lords, 35 guntas equal to 38,115 square feet.
So 13/2 notice, have you filed your objections to 13/2 with on this point that it shouldn't contain 5 guntas, it is only 30 guntas that I have mortgaged, but not 5 guntas? Have you taken such a plea at any point of time?
My lords, that I need to verify, my lords, but so far as the documents reflects, my lords, that objection is not in my hand.
You just be relaxed and then come before the court
No,
after
no, my
2-3 years, whenever you remember
My
a
lords,
plea.
may I submit, my lords?
At an early, no, I want to see 13/2, any objections are filed. For this sale notice, which is here now, which is issued on 6/4/2023, what did you do? What was the order in the writ petition?
My lords, orders of the writ petition, your lordships can find at Annexure Q, page number 32, 132. My lords.
32 is not the order, it's a deed of rectification.
My lord, 132, my lord.
132, yes.
My lord, may I just interfere? The very same issue, my lord, assailed before this honorable court. In fact, this honorable court passed an order to go before the DRT, very recent.
This is the one,
This
134.
is the same thing.
No, he has filed, I think.
My lord, writ petition number
Krishna Kumar's
30162 of 2025, Justice Suraj Gunjraj.
He has filed it.
Because the benefit of copy, I don't have.
I'll serve, but even I am not.
This is, my lord, this is the precise order saying that you go before
Without
the DRT.
expressing any opinion on the merits or demerits of the rival contentions, I deem it just and appropriate.
No, that could not be of this issue.
No, whatever, my lord, sales certificate, my lord,
No,
kindly come to the.
in favor of the petition to approach the DRT in accordance with law, that's the order.
And I'll verify, my lords, my issue, my cause is.
No, the order that you have placed before this court also says so.
Please, my lords. Please, my lords. May I?
Argued before this one. In fact, I am assisted in this matter, wherein, my lord, the petition
Is it WP 3146 of 2023?
30162 of 2025. 30162 of 2025.
This is another pass on.
Kindly see, my lord. It is a very recent order. This all the issues, my lord, which you have, my lord, order dated, my lord, 9th October 2025.
This is WP 30162 of 2025, dated 19th October, recently.
Very recent. Not even.
To issue a writ of mandamus so-and-so, directing respondent number 1 not to register the sale of Schedule A property, dated 14/8/2025. Directing respondent number 1 to open the locks of the Schedule A property and permit the family members of the petitioner and his tenants to reside in the property.
My lords.
What is the order in this?
That cannot be.
But after arguing the matter for some time, counsel appearing for the petitioner seeks permission to approach the debtor tribunal by filing an appropriate proceedings, reserving such liberty to the petitioner.
Let me verify, my lords. Based on the contents, my lords, it is not the same. It might be the one or the other scheduled property, residential property.
In this writ petition, which is, when is it filed? It's filed on 16/4/2025.
Please, my lords.
This is, I think, this is the latest writ petition.
9th, subsequent to this.
This might be pertaining to other properties, my lords.
This all the contention, my lord, which is canvassed. In fact, I was assisted for the respondent in this matter. This court refused to accept the submission, sale certificate issue, sale notice issued, everything, my lord. Then court said that either I'll dismiss or you take it.
No, this court will also do the same thing. Let him argue.
Grateful.
Yes.
My lords.
So now the fact is, from 13/2, they were mentioning about 35 guntas of land.
Please, my lord.
And you have not questioned anything. Then when the sale notice is issued, you have filed a writ petition. The court has asked you to go to the DRT. What did you do?
My lords, I could not go to DRT, my lords, because there was a stipulation. The limitation was not extended. My para 24 may kindly be taken of the writ petition, my lords. 21. Lords, it is submitted that.
So what will happen to that order?
My lords, thereafterwards.
So that issue with regard to the sale certificate,
please, my lord.
this court will not go into, because already There is a direction from this court saying that you go to the DRT.
My-
For
my-
whatsoever reason you have not gone, you have to go and file you ask, go before the same court.
My
Saying
lords,
that I didn't go.
the
I was-
45 days limitation that would impact me, my lords, that is one aspect. Second aspect, my lords, it consistently the courts have held after issuance of a sale certificate or a sale certificate is not a measure under SURFACE. So I cannot go to DRT questioning the sale certificate.
Why did you keep quiet after taking that order? When the court said, go to DRT, you said that you will go, you accepted that
My
order.
lords, the only the
No,
claim-
there has to be some end to this litigation. This can't go on like this.
Please, my lords. My lord, so far as my submission is this, my lords, the subject matter, the property, which is not at all the subject matter of the
That we will
mortgage.
not look into at this stage, when it is happening from the last 3 years. You just be a mute spectator to all this, that the bank time and again is mentioning it as 35 guntas, never it was 30 guntas.
My lords, there.
So you have deposited the title deeds of 35 guntas. And whatever you're saying now, how can the court?
For a minute, my lords, Annexure C may kindly be seen. Annexure B is the sale certificate. Annexure B at page number 38.
No, you have to show me one document where it says, it refers to 30 guntas.
My lords, your lordships can turn to page 67, Annexure H.
Yes.
Lords, Annexure H is the sanction letter. Sanction letter dated 13/8/2018. My lords, page 67, the item number 2. Item number 1, hypothecation of stocks and receivables of the firm. Item number 2, equitable mortgage of converted land and building thereon measuring 32,670 square feet, 30 guntas. This is one, my lords. This second, my lords, Annexure K, page 92. Lords, at the second item, my lords, EM over industrial property bearing survey number 28/6 measuring 30 guntas in the name of so and so and so. This is the second instance, my lords. Lords, Annexure M, page number 127. Page 127, my lords. The collateral security, EM of converted agricultural land and building thereon on the survey number 28/6 measuring to an extent of 35 guntas measuring 32,670 square feet. My lords, next.
Why suddenly, where is it?
My lords, next instance may kindly.
Why suddenly this 30, from 30 guntas, it has come to 35
My lord, I
guntas?
had to verify, my lord, the documents, my lord, the file, my lord, is not given to me, petition.
Because
I-
you're all
I just
your
go through.
loan
But,
sanction,
my
your.
lord, my lord, I will, my lord, I'll definitely, after serving the copy, my lord, I'll. Here the matter, my lord, this issue, my lord, assailed before this honorable court, the sale certificate, that is Annexure K, my lord, kindly come to my lord, page number, that is assailed before this honorable court. They accepted the order, they're not gone before any appeal, my lord, they're not taken this order, my lord, in the writ appeal. Or, my lord, they're taken a liberty to go before the DRT, filing one more writ petition, my lord, it will not serve.
No, this was pending, my lords.
That is from his side, that we will consider. These are all the technical objections that we will consider your objection also. But the action on behalf of the bank should also be fair.
That I have to see, my lord. Let them
Please
serve
get
it.
instructions on that point. Yes.
Let them serve a copy.
This
for
is
me, my lord.
counsel will serve the copy of the writ petition.
Please, my lord.
And the counsel for the respondent. This is matter on 13th of November.
Grateful, my lord.
Lords, may I?
In the name of Mr. Vignesh Shetty.
Lords, 14th, my lords.
14th.
Please.
Great.
Great.
No, 14th it is not possible. Either it is 13th or 17th.
18th, my lords.
Yes, 18th.
Grateful.
God bless.
After lunch.
She's clicked it.
Does she continue the list or does she take pass over?
No idea. So I'm trying to find out. Because she has a 230 list also.
How many markers got passed over?
List 5 is at 230.
Madam. Madam. How come? ಬಂದಿದ ತಕ್ಷಣ ಇದು ಮಾಡಿ 2:30 ಬರ್ತಾರಲ್ಲ ಮೇಡಮ್ ಏನಂದ್ರು ಏನು ಇನ್ನೊಂದ್ಸತಿ ಮಾಡಿ ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಅಲ್ವಾ ಒಂದೇ ಪಾಸ್ ಅವರ ಅಲ್ಲ 2:30 ಲಿಸ್ಟ್ ಏನ್ ತಗೊಂಡ್ಬಿಡ್ತಾರ 2:30 ಇದೆ ಅಂತ ತಗೊಂಡ್ಬಿಡ್ತಾರ ಕಂಟಿನ್ಯೂ ಆಗದೆ ಒಳ್ಳೇದು ಮತ್ತೆ ನಾವು ಕಾಯ್ಬೇಕು
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಯಾವ ಲಿಸ್ಟ್ ಮೇಡಮ್ ಕರೆದಿರಿ ಲಿಸ್ಟ್ 5 ಮಧ್ಯಾಹ್ನ ಇವಾಗ ಯಾವ್ದು ಮೇಡಮ್
ಮಧ್ಯಾಹ್ನ ಬರೋದು
ರೀಚ್ ಆಗುತ್ತೆ
ರೀಚ್ ಆಗುತ್ತೆ ಒಂದು 3:30 ರೀಚ್ ಆಗುತ್ತೆ ನೀವೊಂದು ಸ್ವಲ್ಪ ಕೂಲ್ ಆಗ್ಬೇಕು, ಕೂಲ್ ಆಗ್ಬೇಕು ಸ್ವಲ್ಪ ನೀವು. ಇಲ್ಲ ಸರ್ಗೆ ಹೇಳ್ತೀನಿ ಬಿಡಿ, ಸರ್ಗೆ ಹೇಳ್ತೀನಿ ಕೂಲ್ ಆಗಿ ಕೇಳ್ತೀನಿ. ಸರ್ ಹಾ, ಅದೆಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗ. ಹಾ ಹೌದು, ಅದೇ ಆಗಿರೋದು ಸರ್ಕ್ಯುಲರ್. ಅದಕ್ಕೂ ಪೇಜಿನ ಅದು ಏನೋ ಸರ್ಕ್ಯುಲರ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಇಷ್ಟ ಬಂದಂಗೆ ಮಾಡ್ತಾರೆ. ಅವ್ರು ಮಾಡಿದ್ದನ್ನ ನಾವು ಫಾಲೋ ಮಾಡಬೇಕು ಸರ್, ಬೇರೆ ಆಪ್ಷನ್ ಇಲ್ಲ ನಮಗೆ.
ಸ್ಕ್ರೂಟಿನ್ ಬರ್ತಾರ ಅಷ್ಟೇ ಬರೀ ಬರ್ದ್ಬಿಡಿ. ಸ್ಕ್ರೂಟಿನ್ ಬರ್ತಾರ ಆಕ್ಚುಲಿ ಆಗಿದೆ ಏನಿಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. ಅದು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮುಂಚೆ ನಾವು ಇಮೇಲ್ ಹಾಕಿದಿರಲ್ವಾ, ಆಮೇಲೆ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬಂತು ಅಂತ ಅದು R2 ಮಾಡ್ಬಿಟ್ಟು ಆ ಶೀಟ್ಸ್ ಎಲ್ಲ ಬ್ಯಾಕ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕಿ. ಇಲ್ಲೇ ರೈಟ್ ಬರೀ ಎರಡು ರಾಂಗ್ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲೇ ಬರೀ ಎರಡು ಕಡೆ ರಾಂಗ್ ಹಾಕಿದ್ದಾರೆ ಮಾಡಿಲ್ಲ ಅಂತ ಅದೇ ಬರೀ ಇಲ್ಲ ಮೇಡಮ್ ಆಲ್ರೆಡಿ ಆಫ್ ಸಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಲ್ಲಿ ಅವ್ರು ಬಂದ್ರೆ ಅದೇ ಮುಂದೆನೆ ಕೇಳ್ತೀನಿ ನೋಡಿ. ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಮಾಡಿ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿದ್ದೀನಿ. ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಲ್ರೆಡಿ ಹಾಕಿದ್ದೀನಿ ನಾನು. ಪಾರ್ಟಿ ಮಾಡಿ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿದ್ದಾರೆ. ಪಾರ್ಟಿ ಮಾಡಿ ಆಲ್ರೆಡಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅವರೇ ಹಾಕಿದ್ದಾರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಪೆಟಿಷನ್ಗೆ. ಅದು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿದ್ದಾರೆ. ಹಾ ಯಾವುದು ಮೇಡಮ್ ಇದು? ಪಾರ್ಟಿ ಹಾ ಏನಾಯ್ತು ಮೇಡಮ್ ಅದರಲ್ಲಿ? ಅಂದ್ರೆ ಕೃಷ್ಣ ಇದರಲ್ಲ ಬಿಲ್ಡರ್ ಅಷ್ಟು ಓ ಬ್ರಾಂಚ್ ಇದಾಗಿದೆ. ಓಕೆ 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 ಓಕೆ. ಯಾವಾಗಿದೆ ಮೇಡಮ್ ಮ್ಯಾಟ್ರು? ಅದನ್ನ ಅದು ಸಾಫ್ಟ್ ಕಾಪಿ ಇದ್ರೆ ನಂದು ಇದು ವಾಟ್ಸಪ್ ನಂಬರ್ ಇದೆ. 7th 8th ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಟಸ್ ಏನು ಸ್ಟೇಟಸ್ ಇದು? ಜಮ್ಮು ಯಾರು ಹೊಸ ಹುಡುಗಿ ಯಾಕೆ ಕೊಡಕ್ ಹೋಗಿದ್ರು ಮೇಡಮ್? ಇಲ್ಲಿ ಕ್ಯಾಲೆಂಡರ್ ತಲೆ ಎಲ್ಲೈತಿ ಇಸ್ಕೊಂಡು ಹೌದು ಹಾ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಹಾ ಊಟ ಮಾಡಕ್ಕೆ ಮಾಡಿಸಿದ್ದು ಸರಿ ಥ್ಯಾಂಕ್ ಅದರಲ್ಲಿ ಕನ್ಸ್ಯೂಮರ್ ಕೇಸು ಅದು ಏನಾಗಿದೆ ಅದು ಆರ್ಡರ್ ಕನ್ವೀನಿಯಂಟ್ ಕನ್ಸ್ಯೂಮರ್ ಕೋರ್ಟಿಂದ ಆರ್ಡರ್ ಬಟ್ ಕನ್ವೀನಿಯಂಟ್ ರೋಡಲ್ಲಿ ಇಲ್ವಲ್ಲ ಆಫೀಸು ಅದು ವಾಪಸ್ ಹೋಗಿದೆ ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳೋದು ಅಮೌಂಟ್ ಇದ್ದು ನಮಗೆ ಕೊಡಬೇಕು ಅದರಲ್ಲಿ ನಮಗೆ ನೋಟಿಸ್ ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ ನನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ ಅದಕ್ಕೆ ಪಾಪ ಆರ್ಡರ್ ಆಗಿತ್ತು ಅದು ನಾವು ಎಕ್ಸಿಬಿಷನ್ ಹಾಕೊಂಡಿದ್ವಿ ಅವರು ಅವ್ರು ಬಂದು ಈಗ ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ ಈಗ ನಮಗೆ ಡಿಪೆಂಡ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಸರ್ವಿಸ್ ಮಧ್ಯಾಹ್ನ ಸಂಜೆ I saw in the WhatsApp mail. I will ಸರ್ ವೈಟ್ನರ್ ಹಾಕ್ಬಿಡಿ ಸರ್ ಅದು ಮೇಡಮ್ ಅವ್ರು ಹೇಳ್ತಿದ್ದಂಗೆ ಅಲ್ಲಿ ಬೇಡ ಆರ್ಎಸ್ಗೆ ಡಿಆರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟು ಸರ್ ನಿಮ್ದು ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಏನಿಲ್ಲ ತಾನೆ? ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀವಿ, ಎಲ್ಲ ಕಡೆ ಎರಡೆರಡು ಕೇಸ್ ಇದೆ ಅಷ್ಟೇ ಅಂತ ಇದಕ್ಕೆ ಬಂದಿದೆ. ಆಗಲ್ಲ, ಅದು ಟೆಂಡರ್ ಬ್ಯಾಂಡ್ರು ಅಲ್ಲ ನೋಡಿ ಹೋಗಿದ್ದಕ್ಕೆ ಇಟ್ಕೊಂಡೆ ನಾನು ಇಲ್ಲಿ 16ರಲ್ಲಿ ಇಲ್ಲಿಂದ ಓಡೋದ್ನಲ್ಲ ಈಗ ಕ್ರಾಶ್ ಹೋಗ್ಬೇಕು ಅಟ್ರಾಸಿಟೀಸ್ ಅದನ್ನ ಬಿಟ್ಟು ಓಡ್ ಬಂದಿದ್ದೆ ಮಾಡಿರಲ್ವಾ ಹೇಳಿ. ಊಟ ಮಾಡಿಲ್ವಾ? ಊಟ ಮಾಡಿ ಬನ್ನಿ, ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ. ಮೇಡಮ್ ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಏನಿಲ್ವಾ? ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಏನಿಲ್ಲ ಅಲ್ಲ, ಡೈರೆಕ್ಟ್ ಇದ್ದಾರಾ ಇವಾಗ ಇಲ್ಲಿ? ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಸ್ಪಷ್ಟ ಹೆಂಗೆ ಮೇಡಮ್? ಅದೇ ನಮ್ದೊಂದಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಲಿಸ್ಟು. ಓಕೆ, ಅದೊಂಚೂರು ಫಾಸ್ಟಾಗಿ ಕೂಗ್ಬಿಡ್ಬಿಟ್ಟು.
ಮೇಡಮ್ ಮೆಮೋಕ್ಲು ಸಂಜೆ ನೋಡ್ತಾರೆ ಸಾಹೇಬ್ರು?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮೇಡಮ್ ಇವಾಗ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಕರೀತೀರಾ?
ಮೇಡಮ್ ಅವ್ರೆ 4ನೇ ಲಿಸ್ಟ್ ನಮ್ದೊಂದು ಕೇಸ್ ಕರೀರಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತಿರ್ತಾರೆ. ನಮ್ದು ಒಂದೊಂದು ಕರೀರಿ ರೂಲ್.
ಫಸ್ಟ್ ಪಾಸ್ ಓವರ್ ಕರೆದಾಗ
ಎಲ್ಲಿ ಎದುರಿಲ್ಲ ಇದನ್ನು ಆಚೆ ಬರ್ಬೇಕಾ? ಟೆನ್ನು ಟು ಎರಡೇ ಪರ್ಸೆಂಟ್ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮದು ಟು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಡಿಪಾರ್ಟ್ಮೆಂಟ್ 2 ಪಾಸ್ ತಗೊಂಡ ಹೋಗಿ ಕಾಪಿ ಕೊಡ್ತೀವಿ.
Petitioner, my lord.
Yes.
My lord, in this, there have been two interim maintenance order passed against the petitioner, where we have challenged only one, that is of a wife for 5,000. My lord, order at page number 88 may kindly be seen, where a respondent is also working. It has been 1, 2, 3, 4, 5, 6, 7, 8th line, my lord. He has invited the attention of this court to various documents produced by the respondent along with his objections. These documents are few photographs of Maharshi School and the staff of the said school
Where are
along
you
with the
reading?
Lord, at page number 87, paragraph 10, my lord.
Yes.
8th line. He has invited the attention of this court to various documents produced by the respondent along with his objections. These documents are few photographs of Maharshi School and the staff of the said school along with the list of teachers working in the said school, which also shows the name of the present applicant at serial number 34. She is working, my lord. Even have a huge depth.
Read.
Again, of the applicant at serial number 34 of the said list along with the photograph. By pointing out these documents, it is vehemently argued that the applicant is still continuing the job said as teacher. It is relevant to note that though the respondent has produced this document, it has not been substantiated as to in which year this photograph are taken, nor he has placed before this court as any cognate material by summoning the said
Then
school
what,
authorities.
what is the response? What is the vice response to this?
No, my lord, we are procuring the documents in the school where the suit has been.
I'm asking in this, when you've taken such a plea, what is the case of the wife? Whether she's working or not working?
Actually, she is working, but she has fabricated in the affidavit stating that she is not working.
So according to her, she is not working.
She is not
And the
working.
photographs which you have filed, they pertain to which year? That the
No. She is working still now. That's what I even as I said yesterday before this court, we will procure the document, we will submit it.
Submit it, we'll see. 5,000 is not a big amount that you
No,
can't.
my lord, we are paying child. We are ready.
No, granting of 3,000 to the child is itself is on the How can the child be taken care of with 3,000 rupees?
No, I will take off the school fees and everything. I'll take care of the
Well,
child.
see,
My lord, the
5,000
thing
rupees.
is, I have under a huge debt due to my pre-EMIs and other things. I'm unable to pay. I'm just asking this honorable court to reduce it for 3,000. I'm ready to pay 3,000. I'm not completely denying the maintenance. In total, I'm ready to pay around 6,000. Maybe let them appear before this court and let them file their affidavit.
Let them appear, we consider her case. Yes, notice the respondent. No
My lord,
information.
maintenance amount may be reduced, my lord.
5,000, what is that to be reduced?
At least, at 70, at page number 70, my affidavit may kindly be
I've seen
seen.
that, I've seen that.
There are so many
Court
huge
has-
loans occur,
court
even
has,
my,
Court has rightly considered. Yes. Notice to the respondent. Petition is permitted to take out hand summons on the counsel to the respondent. We shall file a memo to that effect. If counsel memo is filed, this is the matter.
until then, interim stay.
Yes.
Okay.
I appeal for petitioner in this case.
Respondent.
But all the office objections are removed. Now, my lord, this is a clear case of fraud played by the bank. Therefore, we are before this honorable court. Now, my lord, I will demonstrate before your lordship how the fraud have been played by the bank.
First of all, questioning what is the order impugned?
My lord, we have called in question the sales certificate issued by the bank. My lord, in an auction held under section of under the Surfaces Act.
Who are you?
My lord, I am the purchaser of the property even before the auction could be conducted in the year 2022. That's what I wanted to demonstrate how fraud had been played.
When did you purchase the property?
My lord, in the year 2020. My lord, here there are two sets of parties. Petitioner number 1 and 2. 1 and 2 are the borrowers. Petitioner number 3 and 4 are purchasers of the property.
All of you are together.
All 4 are together here.
Here.
Now, my lord, one minute, sir.
So,
Allow me to talk.
when did you
My lord,
purchase the
I have purchased, petitioner number 3 purchased on 7/2/2021. And petitioner number 4 purchased on 22/22/2022.
No.
22 February 2022.
Same property.
No, different property. Flats. These are all the flats.
So, one flat is purchased by 3 on 7/2/2021.
Yes.
4 on
22/2022.
then
Both the sale deeds have produced as annexures to the writ
Then after
petitions,
that?
my lord. Now, my lord, before purchasing the property, in that
was the mortgage.
My lord, mortgage was done much prior to that, my lord. Annexure A is the deposit of 2018.
What is the date?
2018 mortgage deposit of mortgage title deed I have produced before your lordships, which is at
So,
annexure
then
A.
how this property is again sold?
My lord, it is a, my lord, it was a open land when it was mortgaged. Thereafter, one nimsha, sir. My lord, my friend will, last time also I did the same thing. My lord, annex schedule A, your lordship may kindly come to page number 45, where the property what was mortgaged is mentioned in annexure A. That was the first mortgage when petitioner number 1 and 2 borrowed a loan of rupees 1 crore 80 lakhs. That was the first document. Your lordship may next come to document number.
Constructed the flats in that?
My lord,
Who constructed the flats in that?
my lord, thereafter developer and the in a joint development agreement, the property was converted into apartments. Now, my lord, before taking the apartments, my lord, your lordship may kindly see to certain flats. My lord, even before these proceedings, there was one more surface proceedings where the due was 4 crore 87 lakhs. At that point of time, all the stakeholders, that is who wanted to purchase the property, all of us have approached. They have given NOC to 9 flats. We have, all of them have deposited 45 lakhs, depending on the square feet area. We have also deposited 30 lakhs and 32 lakhs. That is petitioner number 3 and 4 have also deposited 30 lakhs and 32 lakhs. But they have not given NOC to us. My lord, the NOCs, your lordship may kindly find at page number 153, 154, 155 and 156. I'll take your lordships to that portion. 153, my lord, your lordship, annexure K. My lord, this is to, my lord, I'll take it in the second paragraph in this.
What are you doing till the sale certificate is issued?
My lord, we have made 100, my lord, emails, the office objections was.
What about the email of the emails? What were you doing without approaching any forum?
My lord, it was, my lord, immediately after
Was the sale certificate issued?
19, one nimisha. 19/2, my lord, this was issued 19/5/2025. And we have approached the DRT also, even before the issuance of the sale certificate, because sale certificate was not made available to us.
What did the DRT say?
My lord, DRT case is pending, no interim order was passed.
Then how can you file a writ petition here?
My lord, after sale certificate, my lord, my lord, there we didn't got any benefit of interim order. Now, why we have approached this honorable court is to demonstrate the fraud. Why, my lord, allow me to convince your lordship. In another 5 minutes, I'll convince your lordship. I'm sure of it. The reasons is, one, it was once when it was 4 crore 87 lakhs, 4 crore 67 lakhs was paid under by the different purchasers, including the petitioners number 3 and 4. The balance was 20 lakhs only. Thereafter, it was the burden of the borrower who has failed. Forget that he has not paid the amount.
How that amount, all the flat owner purchasers, what is the amount that is direct, that everyone has to pay?
Well, for my share, for petitioners number 3,
Each flat is not of the same extent.
it's not of the same extent. So
As per your
pro
extent, how
rata, I was supposed to pay 30 lakhs and petitioner number 4 was supposed to pay 32 lakhs.
How much you have paid?
We have paid the entire thing. But the bank have not issued NOC. For depositing, my lord, your lordship may kindly come to annexure L1, page number 157. This is my accounts extract, which was gone to the account of the housing loan account of the petitioner number 1 and 2.
Is it correct that all the flat owners have paid, this is the one you have demanded from him, 30 and 32?
All apartments are measuring 2,000 square feet of superlative area. Every apartment owner, we have not given NOC. The respondent, the petitioner number 1 and 2 came with to whom he had sold property with his post mortgage. Those had approached the Honorable High Court. High Court said you go to DRT. Instead of those 9 persons to whom NOC is issued, they went to, along with the petitioner number 1 and petitioner number 2, they went to bank. They paid money to petitioner number 1 and 2 on their, it was accepted and NOC was issued to petitioner number 1 and 2.
By whom?
By the bank.
For what?
Releasing that property. 9 apartments were released.
That forms part of this?
No.
Our apartment.
Because the borrower has not recommended that is petitioner number 1 and 2, 45 each, they have not paid. And the dues were mounting. And now he says the other issue is petitioner number 1, petitioner number 2 have filed.
May I still interfere? May I interfere? One more minute.
Only for me to understand, I will again hear you. Yes.
Petitioner number 1 and 2, they have filed SA. It is pending adjudication, that is not disclosed here.
What is the SA for?
SA for challenging the same sale certificate.
1 and 2.
Yes. And then they mention only with regard to the petition number 3 and 4 have challenged SA. They are silent. The petitioner number 1 and 2 have filed one SA. Petitioner number 3 has filed SA, wherein petitioner number 1 and 2 are the respondents.
That's also in the
pending.
sale certificate.
The same prayer. Identical prayer.
Identical prayer. And petitioner number 4 has also challenged, wherein petitioner number 1 and petitioner number 2 are the respondents. Here, all the 3 have joined and they have filed it here. Learned counsel was the counsel for the petitioner number 1 and 2 before the DRT. He has suppressed that it is submitted that petitioner number 1 has not filed any other writ petition or any other petition before any court of law, the same cause of action. Suppression.
Yes.
And then, let me have 1 minute.
Let me answer that question.
I'll take only 1 minute. Afterwards, you can hear him, then I'll give. The same petitioner, to whom 9 apartments were in NOCs were received.
Total or 11 in number?
There are 12 apartments plus 1 penthouse. Same thing it did penthouse when we took invoke section 14, took the possession. The penthouse fellow filed Azam filed an essay that was dismissed with regard to that penthouse. Matter is pending before DR80. 9 applicants whom they are referring NOC is issued. Possession was not delivered because we are duty bound to deliver the possession to the respondent, petition number 192. They filed an SA before DRT. DRT directed me to hand over the possession. 9 apartment holders was paid 45 lakhs each, to whom NOCs were issued. We complied the orders, we have delivered the possession.
Why the owner has not asked for this 2 apartments?
He has not come. Even we have given OTS is not. My lord, he is suppressing other fact is, we sold 3 apartments. Out of which, the balance amount was deposited in petition number 1's account and petition number 2's account. Petition number 2 has withdrawn 60 lakhs also.
Oh, after the sale, the
They have
remaining
withdrawn.
amount already.
Withdrawn.
Yes. They suppress everything. I'll tell you the details, my lord. What has happened is, sale proceeds, the balance is deposited 88 lakhs 3,431 in the account of petition number 1. Again 88 lakhs 3,431 and 37 paise in the petition number 2's account. The petition number 2, now the available balance in her account is 18 lakhs 21,351, 71 paisa. He says only 20 lakhs is due. It is not 20 lakhs due. What was due from past 3 years, they have vanished after taking NOCs for 9 apartments. The security charge itself is per month, it was 1.5 lakh. We have maintained the apartments. The total due that is approved, what we recovered from the sale is, the appropriation is, e-action amount is 3 crores 27 lakhs 29,400. Appropriated amount is 1 crore 51 lakhs 22,537.28.
Remaining amount you deposited.
Deposited, out of it 60 lakhs is withdrawn.
Yes.
And again, and here, my lord, the petitioner number 192 has filed SA bracket diary number 1635 of 25.
1 and 2.
Petitioner number 192 have filed SA bracket diary number 1635 of 25. It is pending adjudication before DRT1 Bangalore, which is suppressed in the writ petition.
Next.
And petitioner number 3 has filed SA number 277 of 25, challenging the issuance of sale notice, sale certificate, that is also pending adjudication. Then petitioner number 4, Arif Pasha, has filed SA number 278 of 25. When the matter comes up before DRT, they say matter is pending in High Court.
When is it filed?
Prior to writ petition, my lord. All these 3 petitions are prior to writ petition.
Well, at page number 22, your lordship may kindly come to paragraph number 34.
Page number?
34 paragraph, page number 22, paragraph number 34. However, my lord, writ petitions are, however, the petitioners have filed application under section 17(1) of the SURFACE Act along with condonation of delay application before DRT1 Bangalore, and the cases are reserved for orders on IA number 1 of 2025 for condonation of delay.
Petition number
There
3
is
and
one-
4, not 1 and 2.
My lord, my friend.
Petitioner number 2 and 3 and 4.
We have
not 1 and
scratched
2.
it and made it as petitioners thereafter.
When did you scratch it?
My lord, before filing, my lord, if there is any mistake, it must pay by, it's all the petitioners, my lord. It was only first petition.
Submitted that the petition number 1 has not filed any other petition. Petition number 1 and 2 have filed SA number 635 of 160.
My lord, this petitioner number 3 and 4 filed before the writ petition. Petitioner number 1 and 2 after the writ petition they have filed. Petitioner number 1 and 2 have filed it after filing of this writ petition. Petitioner number 3 and 4 before filing.
Will you know when once the sale certificate is questioned before the DRT?
My lord, why we have filed before
Because
this?
you don't get interim order.
My lord,
that
why,
cannot be a ground.
my lord, but there was a delay. Therefore, we have approached this honorable court on the ground of delay. Now, my lord, your lordship, my lord, my friend has given all those facts. He has not given what the bank has done. I'll bring to your lordship's kind concern what the bank have done. Now your lordship may kindly see, my lord, we have paid the amount that is not in dispute. They have taken the money from us. They did.
Pay the money.
My lord, we have paid on 3/4/2023, 12 lakhs, 32 lakhs have been paid. by Arif Pasha, that is fourth respondent, fourth petitioner, sorry. My lord, on 6/12/2023, this third petitioner have paid 30 lakhs by way of a check.
You are supposed to pay 45 lakhs.
My lord, because our area was small, we paid 30 to 32 lakhs. That was the an understanding between the owner and ourselves. So as per his instructions, we have paid the amount to the bank. Now, my lord, coming to the facts, now your lordship may kindly come to the auction notice, which is at annexure page now 165. Your lordship may kindly come to 165. Now, my lord, here the proposed properties are description of mortgage asset and reserve price. My lord, page number 165.
This is dated.
My lord, this is dated 2/4/2025. My lord, as per this, my lord, the arrears, my lord, whereas total amount due, I am reading in the e-auction sale notice, second paragraph, whereas total amount due and outstanding on 31/3/25 in respect of the above notices is 1,23,42,631. So this was the total due amount as per the notice. Now your lordship may kindly come to the properties mentioned therein. Description of the mortgage asset with reserve price. There was no necessity to auction the whole property at all. Flat number 302. Reserve price is 1.1430 crores. Flat number 402. 1.4430 crores. Flat number 501. Fifth property 1.02 crores. The balance is one.
All this doesn't belong to one borrower.
It is only one petitioner number 1 and 2, both. That's all. It was belonging to their accounts. And my lord, these three properties, out of this, my lord, we are interested only in 302 and 402. Now, which is not it is wrongly mentioned as 402 eastern side. It should be 401 eastern side. It is a wrong description here, but however, they are coming to my property. Now, my lord, the reserve price itself shows, my lord, total due amount was 1,23 lakhs. What was the necessity to mortgage all the three properties, my lord? Substantial amount would have been recovered by them by mortgaging only one property. At the best, he could have called upon to pay another 20 lakhs to the other purchasers who are known to them also. The malified intention is auctioning of the entire property here. Now, my lord, your lordship may kindly come to the auction confirmation note letter. Your lordship may
Either third respondent's property or fourth respondent's property.
My lord, third property is there.
No.
Third property we have not called in question. Even to this day, we have not.
Any of your property, either of one property according to you, can be auctioned. So all of you cannot have one cause of action.
My lord, one property, my lord, they could have auctioned the third property 1.02 crores. Another 20 lakhs, they could have given, my lord. Even the auction is also bad in law.
You cannot dictate the bank which to be sold. It's for them to do. So
any one property.
No, please tell the court now which petitioner will not seek any relief with your submissions. Either any of one petitioner, either 3 or 4, cannot question this. Who is agreeable for this?
My lord, before going to that point,
no, we will complete this.
My lord, one.
Said, no,
my lord,
first
I can understand the mind of the court, my lord, but allow me to make one more submission. After that, my lord, I will have to consult my client and I make submission so far as that aspect is concerned.
No, the sale is gone. Sale certificate is.
My lord, sale certificate is also bad in law. Why? Because, my lord, your lordship may kindly see the sale certificate.
That will be decided by the DRT.
My lord, there is a delay. But we didn't got the stay. Now they will come for possession. We are in possession of the property.
Possession delivered to me.
See, lawfully, my lord, he may have a constructive possession. Physical possession, he still remains with me. I am residing there with my family. I am residing there with my family. Now your lordship may kindly come to the sale certificate for a while, my lord. For a while, your lordship may kindly come to sale certificate for annexure R1. 1 minute, bear with me for 1 more minute, my lord. I will not take much of your lordship's time now. Now, my lord, the undersigned acknowledge the receipt of the rupees 1,14,30,000 only. That they have auctioned the property only for the reserve price. Not even one bid have been raised. Now, my lord, in case of auction by the only on the reserve price, Rule 9 applies. Your lordship may kindly come to Rule 9. My lord, here. Read. My lord, Rule 9. No sale of immovable property under these rules in the shall take place so and so. provided further that if sale of immovable property by any one of the methods specified by sub rule 5 of rule 8 fails and sale is required to again, the authorized officer shall serve affix published notice of sale so and so. That, my lord, I'll relieve all those things, provided that if the authorized officer fails to obtain a price higher than the reserve price, he may, with the consent of the borrower and secured creditor, effect the sale at such price. My lord, here, the property what is auctioned is only for the reserve price.
As a bank is concerned, when according to you,
wait,
the
page 10.
outstanding, 1 minute, outstanding is 1,23,42,000. And according to you, the price for flat number 302 is 1 crore, what is that?
1,14,30,000 rupees.
For that, why 3 properties are auctioned?
My lord, I can't pick and choose. How if I choose this, the other will come. Because for one property has made.
No, it is not others. Before you are only the borrower.
No, my lord, here the issue is, come to this one, my lord. See how much we have, the way they have harassed us. The NOC.
One judgment in this regard, what you will.
I will not entertain any of this, Mr. Counsel, because you have to go
Before that, my lord.
all these disputed questions with regard to possession and all, I cannot decide here.
My lord,
Having
page
availed the
110.
remedy.
My lord,
Yes.
Well,
page
till
110.
then,
My lord, page 110.
Yes.
They say they are in physical possession, clearing false submission, how they are making. Page 110, my lord.
Yes.
Schedule C, residential apartment number 3, eastern portion, third floor, having super built up for area of 2,000. There is no less for every apartment 2,000. Super belong with car parking, still floor, to be constructed on Schedule A property. What is sold is air to them. That time even structure was not put. There are for 12 apartments and 1 penthouse, there are 50 transactions in the encumbrance. The same petitioners number 3 has taken the property, which is post Abdul Ghaffar, who had approached the High Court and subsequently has come and he filed a SA. SA was allowed, and in terms of SA, we have delivered the possession. For each apartment, this petitioner number 1 and 2, there are several transactions. That is the reason why we put the security guards and we hold the property. When there was an order from DRT in SA 480 of 25 on 17/10/2025, within 1 week there was a direction, we delivered them to physical possession.
May I make one more
Property
submission?
was in the possession. An apartment to be constructed was sold, and making allegation that we are in physical possession. After sale, I have given the possession.
May I make one more submission, my lord? My lord, 1.02 crores, which we have not called in question before this honorable court. Let them take 1.02 crores. I am ready to deposit the balance of another balance amount. I am ready to deposit before this honorable court within 3 days.
What is the power of this court when the auction sale certificate is issued? So they can't even redeem the mortgage.
My lord, sale certificate patently illegal, my lord, which I am demonstrating. Patently illegal. It is patently illegal. The reason is
This court will not
Rule 9.5 is violated. Rule 9.5 is violated, my lord.
The present petition is filed.
Page
Taking
147.
the following prayers. Page 24 of the prayers. The petitions before this court are 4 in number. 1 and 2
Are the borrowers.
The borrowers who have mortgaged the scheduled property to the bank and obtained the loan in the year
2018 and 2019.
in the year
My
2018.
lord, may I seek your lordship's leave to withdraw the petition and their direction to the DRT to dispose of my SAS within a time frame, my lord. Because we are in physical possession, they may come for this thing. Within a time frame,
Physical possession, that cannot be.
within
I
2
will
months.
not record, Mr. Counsel. Please listen to the court. What is the difficulty if such a direction
I
is
will be
granted?
very happy, my lord. In 8 weeks, let the we direct it, we will file it.
I
and
may be
we'll
permitted to withdraw with, my lord, with a direction for the DRT to.
The matter came up before this court for hearing. Then counsel appearing with the respondent submits that already the petitioners have filed
3
Yes, 3 SAS before the DRT.
case. What are the numbers?
A numbered, my lord.
275,
No, no.
277
SA
of
diary
20.
number 1635 of 25
Say 277 of 25.
and SA 278 of 25.
And SA diary number
1635 of 25.
5 of 25 before the DRT. And and as such, this present writ petition is not maintainable. Land counsel appearing for the petitioner submits that he may permit it to withdraw this petition, and there may be a direction to the DRT to consider the pending applications in a time-bound manner. It is submitted that he is in possession of the property. If the appeals are not, if the essay is not disposed of, it would cause a lot of hardship to the petitioner. Land counsel appearing for the respondent as well as the auction purchaser submits that the petitioner is not in possession of the property. Next para. Who is in possession of the property, this court is not going to do any exercise.
Let's
Here.
kindly see the order sheet, Lords. In the order sheet itself, Lords, it is recorded in the order sheet that auction purchaser is in possession. Kindly see the order sheet, Lords.
Before this court.
Yes, Lords.
That is your contention.
No, it is recorded that my possession is delivered by bank to me.
No, that is bank's contention.
That is bank's contention.
What is that? Who is in possession of the property? According to the bank, they have delivered the possession to the auction purchaser. According to the writ petition, he is in possession of the property. In these circumstances, it would be in the interest of both the parties if the pending essay is disposed of expeditiously. In that view of the matter, the writ petition is dismissed as withdrawn with the liberty withdrawn, and the DRT is directed to dispose of the pending essays within a period of 2 months from the date of receipt of the copy of the order.
Much.
No representation. Is this matter in the month of December? What you called is 12 now? What? 11.
For the petitioner, Lords.
Oh, respondent number 1.
Lords, I am a tenant, Lords. Lords, lease is executed in my firm, Lords, registered lease prior to mortgage, Lords. Therefore, Lords, my possession, they have issued Lords 13-4 notice, Lords, against my lessor. Lords, my possession has to be protected, Lords. Let them, Lords, work out their remedy with the borrower. Lords, so long as, Lords, my possession is concerned, Lords, since I am a registered tenant.
Lease is with regard to the mortgages by deposit of the title deeds.
Title deeds. I am in possession.
Who is the owner of the property?
Lords, owner is the borrower, Lords. He is respondent number 2 before this court.
No.
Lords.
By virtue of these proceedings, when
Yes.
when he fails to pay the amount, they will initiate the proceedings and they will sell the property.
Lords, let them sell.
Why
Lords.
can't they sell?
Lords, let them sell, Lords. But my possession, Lords, they cannot dispose of me, Lords, and my possession is protected. Lords, kindly see the judgment of the Honorable Supreme Court, Lords, latest judgment, Lords.
Then there is no question of conducting the sale.
Lords.
What will they, why they will conduct the sale and keep quiet without giving possession?
Lords, my possession is sealed, Lords. Lords, unless, Lords, they initiate proceedings under, Lords, under the TP Act, Transfer of Property Act, Lords, to evict me, Lords, in accordance with law, Lords. They cannot, Lords, throw me out, Lords.
Let's see. Yes.
Lords, kindly turn to, Lords, the ratio laid down, page number 24, Lords. Lords, page number 23, para 22. We may now consider the nature of the right of the lessee and as to when the lease under the Transfer of Property Act gets determined. Section 105 and 111 of TP Act, which are relevant in this regard, are quoted here in below. Lease defined. A lease of immovable property.
Where are you reading?
Lords, page 23, Lords. Para 22. May I read, Lords? We may now consider the nature of the right of the lessee and as to when the lease under the Transfer of Property Act gets determined. Section 105 and 111 of the TP Act, which are relevant in this regard, are quoted here below.
All are not required. Please come to the.
Lords, now, Lords, come to them, Lords, the relevant portion, Lords.
Then to section 14 of the Such as act is extracted. 10.
Let's kindly come to
Fine.
page number 34, my lords.
Hmm.
Page number 32.
Paragraph number 34.
34. We have perused the aforesaid decisions of this court in so and so, so and so. We find that in that case, the question whether secured creditor in exercise of his right under section 13 of the Surface Act can take over the possession of the secured asset in possession of the lessee under a valid lease was not considered, nor was the question whether there is anything in this Surface Act inconsistent with the right of the lessee to remain in possession of the secured asset under the Transfer of Property Act considered. In our view, therefore, the High Court has not properly appreciated the judgment of the court in so and so and has lost sight of the opening words of the subsection 13 of the Surface Act, which state that notwithstanding anything contained in section 69 and 69A of the Transfer of Property Act, any security interest created in favor of the secured creditor may be enforced without the intervention of the court or the tribunal by such creditor in accordance with the provisions of the Act. The High Court has failed to appreciate that the provisions of section 13 of the Surface Act does override the provisions of 69, 69A of the TP Act, but does not override the provisions of the Transfer of Property Act relating to the rights of the lessee under a lease created before the receipt of the notice under section 13(2) of the Surface Act by the borrower. Hence, the view taken by the Bombay High Court in the impugned judgment as well as the trade well, so far as the rights of the lessee in possession of the secured assets under a valid lease may be the mortgagor prior to the creation of the mortgage or after the creation of the mortgage in accordance with section 65 of the TP Act, is not connected with the impugned judgment of the High Court insofar as it takes the view of is set aside. A further question of law raised in this appeal is whether tenants have remedies under the tenancy law concerned in the state of so and so, so and so, so and so. Education basis, let's kindly come to the last para. Reading of the second limb of section 32 of the Surface Act would show that no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred or under the Act. Thus, when action is sought to be taken by the secured creditor under section 13 of the Surface Act by the Chief Metropolitan Magistrate or the District Magistrate under section 14 of the Surface Act, the court or the authority mentioned in section 33 of the Maharashtra Rent Control Act cannot grant the injunction to prevent such action by the secured creditor or by the Chief Metropolitan Magistrate or the District Magistrate, even otherwise section 33 of the Maharashtra Rent Control Act West jurisdiction in the courts named Devil to decide dispute between the landlord and tenant and not dispute between the secured creditor and the tenant under the landlord who is borrower of the secured assets. We may now consider the context of the respondent that some of the appellants have not produced any document to prove that they are not bona fide lessees of the secured assets. We find that in cases before us, the appellants have relied on the written instrument or rent receipt issued by the landlord to the tenants. Section 107 of the TP Act provides that a lease of immovable property for year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by registered instrument, and all other lease of immovable property may be made either by registered instrument or by oral agreement accompanied by delivery of possession. Hence, in any of the appellants claim that they are entitled to possession of secured asset for any term exceeding 1 year from the date of the lease made in his favor, he has to provide proof of the execution of the registered instrument in his favor by the lessor. Where he does not produce proof of execution of the registered instrument in his favor and instead relies on an unregistered instrument or oral agreement accompanied by delivery of possession, the Chief Metropolitan Magistrate or District Magistrate, as the case may be, will have to come to the conclusion that he is not entitled to possession of the secured asset for more than a year from the date of the instrument or for the date of delivery of possession in his favor by the landlord. But mine is not registered document, my lord. But kindly see my registered lease deed.
Read further.
I will read it. Having expressed our opinion on the different question of law raised in these appeals, we may now pass orders or directions considering the broad facts of the three different categories of the cases before. In criminal
no, if you look at 37.1,
lots.
It is observed that the orders passed for the Chief Metropolitan Magistrate, Mumbai are set aside.
And matters submitted to the Chief Metropolitan Magistrate to pass fresh orders in accordance with this judgment and any other law that may be relevant after giving an opportunity of hearing to the appellants and the secured.
No, what is, as per this judgment, what is the course that is laid down by the apex court? Where is that?
My possession, once my lease is registered, my possession has to be protected, my lord. And my lease is, my lord, prior to the mortgage.
No, if that is the case,
Lord.
There is nothing to be considered by the magistrate. Court already records if the court records.
No, Lord, that still it is a premature stage. I am challenging 13 form, Lord. Lord, if Lord, the bank approaches.
I'm not asking you to go before the magistrate.
Yes, Lord.
And from this judgment, the apex court, when once Once the
Registered instrument of-
ratio is laid down, saying that your position
Was
has to be
protected.
protected, what is the purpose of again going to the magistrate? That I'm not able to understand. The code says about the procedure that is laid down. Where is the procedure that is laid down? You
Lots-
read it,
lots-
you read that paragraph.
I will read, Lords. Lords, para 37(1), Lords.
37(1), the appellants claim that
Yes, Lords, I will.
after
The
the
appellants
numbers.
claim that they are in possession of the secured assets under a lease made prior to the mortgage. But the Chief Metropolitan Magistrate, Mumbai, has passed orders under Section 14 of the Surface Act for delivery of possession of the secured asset to the respective secured creditors. These orders passed by the Chief Metropolitan Magistrate are.
So pausing here, it is set aside.
Yes, my Lord.
Now, court gives a finding that you are all the registered leaseholders.
Leaseholders.
Then read thereafter.
These orders are passed by Chief Metropolitan Magistrate, Mumbai, are set aside, and the matters are remitted to the Chief Metropolitan Magistrate to pass fresh orders in accordance with this judgment and any other law that may be relevant after giving an opportunity of hearing to the appellants and the secured creditors. In the criminal appeal, so and so, so and
No,
so.
those are all not relevant.
Lords.
Hmm.
Lords, this is under Section 14, Lords. This is under Section 14. Lords, if they approach, Lords, the bank approach.
Even if the matter is remanded back to the magistrate, he cannot do anything.
No, remand, Lords, I'm not for the remand, Lords.
I am talking about this judgment.
This judgment, yes, Lord. Lord, Lords,
No,
the
it
lessee
says-
has to go and Lords, produce them, Lords, registered lease before the Chief Metropolitan Magistrate. I'm not saying, Lord, their possession is sealed unless they have been, Lords, disposed by taking due process of law.
My lords, we are still yet to receive notice and file that wakalat for, we undertake to file wakalat for
What
respondent.
are you doing from the
We-
last 10 minutes?
No, Swami, we have issued we got the summons for morning itself. We got to know that the case is listed. So we'll file wakalat by today afternoon. So wakalat is already gone, Swami.
Land counsel for the petitioner submits that he's in respect of the property, a registered sale deed is executed in favor of the petitioner, and thereafter
And there's one
the
more
property
submission.
is I have given enough chance to you. Thereafter, the property is mortgaged to the bank. It is submitted that in the light of the law laid down by the Apex Court. In Harshad Govardhan Sundagar versus International Assets Reconstruction Company Limited and others, reported in 2014, 6 Supreme Court cases. The possession, the registered leaseholder cannot be dispossessed from the property. This court, when the matter came up for order sheet, when this matter came up before the court on 25/10/2025, this court had directed Srimati Sridevi to take notice on behalf of the bank. The matter,
My lords, Sridevi was not a panel advocate. We are different. Satish, we are panel advocates. That day
on
we are.
29/10/2025, it is submitted that Mr. Sridevi is not in panel. What is your name?
Satish V.
Satish V is a advocate for the respondent. Then papers are served on you.
No, no.
Then counsel the petitioner serve the copy on the land counsel appearing for the respondent. This is matter on 25th of November. By the time the respondent shall file objections, if any, till such time there shall not be any coercive steps.
My lord, we'll file the objections. Stay cannot be granted in this. They are no longer connected to the sufficient
We'll
proceedings. my
see.
lord.
Yes.
Lords, I am handing over the petition copy, Lords. It will be recorded.
The petitioner has served the copy of the writ petition to the counsel for the respondent. Yes.
Double Lords.
My lord,
Petitioners
I
in this
take
case.
notice for respondent, my lords. A very short consideration is that, my lords, the property which is auctioned and sale certificate is issued has been undervalued. My lord, may kindly see page number, annexure D at
Can be
page.
decided by the DRT. Go before the
My lords,
DRT.
I have approached the DRT. DRT has dismissed my essay on a technical ground that I have only challenged the sale certificate and not the sale notice or sale proceedings.
Then we don't done it.
Lots.
Then you should have done it. Should have gone before the DRAT, say that whatever.
But
such
short
a-
point,
such-
and the same identical matter is also pending before your lordship for consideration, which is going to be listed on 5th of November, my lords. It may be connected together and heard along.
5th of November.
Please, my lord.
This is matter, give the number along with so and so.
Please.
On 5th of November, what is the name?
Suresh V.
Suresh V. Suresh V is directed to take notice, or your file wakalat?
No, my lords.
Is directed to take notice, papers are served,
No, my.
then counsel the petitioners has served the copy of the petition on the council. This is matter along with so and so on 5th. Is 14. In this side, number 1/25 is filed seeking dispensation of protection of the certified copy of the nature.
Copy, sir.
Dispense with for the present. Next two also. I number 2. Next 14.
For the petition, my lords.
For respondent, my lords. I'll take notice in this.
Lords.
Any urgency in this?
My lords,
on
the
that.
scheduled
What is
property is the
challenge?
residential.
What is challenge?
My lords, 13 class 2. My lord.
Hmm?
Challenge the notice on that section. 13 class 2. My lord.
13?
13 class 2.
13 to notice this question.
Yes, ma'am.
When was the notice issued?
Notice issued on my lords 29/6/2021, my lords.
That is question now.
Now, my lords, after filing this petition, my lords, on 23/10/2025, they issued a possession notice, my lord.
No, the so-and-so the same advocate Suresh so-and-so takes notice. Is directed to take notice on behalf of the respondent bank, shall file his objections. List this matter on 19th of November.
Appear for petition, short pass or your lordship. Sin is engaged in portal number 19. Your lordship.
For respond number 2 and 3, in fact.
Short pass or your lordship. Sin is engaged in portal 19. Your lordship.
In the meantime, could I just request my lordship kindly see the order sheet. The lordships have directed the respondent number 2 and 3 to secure certain instructions as to how this loan came to be assigned. We've secured those instructions. But if I could just make submissions in that regard. Kindly see the order dated 28th of October.
With regard to assignment of the.
Right.
Or
Just
what
to
is the
refresh your
price?
lordship's memory, of course, I was not there, my instructing
What
counsel.
is the
tells-
amount fetched in the auction, other relevant details?
Okay, so I think what was submitted in the petition also by the petitioner is that the loan was assigned for a meager sum of just 55 lakhs by the respondent number 1 to the respondent number 2 and 3, whereas they had already paid a sum of about 95 lakhs, and therefore this assignment of loan at a throwaway price would prejudicially affect their rights. But my response to that actually is that the submission is flawed on one account. The assignment, my lords, was not of only this loan. I've seen the assignment date. If your lordships pleases, I can place it on record. Of course, it's a confidential document, so I wouldn't like to share it with the petitioner, but your lordships can have a look at it. 168 loans were assigned by respondent number 1 to respondent number 2 and 3 together, without any particular sum being assigned to any one loan. So 168 loans were assigned for a total sum of around 33 crores, my lords. 33.68 crores. So the assignment deed also lists all 168 loans.
The other day when he also accepted that it is for 50.
I'll explain that. I'll come to that, Malas. Now, the annexure that the petitioner places reliance upon is the loan statement maintained by respondent number 1. Now, Lords, in their loan statement or a statement of account, they have mentioned 55 lakhs. Lords, now I can make it absolutely clear, Lords, but as far as respondent number 1 is concerned, it is completely their prerogative. As per their accounting principles, they can assign whatever amount to whatever loan. Of course, they have received 33 crores from me, 33.68 crores. Those loans are assigned. Now, my lords, how much to assign to each loan is a pure accounting principle. And the assignment deed, my lords, I can place it on record, does not specify any amount for a particular loan. Now, what generally happens in these cases is this, my lords. There will be, as in this case, 168 loans. The respondent number 1, for purely commercial reasons, will feel that I don't want to take the burden of these loans upon me right now. These are all non-performing assets. Inevitably, they will lead to litigation. Costs will increase, point number 1. Litigation costs. 2, there's something called time value of money. So 1 rupee in my hand today is worth more than probably 2 rupees in my hand tomorrow.
When it comes to one-time settlement from the bank,
correct, ma'am.
They will never come with these kind of proposals for an outstanding of for a property which is worth 1.5 crores.
Correct.
No. Which is assigned the debt for.
True,
50
but possibly, I quite see. In fact, I completely appreciate what your lordship is saying. Why possibly I can only second guess why the bank would do that. As in this case, my lords, these will not
be as well given to them when they want to give it for a throwaway price of 50 lakhs, the same could have given to them because it makes substantial difference. They would have paid the amount. No, the
Correct.
same approach, what they're doing it.
I understand what you're like.
For
But
once
then
they give it the
your lordship may
proposal.
also see the contrary view is possibly the bank, if respondent number one had offered us only this loan for 55 lakhs, we may not have taken it upon ourselves. We'd say, this is not worth my time. This is not worth my money to pay 55 lakhs. But since you're offering me
Definitely it's worth
160.
your time to pay 50 lakhs.
Yes.
The property that offset price itself is 1.5 crore.
Correct, Manoj. Now, what I'm saying is if the petitioner comes forward, let us say of course, I can't speak for Piramal, but let us say they had come forward to Piramal and said, I'm willing to pay 55 lakhs. They may not have taken it upon themselves at all because they said this 55 lakhs is really not worth it. It's just a single loan. But now here is somebody who's willing to pay me 33.68 crores. Therefore, I'll assign it my entire loans. So all I'm trying to say, Malaj, is these are purely commercially driven decisions. Standalone, Malaj, possibly it is not.
No, there must be some norms for assignment of a particular
To the
loan.
best of my knowledge, RBI does not prescribe any price at which loans can be assigned. These are purely within the
If they
contractual
ask
realm.
them, if we say whether there is any proposal for the one-time settlement, for
Correct.
that RBI guidelines, first time the auction has to be conducted when it is not fructified. Second time, there are so many clauses
Correct,
for
that's correct.
one-time settlement
Yes.
also. But for a asset reconstruction company, somebody's property, just like the assigning it and selling it for a price more than
Of course, ma'am, I'm not saying.
something
One
is lacking
humble
somewhere.
submission,
Huh?
one humble submission from respondent number one. We have already offered a one-time settlement for the petitioner, my lord, that is for 1 crore 82 lakhs. In that, they have paid 95 lakhs 50,000, my lords, and they have didn't paid the remaining amount which they have agreed to pay.
How much they have paid?
95 lakhs 50,000, my lords.
You offered for 1 crore?
1 crore 82 lakhs, which they have agreed to pay for one-time settlement, for which they have not paid.
And for how much you have assigned it to the
My lords, that I am not aware. Today we have filed wakalat. I see. My lords may kindly post the matter for tomorrow. My regular counsel is engaged in.
The assignment deed
Please
is.
pass on.
The assignment deed is.
Copy me, please.
No, can't give. Malaj, may kindly see the assignment deed right on, this will be page number, it says, between the, my lord, may kindly see the parties, Piramal Enterprise and Asset Care. Then at page number, where is the, page number 6, my lord. Clause M, purchase consideration means an amount of 33 crores, 68 lakhs, 28,000.
Page number 6.
Page number 6. My lords will find that page numbering at the bottom right-hand corner. Clause M, purchase consideration means an amount of 33 crores, 68 lakhs, 28,000. Being the aggregate purchase consideration for the loans. Now, my lords will find in the schedule the number of loans that will start just immediately after page 26. These are all the loans that have been assigned. My lords will find this particular loan at serial number 124. My lords has that. It says so-and-so customer ID, borrower name is the petitioner, PAN number and so on, disbursement date, disbursement amount. My lord, the serial number 124.
This person stands at
124, my lord. Serial number 124. It's right at the top of the second last page. No, I'm sorry, not second last page. This will be about 4 or 5 pages from the end, my lords. But it's right at the top of the page. There's no page numbering. I'm so sorry.
Yasin Ahmed Khan.
Correct, my lords, correct. My lords will find that there's a customer ID. There is a borrower name.
Disbursement amount.
Correct, my lord.
1 crore 38 lakhs. NPA date 9/1/9/12/2024. What is the next column?
Which
What is that 1 lakh, 1 crore 7 lakhs is what?
That is the principal outstanding as on 31st January 2025. 1 crore 7 lakhs.
Next to that?
Then interest. Then there'll be total 1 crore 25. And then the property details, that is the properties that have been mortgaged, and property value And of course, there's security. But what I want to point out, Malas, is there is no figure assigned to any of these loans. It's a
Where from this
total lump sum
50,000
consideration.
Where from this 50 lakhs has come then?
That I'm sure Piramal, I can't answer for Piramal, very frankly, Malas, but that I can only second guess is an accounting principle which they have maintained, how much they want to assign to this particular
Pyramid
loan.
didn't say anything about 50 lakhs.
I'm sorry, Malas?
No, on the last occasion, bank was not before the court.
Correct, Malas. Of course, my learned friend has come for the first time. I can't speak
So
for
he
her.
argued it, about 50 lakhs assignment.
They've shown it as
Price of the offset price is 1 crore 25 lakh.
correct. And my lords may also note, whatever amount, now the property has been auctioned, we have received a consideration of approximately, my lords, what is the, 2.55. As per the Surface Act also, after deducting whatever charges towards the auction, whatever balance amount we received will have to be, as per the statute, returned to the petitioner. So, my lords, let us say 2.55, and the outstanding amount is 1.4. So, my lords, about 1 crore 12 lakhs, less of course certain charges towards the auction conduct. All that has to be returned to the petitioner. So, it's not as if the respondent number 2 will profit it to the extent of 2.25 crores. Towards the whatever amount has to be set off against the loan outstanding, we have to do it. Deduct certain charges. All balance amount will be returned to the petitioner.
Short pass oral, please.
Your presence is not required.
Very good. Great.
Yes.
Much obliged.
Great.
The counsel, arguing counsel is on his legs, my lords. He intends to withdraw the petition.
For respondent one. With the order sheet. A memo is filed seeking. No, what is this fresh petition?
He wants to file a fresh petition with the liberty to file a fresh.
What is the liberty to file a fresh petition?
Maybe he wants to include other grounds.
That's like that we will not grant a liberty. We should know what is the liberty is seeking. Ask him to come.
My lords may pass it over. I'll ask him.
Yes.
Lords, serial number 17, I am appearing on behalf of the petitioner's counsel, my lords.
Yes.
Lords, just 4 or 5 dates I will mention, my lords, before taking your lordships to the writ petition papers. Lords, the loan borrowed by the respondent was treated as NPA on 31/2020. 31/2020, it was declared as NPA. Lords, 15/7/2020, 13/4 possession notice was issued. 15/7/2020. Lords, on 10/2/2023, under a Panchnama, there was a voluntary surrender of the possession by the borrower of this property. Lords, then we are required to keep watch and ward. Therefore, we had appointed security for this property. Lords, now there is a disposition which takes place. The people again forcibly enter into the property, as a result of which complaint was registered by the authorized officer in crime number 231 of 24. Lords, this charge sheet is filed saying that there is a trespass. Charge sheet is filed, cognizance is taken. Lords, the complainant also files a complaint saying that that's the respondent also files a complaint saying that we have forcibly taken possession of the property. Complaint is not accepted. Files a PCR. PCR is rejected. Lords, it is in this background we go before the magistrate under section 14. The authorized officer approaches the magistrate under section 14. Lords, now under section 14 and after the insertion of 1A, we are required to file an affidavit after due compliance of all the requirements for passing in order in terms of section 14. We filed the affidavit. Then your lordships may kindly come to annexure A now. What the magistrate does. Page number 15.
Yes.
Lordships will find petitioner is authorized officer Respondent is the borrower represented by the lawyer. Purely a ministerial proceedings is what the Supreme Court reiterated. Lords, may kindly come to paragraph number 5. Lords, up to paragraph number 4, the magistrate records the compliance with the requirements in terms of 1A for the purpose of issuance of order under section 14. Now from paragraph number 5. When the case is posted for argument on 30/11/24, the PG advocate for respondent has filed an application under section 379 of CRPC, 215 of BNSS for the offences punishable under 227, 220 of BNS, that the petitioner has filed the petition for obtaining physical possession of the scheduled property belongs to the respondent. On 10/2/23, the respondent gave complaint to the rural police station Mandya for illegal forcible possession of the factory property without obtaining any order by threatening the guarantor Ramanjulu. On 13/5/24, police have recorded the statement of Ranjan Kumar, who is the manager, Asset Recovery Branch, Bangalore. Since the police have not taken action, the respondent without alternative filed a private complaint as per PCR number 47 before the court on 14/5/24, and the same was dismissed on 28/10/24. That is the file by the respondent. During this period on 11/6/24, petitioner with a bad intention filed false and frivolous complaint against the respondent under family members for trespassing the above said property for offences punishable under section so and so. The police without inquiry has registered the case against the family. As per the complaint, the petitioner took physical possession of the property on 10/2/2023. Therefore, petitioner is not entitled for possession. On 3/8/24, on the complaint against the petitioner, for that the complainant also the police have not taken any action against them. On 16/7/24, the petitioner has filed an application under section 14 before this court for taking possession. As per the statement of authorized officer by name so and so on 10/3/23, itself they have taken possession on petition scheduled property. Now they claim possession which is not in accordance with law because already possession is taken over, is not under section 14 of the Act. Hence, he prayed to allow the application. Lords, kindly mark para 6. To this application, petitioner has not filed objections. He gets into adjudication mode. Para 7. Kindly pardon me, Lords. The application filed by the respondent shows that it is in the form of objection as well as praying for against the petition for not complying with section 14 sub-AC. In this case, it's pertinent to note that the present petition was filed for the relief of passing an order taking possession of the scheduled property. It may be true that the petitioner, before filing the petition dated so and so, notice under 13.2, possession as per 13.4 has been issued, paper publication is compliant, document produced by petitioner dated 1/2/22, which is the application given by the respondent before petitioner, praying to settle the bank account and compromise the matter. Document shows that after issuance of paper publication, the respondent the respondent before this court shows that the basis of the complaint filed by the respondent. On 10/2/24, before the Mandya Rural Police, they have recorded the statement of Ranjan, who is the manager, Asset Recovery Branch. His authorized officer is clearly that on 10/2/23, petition scheduled property have taken possession of the possession by the petitioner bank. They have not illegally seized the scheduled property. As per SARFAESI, they have taken possession of the same. On perusal of the statement, it clearly goes to show that already possession of the property is taken by the petitioner. Authorized officer of the petitioner has lodged the complaint on 10/2/23 for having obstruction made for uttering filthy language to the respondent of the family. For that reason, the police have registered the case for offences punishable under section 143, 448 against the respondent and her family members in the complaint lodged with the authorized officer. He stated that on 10/2/23 they took possession of the scheduled property, but it's the respondent bank and the family members who have obstructed the property. Respondent has produced another copy of the complaint dated 3/8/24, which is produced to show that the husband of the respondent by name Lamlingo has filed another complaint against the authorized officer petitioner in which he is alleged that the petitioner physically took factory key from the complainant by threatening him and also took signatures in the paper and so and so. As per the complaint, the police has not inquired and investigated the matter. After verifying the entire documents produced by the respondent, it clearly goes to show that before filing the present petition, petitioner they have took possession of the property on 10/2/23. But by suppressing the said fact, also by suppressing the complaint lodged by the authorized officer, the respondent, the family members have filed the present petition. As per SARFAESI Act, after complying with 13.2, 13.4, an act, the recourse open to the petitioner is to comply with section 14. In order to take possession of the petition scheduled property, the petitioner has to approach before the Chief Judicial Magistrate. In this case, although the petitioner has filed the petition before this court, but the prayer made in the petition is that the prayer for passing order for taking possession of the scheduled property, in this case, contrary to the said aspect stated before this court, in the petition filed by the authorized officer, The main contention raised in the petition shows that possession of the scheduled property is not taken, but statement given by the authorized officer on 13.5 as well as the complaint lodged in 10.3 against the respondent or family member clearly goes to show that already possession is taken. When petitioner by sending notice under 32 of the SURFACE Act had opted the provisions of SURFACE, then they have to adhere to the provisions. Materials on record shows that before passing the order by this court, possession of the property was taken by the petitioner. The same was not intimated to this court and they have suppressed the same facts in the petition. Therefore, without following the provisions of SURFACE Act, the taking possession of the scheduled property from the hands of the respondent itself shows that it is not in accordance with law. When already they have taken possession of the property on 10/2/23, since from the period the respondent is unable to do any business, since from 10/2/23 till today the factory kept under lock due to mistake committed by petitioner. If petitioner wants to recover possession of the petition scheduled property, it must be in accordance with law. But in this case, before complying with section 14, they took physical possession of the property, which is against law. Your lordships may kindly mark this, because this is contrary to the view taken by the Supreme Court minutes. Therefore, now the respondent prayed to take action against the petitioner. Materials on record goes to show that petitioner suppressed facts before this court. The citation referred to by the counsel for the respondent criminal revision is aptly applicable to the contention raised. Therefore, preliminary inquiry has to be conducted against the petitioner in respect of contents of
Who
the
appears for the respondent?
Lords,
C Tech. Company Milord is borrower, principal borrower.
Lords, I just wanted to bring to your lordships notice two aspects, Lords, which is purely legal in nature. In R.D. Jain's case, the Honorable Supreme Court said
No, that's
purely-
true. No, what is the interim order that is required
we
in
are
this?
only seeking stay of these orders. Ultimately, Lords, what they are doing is they are seeking to hold an inquiry against the bank for having made an application under section 14. These are all the records for which the respondent has participated. The fact that there was a dispossession which was voluntary in nature, which is under a panchnama. 1 year they did not do anything.
Where is the
After that, they came out
panchnama?
physically.
Milord, page number.
Please, Milords.
Milord, page number 55, Milord. Actually,
Page 55 is the panchnama.
that contention already considered in PCR also. Page number 65.
This is dated 10/2/2023.
Yes.
When was the crime registered?
Milord,
Lords,
page number
14/4/2024.
Now, what happened to the PCR?
Lords, the PCR filed by respondent is dismissed.
Page
The
number
crime
65.
registered by us has resulted in a charge sheet that they have actually illegally trespassed into the property.
Please come. The bank is before this court questioning the order dated 28th August 2025, whereby the magistrate has dismissed the application that is filed under section 14 of the SURFACE Act and directed the office to register a criminal case against the petitioner, who is represented with the authorized officer, in view of the application filed by the respondent dated 30/11/2024. After registering the criminal miscellaneous, the preliminary inquiry will be conducted against the petitioner authorized officer. There is senior counsel appearing for the petitioner submits the order that is passed by the magistrate is contrary to law and also the contrary to the facts of the case. It is submitted that the account of the respondent is declared as NPA on 31/2020 and the SURFACE proceedings were initiated and a notice under 13(4) was issued on 15th and 2020 and the position was given on 10 voluntary position, voluntarily surrendered the position on 10/2/2023 and they have conducted the panchnama. Later in the year 24, when the respondent has forcibly entered into the property, they have filed a complaint, that is crime number 231 of 24. Later, after a full-fledged investigation, the police have filed the charge sheet stating that the bank has taken forcible possession. The respondent also has filed the PCR. The same was the same was the same was rejected. It is submitted that the magistrate has, without considering the facts and beyond the jurisdiction conferred on the magistrate, the order impugned is passed. Next paragraph. Considering the submission of the learned senior counsel. And the crime 231 of 2024 that is registered against the respondent, and also the fact that a charge sheet is filed and the PCR that is filed by the respondent is rejected, there shall be stay of all further proceedings. There shall be the stay of operation of the order dated 28/8/2025, passed in criminal miscellaneous number 185 of 2024, on the file of the principal senior judge, civil judge and CJM at Mysore. Notice
But
to
your
respond-
lordships may say the order and all further proceedings there too, because it should not appear, my lords, to the magistrate. If they have already initiated the inquiry, it should not lead to a confusion that.
That's a relief that is sought. There shall be stay of all, leave that. In view of the same, there shall be stay of all further proceedings pursuant to the order dated so and so.
Grateful.
Yes, so grateful.
Cell number 18.
In this matter, a hand summons to the
For
respondent,
respondent.
hand summons to the respondent and shall file a memo to that effect by that the order
we have
is
filed
till the next date of, not in your case, till the next date of hearing. This is matter on 26th. By the time the petition shall file by 24th, the hand summons, the memo shall be filed. Or else on that ground also the stay granted by this court stands vacated. Yes.
Said Jafar Moinuddin.
Appearing for the petitioner, my lord. You've served the copy onto the respondent bank.
We have received the copy. There is outstand of 1 crore 30 lakhs for 41,000, my lords, as on date.
30 lakhs?
1 crore 30 lakhs 41,000.
My lord, in this case, my lord.
According to him, he is continuously paying the money. There was no reason for the bank to declare his account as NPA. That's what is his submission. He has filed some bank statements. That itself clearly reveals that the amount is not paid.
No, my lord, at in page 45.
Please come to that. Let me understand what you are submitting.
Please.
Every time 2/10/2023 payment presented EMI number presentation 1,32,449. That is at page number 38. Come to page number 39 top. Same date. 2/10/2023.
Those are the dates on which they are producing the checks before the.
No. Your payment 2/10.
Lord, right below that, my lord, 2/10, 29/10, 31/10, 31/10. Those are the receipts that have been recorded, my lord. It's not that we are not.
Let's see.
At the same page, my lord, right below where your lordship is reading. At
what is that? 50,000.
50,182,350.
What is your EMI?
It is
1,32,449.
Please, my lord. Adding that together amounts to the entire EMI, my lord, for that month. We are making payments in that regard, but my lord, they exactly on one.
That's not the ground, Mr. Counsel, that where this court will interfere. What is the prayer that you sought?
Lord, they've
requires the measures initiated with the respondent in the possession notice dated 22/7/2025.
Please, my lord.
To stay all the incidental. If this is the only ground, then we can't entertain this petition.
No, my lord. Considering the fact that we are in talks with them, they have not informed us that.
Both of you talk. Whatever. Why should you come to this court and what this court will? Why this court shall?
No, my lord. When section 13(4) proceedings were initiated, we were not informed about those proceedings. Even after the notice was issued, we have still made 2 additional payments towards the bank with regards to EMIs, and that is also recorded in the statement of account. Without providing us opportunity, the managers from the banks were in conversation with us, we are trying to find ways to settle the amount in a surprising manner without providing us proper information.
13(4) is already initiated, so go before the DRT. Will not interfere.
Lord.
Provided if you say that this 1 crore 30 lakhs you are ready to pay and some installment, let you come out. Other
we-
than that, no
we
interference.
we are ready to clear the amount, my lord. We at no point of time.
When, how?
My lord, in 4 trenches, if it may be allowed, at 4 trenches, my lord, at 4 intervals, 25%, 25% and 25%, because we are trying to,
File an affidavit.
please, to
Let
that
counsel for the petitioner submits that they're ready to pay the entire amount in 4 equal installments, running a span of 4 months.
please.
In a span of 4
Lord,
months.
6 months, my lord, please. The amount is a considerable amount, my lord.
Running in a span of 6 months.
Please.
And in that regard, he will file an affidavit, undertaking affidavit before this court. Place this matter on Tuesday.
Please.
Before file, on Monday, by Monday, the affidavit shall be served on the respondent.
Please, my lord.
Yes.
Cell number 9.
Appearing for the petition in this case.
For
my lord.
respondent bank, kindly have it on tomorrow, my lord. Senior held up in trial court.
Tomorrow's auction date is at 31/10/2025, around 11 o'clock. Kindly see that impugn order page number 88. The second page itself, they stated very clearly timing and other things, but auction date as fixed, 31/10/2025, tomorrow. Tomorrow is there, around 11 o'clock, 11:15 it is there, e-auction sale. But this notice has not been served on me.
Which
Well,
notice?
This notice, e-auction sale notice, have not been served. Not only 13/2, 13/4 is not all, they're not due process of law, they're not made it, respondent back. And right from the 12,000 to 2024 onwards, I have given more than 10 representation before the bank.
What
And
is
see
the
that one-time
outstanding
settlement, nothing
What
has
is the
been done.
outstanding amount?
Now,
What is the outstanding amount?
according to this notice, around 5 crores 88, 5 crores. But according to me, that only one property, I have taken loan for 1.25 crores. But 1.25 crores,
Which year you have taken?
2014 we have taken loan. 2014 we have taken loan.
It will become 5 crores by this time. if you don't pay.
One minute. There are 2 properties we are mortgage. The 2 properties, 12/12/2024, e-auction kindly said impugned, the previous impugned notice. That one property has been sold by the bank and that recovered 2.46 crores.
When
Kindly
counsel
see
for
that,
the
kindly see
petitioner
that.
submits that,
1 minute.
none of the notices either under 13.2 or 13.4 or order under 14
1 minute.
or the sale notice is served on the petitioner.
And also that fixing a price is much lower than the market value. 1. Second one is, kindly say 2 minutes, I'm not taking much. Kindly say page number 66.
And counsel for the respondent shall get instructions and also all the documents shall be placed before the court with regard to the service of notice on the petitioner. This is matter tomorrow. Get all the papers.
Tomorrow morning around the top of the list.
Stay the auction.
No, let him conduct the auction first. I'm not thinking. Defer the confirmation of sale. 1. Second one is kindly say 1 minute, my lord. Kindly say page 66. 1 minute. I'm clearly explained to your lordship and see that now the value of the fixation of the amount for this property is on the 12/12/2004 fixed at 2.5 crores. But in this notification, 1.99. How it has come down? And I purchased.
We'll ask him.
Yeah, tomorrow, because they may conduct the e-auction. That's why I'm saying that. Let them defer the sale or defer the confirmation of sale. I'm doing that.
Find any reasons.
I'm ready to deposit the entire amount of 1.2 because subsequently, day for 3 days back, I gone to the.
Deposit by tomorrow.
1 minute. I'll come.
By tomorrow,
I'll
how
come.
much?
I'll come to that.
By
1
tomorrow, how much amount you will deposit?
Yeah,
Only on
tomorrow-
that ground it will be stayed. Otherwise, no.
Tomorrow, I'm depositing 25 lakhs.
Out of 5 crores.
Out of 1.25 crores. Because.
Funding according to them is 5 crores.
Let them say, I have gone and met the CEO as well as president of the Tumkur Gramina Bank on Saturday, and they given promises that you pay the entire amount of the, principal amount of 1.25 crores, and the balance is interest waiver. That is, put a letter to me.
What about the promise made by your bank manager to the
CEO told me very clearly on that day.
This matter tomorrow, yes.
Till then, 1 minute. Till then, not to be precipitated any actions on the e-auction sale notice.
Nothing will happen. Tomorrow
Nothing will happen because what will happen, they will hand and go with the third parties and release it. One more property, the value was 1 minute, my lord. 1 minute, my lord. The one property has been sold on 12/12.
Go to the DRT.
1
Then-
minute, 1 minute, 1 minute, my lord.
Next option is go to the DRT.
What the bank has done, 1 minute, only for. See, 12/12/2024, one property of a mine, second property, 7 crore worth of value is 2.46 has been sold. Here, this property value is approximately around 4 crore. They want to go for 1.99. So that is his throwaway price. They want to sell it. But my humble submission is, I have not received the notice. So this, let them, tomorrow is his auction stage. If suppose next month it is there, I can wait, or I can go to DRT for filing of this one under section 71 of the 45 days. His requirement is there, timing. But this notice has been not sent. This notice has been sent through one of the petitioner's mobile number, WhatsApp, on 21/10/2025. Even if he's taken 20 from the date of 21, it can 50 days time to be calculated for the notice. If case it comes 36 days. Now 31 instead of 31, 50 only they have to sell it. But they want to keep it on 31 only for that purpose, not to defer the confirmation of sale. I'll ready to pay the money in case this court wanted. I'm ready to pay the 1.25 crores before this.
So let me understand what is outstanding.
Before this court itself, I paid within 50 days of 1.25 crores.
We'll understand tomorrow.
That's what, because then I don't want to lose a property. But
Mr. Counsel, let the respondent come with instructions. Tomorrow I'll hear. Tomorrow on that I'll pass order. See you next.
How much?
Cell number 20.
Malaj, I'm for the
Prabhushan
petitioner in this
CB.
case, Malaj.
Hmm?
I'm for the petitioner in this case, Malaj.
Who appears for the respondent?
Malaj, it's a Canara Bank, Malaj. Before that, Malaj, page number 49 maybe.
Where is Mr. Shetty?
Malaj, I'll serve it, Malaj. Before that, Malaj, page number 49 maybe look.
No ad interim orders I'm going to
Malaj,
pass. I'm
there
making
was
it
a
very clear.
demand notice and possession notice that was already set aside by the DRT, and they've again issued a demand notice.
They should have.
Demand notice again. There was a demand notice in the year 2022, Malaj.
Pushing the demand notice now.
Yes, Malaj. Malaj's demand notice and possession notice was issued in the year 2022 and 23. And in the year
See the DRT
2024,
order.
Malaj, page number 49, Malaj.
So nothing is going to happen by tomorrow.
Malaj, 28 is the demand notice, Malaj.
So what will happen?
Malaj, 60 days is already over
What
on.
it say? Accordingly, read it.
Malaj,
Para 33,
Malaj, para 22,
23.
23. Accordingly, yes, Malaj. Accordingly, the tribunal holds that both the demand notice dated 29/11/2022 and possession notice dated 16/2/2023 are legally unsustainable and hereby set aside. However, the respondent bank is liberty to initiate fresh proceedings under the SURFACE Act in accordance with law after issuing a valid demand notice with accurate particulars of due. The essay is allowed and about terms.
This order is when?
Malaj, this is on 31/7/2025.
So
Yes, Malaj.
after this order, they have as liberty is given to them.
Malaj,
They issued a fresh demand.
Malaj, can I make only two submissions? 20 August 2025 demand notice was issued, and demand notice is with regard to agricultural lands. Malaj, it is contrary to section 31I of the SURFACE Act.
Don't jump into different documents
Malaj, I'm
at a
sorry.
time.
I'm sorry.
Your first submission is issuing demand notice is bad.
Yes, ma'am.
That is not bad for the reason the tribunal, in the light of the DRT orders. DRT has given them the liberty to give a fresh demand notice.
Yes, Malaj.
So what are the contents of it and all? That's the second aspect.
Yes, ma'am.
First, you have to accept that they have the power to issue.
Yes, yes, they have the power, Malaj.
That's not your submission earlier.
Malaj, sorry.
Yes, that is
was,
one. Number
yes.
two.
Number one is 28/2025, 13/2 demand notice was issued. Malaj, in that agricultural lands
Demand
were
notice is under
included.
13(2).
Yes, Malaj.
What you're supposed to do?
Malaj, I'm supposed to object to that. I've already done it. I've already done it. 13(3) is not complied with. They have not replied to my reply letter.
When did you give the reply?
16/10/2025.
16?
10/2025.
In
Page
how many
number
days they have
52.
to reply you?
Malaj, as per the statute, Malaj,
When is it received by them?
Malaj, it is received on 18, Malaj.
18. How many days they have to give reply to you?
Malaj, I'm sorry, it is received on 16/10 itself because it is
By
through
way
hand.
of mail.
Yes.
Hmm.
Malaj, as per the statute, they have to reply within 15 days.
So 15 days time completes when?
Malaj, next week, Malaj, but
I'm sorry.
Malaj,
These
Malaj,
kind of petitions we can't entertain.
Malaj,
Mr.
but
Counsel.
it is agricultural land, section 31I.
Then you have a remedy. Why are you rushing to the court without even waiting for them to do what they are supposed to do? If they don't give you a no reply
Yes, ma'am.
and they proceed further, you have a remedy then. It's the premature writ petition.
My lords, but the demand notice
But
itself
no,
is
but no
contrary.
ifs and buts. Please come.
My lords, can I produce this?
Please don't abuse the jurisdiction like this.
My lords, can
Please
I
come.
produce this judgment, my lord?
The present writ petition is filed
My lords, can I produce this judgment, my lord?
for judgment.
My lords, 31I, my lords. It's an agricultural property,
No
my lord.
judgment says that before you get an answer from them under 13(3)(a, on the
Yes, my
13, you
lords,
will come
but-
to the High Court and High Court will interfere.
My
You
lords,
have,
but-
it's a premature writ petition. The stage has not at all come.
My lords, but,
When it comes, we will see.
my lords,
The present writ petition is filed.
my lords,
Seeking the
let the
following
writ
prayer.
petition be pending, my lords, I will serve.
I will not keep it pending. Why should we do it? The present writ petition is filed, seeking the following prayer. In this writ petition, the petitioner has questioned a demand notice dated 28/2025 that's issued under section 13(2) of the Surface Act. When once the notice is received, he has sent his reply on 16/10/2025. Learned counsel for the petitioner submits that the reply to the notice that the bank shall give the reply to the reply that is given by the petitioner under section 13(3)(a) within 15 days. Now, even before that time has even before the time has elapsed, he has filed the writ petition on 25/10/2025. Different contentions are urged before this court that it is an agricultural land, there is a bar for initiating the surface proceedings and all. When the statute confers certain procedure to be followed, and when the bank issued a 13(2), when he has filed his objections, if the bank doesn't follow the procedure contemplated under the act and takes any coercive steps, then the cause of action will arise to the petitioner. The writ petition as it is filed now is a premature writ petition, and these kind of writ petitions this court cannot entertain. Accordingly, the writ petition is dismissed.
My lords, I may be given a liberty to approach this honorable court if.
I already
they do.
said so.
Yes.
Cell number 21, preliminary hearing B group. Aruna, you for petitioner.
Yes.
EPS.
Correspondent, my lord. My lord, on the previous occasion, I was directed to furnish the present outstanding amount with respect to the loan account. I'm producing through memo.
Please give that.
Copy. Copy also, sir.
So the outstanding is 1,02,78,490.
Yes, my lord.
With respect to this particular outstanding amount, my lord, still no cursive step has been taken because the bank was waiting for the orders to be passed by the Honorable DRT, and DRT has passed the orders on.
Now, let's see what is the order that is questioned before this court.
The same order, my lord, at page number 42, annexure H. The order is passed on 30th May 2025, my lord.
Page number?
Page number 42, my lord, in the writ petition.
No, I don't think it is 42. 42 is 13B4 notice.
Sorry, our page.
13(4) notice.
13 for notice.
That is what is questioned.
My pagination.
Huh?
The pagination might be wrong, my lord.
My lord, my prayers were to quash the order of DRT, which prevented me from questioning the wrong 13(2) notice, which was raised on wrong balance from the surface roads. That was prayer number 1. Prayer number 2 was consequently the possession notice, 13(4) notice have to be quashed, and consequently the e-auction sale also have to be quashed. These were the 3 prayers in the main petition. So the whole writ petition is my lord have taken the current outstanding, but the question is about whether a wrong 13(2) notice can be propagated further to an action which will lead to auction of a property without considering the actual balance and the actual circumstances. That is the only question. since the new outstanding have been given, submitted before this court, my lord may dispose this writ petition quashing the old 13-4 notices and with a liberty to the bank to start the fresh 13-2 with the correct balance. So I will also get a chance because as per me, 2022 March, I have paid 3 crore 5 lakhs.
My lord,
Let me complete
the
that.
account has not slipped out of NPA, my lord. Still, it is classified as NPA, subject to they were supposed to make remaining 60 lakhs.
What was the earlier 13 to notice? What is the demand?
Oh, my lord, that demand was for 3 crore
3 crore 64 lakhs 9,234 rupees 80 paisa.
as on 28 January 2022, my lord. So subsequently, my lord, they in the duration where they were supposed to give a representation, they proposed the bank with an OTS, which was subject to payment of few of the particular amount. And they were also given a benefit of making a payment of 2 lakh 50 lakh to 2 crore 50 lakhs and getting a property released from the bank, which has already happened. And subsequently, my lord, they were also supposed to make the remaining payment of 60 lakhs at the earliest, but they have failed to do so, my lord. Hence, the bank further proceeded with respect to surfacey measures, my lord. And all the grounds which have been urged here are already been addressed by the DRT and have passed the necessary orders. This the order which they have challenged, my lord, here, the same grounds have been already been addressed, and without any way other for any additional grounds, they are here, my lord. So they have not made any other ground for this honorable court to interfere and set aside the order, my lord. And with respect to the prayers, my lord, all the prayers, my lord, have become infructuous because the sale notice which they have challenged has never taken place, my lord.
Come to the prayers. Impugned order of the DRT is questioned, 35/2025. What is the order that you have questioned?
My lord, that is page number 56, 55, 56.
50?
Page number 56 of the petition, say dismissal of SA number 287 of 2023. Because of the reason that there is nothing contrary in law for the time being in
The
force.
applicant contended the authorized officer ought to have issued a fresh demand notice in furtherance to and so and so. In view of an A2 sanction letter, it could not produce any provision of law or any judicial precedent prevailing in the country in support of its claim. The scheme of the act and the rules made thereunder do not provide for that. The benefit of one-time settlement granted by the first defendant bank by way of an A2 sanction letter does not interdict the proceedings initiated by it invoking the provision. So what is your submission on that?
My submission, my lord, as I had submitted previously, the question is about the continuity of the law. So 13.2 to 13.4, in the regular course of action, if I am not complying to anything, bank, obviously, the respondent have the right to go from 13.2 to 13.4. Now, in between, there is an OTS.
There is a question of questioning a 13.2 notice before the DRT.
13.2 notice is questioned in SA number 287 of 2023, which is dismissed, my lord. So my subsequent prayers are consequent to the dismissal of the consequent to the questioning of the DRT order. But the question is, my lord, the question is purely a question of law. Moment the bank, I write back to the bank and an OTS scheme is sanctioned, it is the process is getting digressed from the regular surfacey rules. So once the OTS scheme I have substantially paid and there is a reduction in balance outstanding.
Automatically your NPA will not be revived.
Yes, my lord. I agree to that. But question is, it is a debt recovery tribunal. Debt actually is very clearly defined in the acts. In 2I and 2J of the surfacey rules.
Unless and until you pay the entire amount under the OTS scheme,
yes,
they will not appropriate that amount to your account.
Yes.
So it will be lying.
No,
so as far as the amount is concerned, there would not be any change.
The outstanding amount, yes, my lord. But when it comes to the debt recovery tribunal have the power to appreciate the debt and get the debt recovered, not the entire loan. Now, question is, my 13.2 notice was one amount. Subsequently, OTS scheme was there, I have paid some amount, there is substantial reduction in amount. But my 13.4 further possession notice is again based on that same amount, which should not be, because that amount is not my debt.
Why it would not be? Why
Because
would
debt
it-
is an unpaid balance.
Have your OTS scheme attained penalty?
Or OTS scheme was given based on my request.
You have not paid.
Yes, my lord. Let us
So
not
they have not
consider,
apportioned the money.
I have not paid it fully. My lord is correct. I have not paid it fully. But even if my lord may consider that I have
Not make any
paid
change
fully.
in your 13.2 or the 13.4 notice, because the proceedings still remain to be, if you don't pay the money under the OTS scheme, then what remains, the whatever proceedings that were initiated, they will be intact, they will continue from there.
Then the 13.4 notice should reflect my debt, my lord. It is not reflecting my debt. It is reflecting my loan. And unfortunately, my lord, honorable DRT have also crossed their limit. DRT is a debt recovery tribunal, rather it became a loan recovery tribunal by accepting respondents' pleas. My only condition is that 13.2, then there is a payment. 13.4 should reflect my payment. Because it is not about repayment of loan, that is one side of it. Second side of it, the impact on me personally.
Where is the 13.4 notice, let's see. Whatever is outstanding, that 13.4 will show.
Yes, my lord. Whatever the outstanding, whatever is payable back to the bank, the question of debt is unpaid money from the loan. Debt is an unpaid amount, unpaid balance. So it should be, for example, loan is A, I have paid an amount B.
When did you pay?
I have paid before, in between the 13.2 and 13.4, I have paid that amount.
That is what I am telling you.
Yes, my
It is
lord.
under the OTS you paid, which they have not apportioned to the, appropriated to the accountant. So that will not be. If you want, you can take it back, that amount.
No, they didn't give, no. Once the amount is given, there is no going back. There is no question of taking back the amount.
My lord,
The question of not appreciation.
As per the OTS, if some amount has to be paid, he has not paid, what will you do with the amount that has already been paid? Are you
It will be kept-
appropriated to the loan account?
my lord, it will be usually kept in the no lien account,
Yes.
and subsequently on honoring the OTS, everything will be appropriated and the mortgage property will be released, my lord. So here, my lord,
Here in this case,
my lord, honorable DRT has recorded that when was he supposed to make the last repayment? The remaining of 60 lakhs was supposed to be made on or before 24/6/2022, my lord. Only then the OTS would be honored. So subsequent to that, due to his default, the further proceedings under the surface was initiated, my lord, was continued.
so the amount that is paid by him, what will happen to it in 2022?
My lord?
The amount that is already paid by him,
Yes, my lord.
what will happen to it? OTS, under OTS, part of the payment is made.
Yes, my lord.
What will you do
So
with that?
with respect to release of one property, my lord, there was the OTS was partially complied. The remaining was left out. So that is why out of 3 loan accounts, one account stood closed, and the remaining 2 accounts, in that 2 accounts, the remaining amount was appropriated. That is why the outstanding amount has been dropped to 1 crore, my lord. So further any notices will be issued, will be subject to this particular outstanding amount, and
For that, are you not supposed, then if it is now from 3 crores, it has come to 1 crore and odd,
yes, my lord.
then the demand notice should be there for on that 1 crore.
Madam, sorry, my lord, after this DRT has passed orders, no coercive orders has been issued, my lord. Coercive notices have been issued, my lord.
So sir, I'll record that. Now you will raise a,
The fresh notices will be issued subsequent to the present outstanding, my lords.
with this 1 crore and odd.
Yes, yes, my lord, 1 crore and odd.
Yes, please come. The present petition is filed seeking the following prayer. The petitioner has approached the DRT questioning the notice issued under 13.4 dated 25/4/2023 in respect of the immovable property taking symbolic position. The petitioner has availed a term loan of rupees 3,64,09,235.80. The petitioner has submitted a letter dated 16/2/2021 requesting for a one-time settlement outstanding under the term loan and the working capital accounts. But the bank accepted the same only on 24/3/2022 and issued a letter dated 25/3/2022 intimating that the proposal for one-time settlement as against a down payment of a sum of rupees 3,450 lakhs has been accepted by the competent authority. The applicant had paid an amount of rupees 2,90,000 to 2 crore 90 lakhs.
My lord, it's 3 crore 5 lakh rupees, my lord.
That was the OTS
I have
amount.
attached another annexure also.
That is
annexure.
your case before the DRT.
No, DRT also appreciate that, my
2
lord.
crore 90 lakhs.
During
And
the pendency
thereupon,
of DRT,
one
another
of the
15 lakhs
secured
was paid.
assets was released from charge. Then the bank has issued a demand notice dated 4/2/2022 under section 13(2) of the Act, calling upon the petitioner to pay an amount of rupees 3,64,09235.80 within 60 days from the date of receipt of the notice. And and it is a case that the account was declared as NPA only on 26/2/2022. When the petitioner was about to pay the balance amount of rupees 60 lakhs, the bank has issued a possession notice on 25/4/2023 under section 13(4) of the Act. Instead of issuing a fresh demand notice, the tribunal, the DRT had dismissed the said application permitting the bank to continue with the further proceedings pursuant to the possession notice dated 25/4/2023. Thereafter, the bank has issued a auction notification dated
Dated 26/5/23, my lord.
26, yeah.
26/5.
2023.
26/5/2023. When the matter came up on the last occasion, this court had directed the respondent bank to state what is the outstanding. It is submitted that the one-time settlement amount is adjusted, appropriated to various accounts of the petitioner. One account bearing number 24217 5500137 stands closed on 28/4/2022. The remaining two loan accounts are pending and yet to be closed. And the present outstanding dues on these two accounts is 1 crore 2,23,825.18 paise. And in respect of the second account, 54,66,000, 54,666.22 altogether. What is this? There is some calculation error. Look at it. The memo which you have given the court.
My lord,
It should
I've
be-
added both.
It
And
should be 1 crore 56 lakhs, I think.
How much it will become?
1.56.
1 crore 2 lakhs and 54 lakhs become 1,456 lakhs.
my lord, 54,000 plus
Oh, it's
40.
54,000.
Because of the alignment confusion.
1 crore 2 lakh, the second account it is 54,666.22 paise, and the whole amount becomes 1 crore 2,78,491. Learned counsel appearing for the respondent submits that after the order passed by the DRT, after appropriating the amounts to the different bank accounts, now with this amount of 1 crore 2,78,491.4, they would be initiating the
continuation of like the surface proceedings will happen from this for this amount, my lord.
They will continue. That is from 13 to.
No, my lord, they are not slipped out of NPA because this particular account has been classified as
that
recalled
is-
assets.
No, but this amount you have to demand them
Yes,
to
for
pay.
this particular amount, the recovery will happen, my lord.
They will record they will initiate the surface proceeding for the outstanding amount. Then in that case, the earlier one will go,
My lord,
earlier order will go, earlier notice.
no, my lord, the Honorable DRT has not set aside any notices because which were issued prior to OTS, my lord. The demand notice was prior to sanction of OTS. Subsequently, they waited for the borrower to make the repayment.
I'm not able to understand this. Earlier you demanded him to pay 3 crores and odd. Now we say it is 1 crore.
My lord, if in case the account slips out of NPA on the fresh date of reclassification of the loan account as NPA, from there again 13(2) will be initiated, my lord. But in this case, they have only one option to close the loan.
Don't even intimate to him that what is the amount.
My lord, that was intimated, my lord, by via the letter dated the recently which the petitioner has produced. In that amount, in that letter where the rate of redemption was explained to the borrowers, in that
Where is that?
they have produced, my lord, by way of memo that was already communicated to them, my lord. The memo they have produced, the letter of correspondence is 8/8/2025, my lord. The second page, the amount has been mentioned, my lord. 96 lakhs 64,754 rupees 18 paisa as on 8/8/2025, my lord. It's not in the petition, my lord. Separate memo was filed by the petition.
Looking at a separate memo.
Madam, sir,
Memo, one second. My lord, that memo.
The bank has already issued a.
My lord, but
notice
that is
for
subsequent to
The
the
borrower-
petition, my lord. After I knocked the door of this.
Exercising the right
honorable
of redemption under section 13A of the Securitization Act and also bringing to the notice of the petitioner, what is the outstanding amount as on that date,
As on 8/8, my lord.
as on 8/8/2025, and the amount that is placed before this court outstanding as on 27/10/2025. The petitioner shall pursuant to the notice under 13(8) that the petitioner is interested to redeem the mortgage by clearing the amounts, the petitioner is at liberty to do so.
My
And,
lord,
on the other grounds, this court is not inclined to interfere.
my lord,
Published, my lord.
my lord, kind submission. My solution to my problem lies when my lord gives me an opportunity to question this outstanding also, because this is the new outstanding that have been
My
submitted.
lord,
before
that
this
is
court
open
after
for the
I came
petitioner
to
before
court.
the Honorable DRT.
Court will not do
So,
anything.
my lord,
on that.
invariably it have to start as a 13(2) proceedings. Then I will get an option to question, not in this forum, in the actual forums, DRT forums. I have to be given 60 days. I have need to given an opportunity. So that liberty may also be recorded in the order, my lord.
Next part.
That
Published, my
liberty
lord.
also may kindly be recorded in my in the order,
Then
my lord.
consider the petitioner submits that the respondent shall initiate the proceedings afresh under section 13(2). Then consider the respondent submits that when the account still is still a NPA, and as per the order of the DRT, they can proceed with from 13(4). In that regard, with all these details, they have already addressed a letter. This court finds force in the argument of the respondent, and they cannot be initiated from 13(2). Yes.
Published, my lord.
Which otherwise, my lord, it will become binding on me, this amount, if my lord. Great from my lord.
Cell number 22. Cell number 22. Jagdish Acharya for petitioner. S. Narayan, coming.
My submission.
Loan amount.
Initial is D.
Loan amount is 22 lakhs on 3/6/2022. 22.
How much is the amount?
22 lakhs, Paid amount, by the petition, 18 lakhs 50,000. Your lordship is a house property along with the power loans. Power loans. From the date of loan amount till today, no notice. Your lordship and you file a petition before section 14 of surface yard and obtain the order. Obtain that without notice to me. He is a hard patient, madam.
Those are all the factual disputes that cannot be decided by
Tell
this.
the court whether you have given him or notice or
Because
not.
the learned magistrate, without observing all those.
Not all that.
Yes,
Please
my
tell the
lord.
court whether you have issued the notice or not, when was
Yes, my
issued,
lord.
whether it is served on him, place
Yes,
them on before the court.
Yes, my lord.
Place all those before the court.
I do.
What is action initiated now?
My lord, now, my lord, my property seized by this respondent.
Order is executed.
Seized.
Order under section 14 of the Surface Act has been executed. my lord.
Position is already taken.
Yes, my lord.
Position not taken, seized. That's all. He's on the street, madam. Family are on street. Power looms, minute with family.
What is outstanding now?
Outstanding amount, he paid the outstanding amount, my lord. Thereafter, he undertaken to close the entire loan amount.
How much?
That has to be calculated. When he will pay the entire amount, by the time the respondent is ready to give the actual figure which he needs to pay. That is what they requested. The petitioner is approached.
Your client can give you a better instructions about what is the amount instead of if he pays, after he pays, not all that. He can come up with a specific.
Let him undertake to pay the amount in a time bound manner, either 4 weeks or 8 weeks, whatever.
After
it may be.
disposal of
Accordingly,
Surface Act, the respondent accept 2 lakhs, madam. June 2025, 2 lakhs.
Mr. Counsel, when are you ready to pay? When are you ready to pay?
Madam, I leave it, I am ready to pay. I leave it to the court, madam, I am ready to pay.
within
What is
4
that?
weeks may be
Madam,
given to the petitioner to
Madam.
close the entire dues, my lord.
22 lakhs, madam.
I heard the figures. I asked you, whatever is the remaining, within what time you are ready to pay?
You are last minute, now minute, within a week, minute, 5 lakhs I am ready to pay.
What is outstanding?
Minute, the meantime, minute, you file a memo, how much minute balance? Remaining amount. I am ready to pay minute, 5 lakhs within a week.
My lord, I can.
Listen until you tell the court what is outstanding.
Yes, my lord. Tomorrow I will submit the entire outstanding amount and it will carry forwards. If he pays 5 lakhs tomorrow or 1 week, whatever the remaining amount, that will carry the further interest.
Yes,
under. Therefore,
We want to know, court wants to know what is today, not what is after 1 month, 2 months or 3 months. Ask him, your officer.
Yes.
Ask him.
One. Approximately 21 lakhs is the outstanding amount, my lord.
21 lakhs.
It may vary.
Minute, 10 lakhs minute, if any minute, more than minute, 18 lakh 50,000 already paid by me. You are like, I am ready to minute, pay minute, 10 lakhs within a minute, a week. Within a week. 10 lakhs. Meantime, minute, calculation minute by the respondent, then a minute, I am ready.
For the remaining amount, let him pay within 4 weeks. my lord.
Meantime, calculation memo.
What we do is, let him pay within 10 days.
Yes.
I list the matter after 12 days. By the time you come up with actually after deducting this amount.
Yes, ma'am. I
What
do.
is outstanding?
Yes.
Give him a copy of it.
Yes,
Then we'll ask him to file an undertaking. Within what time he will pay the remaining amount.
Yes.
Yes, ma'am.
The land counsel for the petitioner submits that without following the procedure under 13(2) and 4 and 13(4) without issuing any notice to the petitioner. The respondents have initiated the proceedings under section 13(4), section 14 of the Surface Act and has obtained an order from the magistrate. Now they have seized the premises. It is submitted that the petitioner in that property there are power looms. There are power looms in the said property. It is submitted that the petition is ready to pay an amount of rupees 10 lakhs immediately, and the remaining amount basing on what is outstanding, he will be filing an affidavit before this court. Considering the same. Then what should follow?
I can deliver the portion of the property.
The respondent, when will you deliver?
I will ask them, both of them, to discuss and they can decide.
The respondent shall redeliver the possession of the property to the petitioner on the condition that he will be depositing an amount of rupees 10 lakhs by sixth
of November.
by 6th of November, list this matter on 11th of November. On 10th of, by 10th of November, the respondent shall give what is the actual amount, what is outstanding, and basing on that, the petitioner shall come up with an affidavit undertaking before the court, and within what time he would be paying the remaining amount. Yes.
Possession may be after final decision of this honorable court, possession can be delivered, my lord.
Give it.
Within.
We'll see.
Within
You are
what-
not precluded. You can do it immediately. If it's not, it's on a condition. Deliver the possession. Yes.
Till number 23, Praveen Donagiri for petitioner.
My lords, I appear for the petitioner. My lords,
Here for respondent, once on 25/10/2025, they had obtained an order in which they had taken an undertaken, in which they had told that they'll pay 4 lakh rupees of amount by 28/10/2025. And within the remaining amount, whichever the remaining amount is there, they'll pay it by within 3 months. My lord, they have failed to pay the undertaken amount, which is 4 lakh rupees of amount. They have paid only 1,53,000.
It's ready to pay the entire amount within a period of 3 months from today.
my lords, I
Come
have,
up with an affidavit on Monday, on 27/10, with an undertaking that the petitioner will pay an amount of rupees 3 amount within 3 months, and they're also ready to pay an amount of rupees 4 lakhs by. What happened to this?
They only submitted
my lords,
1,53,000
I have,
of amount.
yesterday I have deposited 1,53,000. Today I have deposited,
I'm making it very clear. First of all, the interference of this court in these kind of matter is most unwarranted. In
I
spite of that, considering the interest of both the parties, courts are passing orders. And any kind of violation cannot be, there has to be viewed seriously. And I'll vacate the interim order where the petitioner do whatever they want.
Let's- may I make one submission? Today I have deposited another 20,000, which altogether comes to around 1,80,000 I have deposited today, altogether.
How much you're supposed to deposit
I-
by
I-
27th?
Understand, my lords. I'm supposed to deposit 4
Nothing
lakhs.
to understand. It is simple mathematical calculation.
My lords, if I may submit, my lords, the section 14 order was for,
I am not on the merits of the matter, whether 2510 order is complied with or not. It's a conditional order.
I
You have
understand,
not
ma'am.
complied with. So I will vacate this order. Please come.
my lords, I may submit. My lords, I have filed an affidavit for repayment of full amount
the
within
affidavit
3
was
months.
also submitted on 29.
What you can't do for a part of amount today, you want to purchase a good time for 3 months.
No, my lords.
That we will not. Step 1 is 4 lakhs. Thereafter is the undertaking. You are not able to fulfill that amount. Will not grant.
My lords,
The-
within 3 to 4 days, I'll deposit another,
No.
the balance.
This is not the way. This is not the way.
Well,
Just to get away with the order, whatever, just like that submitting before the court that we will do this and that. No. This court on 25/10/2025. This court has passed an order recording the submission of the petitioner that he will come up with an affidavit on Monday with an undertaking that he'll pay the amount within 3 months. And he's also ready to pay an amount of rupees 4 lakhs by 27/10/2025. This court has further observed that by 28/10/2025, an amount of rupees 4 lakhs shall be paid and an affidavit shall be filed before this court. On such deposit, the bank shall not take any coercive steps. If the petitioner fails to pay the amount to the bank or he fails to file a memo before this court by 28/10/2025, the bank is at liberty to take steps. In the light of the conditional order and counsel for the respondent submits that only an amount of rupees 1,80,000 is paid, 1,80,000.
1,53,000 on 28/10. They are making submission that they have paid amount today. We have to
27,000
wait
deposit.
1,53,000
on 28/10.
28/10. Today,
Today we
it
have
is a submission of the land counsel to the petitioner that
27,000.
27,000 is paid today. Land counsel submits that he's ready to, he'll pay the amount in within 3 months. Within 3 months. When a conditional, in a matter of this nature, the present writ petition is filed, questioning the proceedings under section 14 of the Surface Act. The petitioner has a remedy to approach the DRT. The Honorable Apex Court, time and again, has reiterated about what the interference of the scope of interference with the High Court in surface proceedings. Only considering the fact that the petition is ready to pay the amount, this court has granted an interim order as he has failed to comply with the interim order, and the fact that this court will not entertain the writ petition questioning, which is filed questioning the proceedings under section 14 of the Surface Act. The writ petition is dismissed, giving liberty to the petitioner
make one
to avail
submission.
the appropriate remedy.
Well, it's a week time for movables at least, my lords. It's a
My lords,
residential house.
They have been promising this from
No,
2000.
no, I will, this is final order.
Yes.
From today, 1 week time is granted for the petitioners to remove the articles from the scheduled property. That is, 1 week is, today where are we? Today is 30th. The petitioner shall collect all the movables by 10th of November.
Oh, yes.
Please.
Yes, next. Disposed of.
Cell number 24.
The respondent has to answer a limited question where how the NPA came to be calculated. Just to simplify matter, I have taken it on a paper. This.
Take that.
What happens is whenever
Yes.
whenever a installment for a particular month is skipped and the payment is made on a subsequent month, what happens is it is appropriate for the previous month in which it was skipped. In this, what has happened is February 23 and November 2023. These 2 months he has not paid any amount. February 2023.
February, that is 3/2/2023.
Yes, Lord.
He has not paid.
He is not paid. So what has happened is March, whatever is paid, 28/3, is brought forth to February 2023.
Yes.
So there is one skip. Then again he has skipped in November. Whatever he has paid for December, it's again appropriated towards October. So November is not paid.
So you will be for these 90 days, here and there, you will calculate.
It's not like that, Lordship.
Not
When
then-
he skips, the next EMI goes to that particular.
That I understand.
So what happens is,
No, you have given
Lordship,
it. Let us look at it.
Lordship, then rule is very clear. 90 days gap has to be there in payment, part installment or part interest. 90 days gap has to be there. That gap in this matter starts from November.
Let's see.
Yes.
November
of 2023. Whatever he was supposed to pay on 3rd November 2023 has not been paid. Since he has skipped an EMI earlier, what has happened is whatever is paid in December.
3/11, 3/12, 3/1. He has not paid anything.
Yes, Lordship.
Then
So it is a trigger. It's a mechanically operated. It is not no human interference. It is not possible also.
Now let us see from the statement what he.
Yes, Lordship.
Please come. And when was the account declared as NPA?
1/2/2024.
1/2.
2024. See, I'll complete, Lordship. In November, it is calculated as 28 days, including 3rd, 28 days. December and January, 31 days plus. 31 days plus 31 days. That is 62 plus 28 is 90 days. The machine would declare NPA on 1st February 2024. That's how it is.
Now please come to your account
Page
and
four.
have you given a copy of it to him?
Yes, my lord.
Yes, sir.
Page 14, my lords.
14, yes.
my lord.
Can I have a look at it?
Yes.
No,
Yes.
it's not clear. That is what. Okay.
My lords, the payment is made on 11/10.
On
11/10, my lords.
11/10. No, that is not in dispute. You don't have to go to it. No, it's on 3/11. In the month of 11/2023.
My friend has to show only February and November payment.
Kindly, my lords. That was adjusted to 3/9/2023, my lords. Then for 3/10, they have adjusted the amount of 13/12/2023. That your lordship may kindly see. The due date itself, the first installment is itself on 3/7/2022. They could not have counted the first day on which I have to pay. What they have to count it from 4th, not from the 3rd, my lords. Even if we go by their calculation, they are saying that they included 3rd itself. They cannot include 3rd, my lords. If the calculation is to be done in a strict manner as it is under the Surface Act and the RBI guidelines. If they count the 3rd, my lords, that is on the due date. If I don't pay on the 3rd, that is.
When did you pay?
Lords, that is on 13/12. That is paid, and they have adjusted it to
October,
my lords.
So that means you have not paid for the month of
November.
Ah.
November. 3/11 is the due date, my lords. They have to count it from 4th. November comes 30 days. Lords, that is simple mathematics, my lords. Even if you are counting for the limitation period, we would not be counting down that which day it is the judgment is delivered.
So we will say, no, it is 1 day here, 1 day there. So it is only 87 days. That's why it is not 90 days.
Yeah.
So the
Lords, because for the reason the taxation laws and this banking laws has to be interpreted strictly, because if we are committing default, they don't say any mercy upon us. They don't even show single mercy upon us. They're clear on that. And my lords, when they are calculating, they should be diligent upon that. If at all, my lords, my learned friend has stated that the 3rd has been calculated, that cannot be done so. For the reason when it is the due date on the 3rd, that is the 4th that has to be counted. If we leave 3rd, it is 27 days. 27 plus 31 plus 31.
how much
Lords,
how many days?
Lords, they are short of 90 days.
As on the day it is
Yes, my
declared
lords.
as NPA.
Yes, my lords.
Lordship.
Because, my lords, it has to be strictly complied with.
My friend is highly on technical grounds.
My lords,
Now
obviously,
point
my
is,
lords, we
my
have
point
to.
is, my point is,
Because you also like bank is always. on
Yes, my lords, they don't show mercy upon us.
that's how it is calculated. That's how it is
That
calculated.
calculation is bad.
No, I
As
don't
you
know.
see.
I
So
leave
that
it to the
90
court.
days,
Lordship,
yeah.
apart from that,
No,
let's
no.
look at this way.
No, you shouldn't leave anything to the court. What is his
But even today-
limited ground that he has raised is declaring his account as NPA is bad because he has not completed that 90 for a period of continuous 90 days is not completed. So if it is completed, that is completed or not, that you have to say.
I am not finished, Lordship. One particular
Even
aspect I want
one
to.
submission, my lords, I would make. Even today, we are ready to pay the amount.
What is the amount?
3,07,000, my lords.
No.
As on
As
the
on
date,
That?
as on the date when they issued notice, it is on 3,06,961. As of today, we don't know, my lords, what it is.
They have to go to the bank and find out, Lordship. One more thing.
No, for such a small amount, if he's ready. why don't
530, it's only 537. 5 crores.
5 crores.
That's a loan amount.
That's a loan.
Loan amount is 3 lakhs, my lords, not 5 lakhs.
No. What I'm saying is as on 310, the amount payable is 5 crores, 5 lakhs 68,763.
Let them, my lords, if they
It's a
have
very, very
included NPA and they've imposed penalty and charges everything, that's why it comes to 5 lakhs, my lords. Let them give us a OTS amount. We are ready and we will pay the amount. We are not denying that.
I've not completed,
Right.
Lordship. One submission I want to make.
Hmm.
My friend, if he comes back and pays that amount, even on 1/2, subsequent to 2/2, or any other days, he has not paid a single amount after that, after declaration. If he has paid on the subsequent month, it would have become a
Lords, no, my lords.
non-NPA.
I will
Would
make a
have gone
simple
out of the
submission.
book.
Once it becomes NPA, bank will not accept installments. They will say you have to pay the entire amount.
No,
pay
no,
the
no,
entire
that is
amount.
not correct.
That is the harsh reality, my lords. That
Please-
cannot be
please
looked
get
over.
instructions from the bank. With this calculation, know that, declaring his asset as NPA is wrong. Once you set aside, everything goes. Instead of that, you please get instructions from your bank, whatever is outstanding. And if he's ready to pay, we can.
Once
dispose of
OTS,
that.
if they give, my lords, we are ready to pay, we'll pay the. Only thing is, my lords, let them not impose the
5 lakhs
penalty.
68,000 something.
Lords, that is
Let him pay
imposing
that.
penalty and everything. That cannot be done so, my lords.
So that penalty you can't impose.
And
If that is the
everything-
case, then we will say that we will satisfy that order. Means that procedure itself is bad, that the court will give a fine.
Lordship, that 89 days would fall on 31st of January, not on 1st.
On
After
completion of
90
days, they have
only
to
we have
declare
done
it, not on the 90th day. my
Only on
lords.
90th day,
On com-
or not on 91st day we have done it.
Bank has enough litigation. So when somebody is ready to pay, accept the money.
Let him visit the branch. I don't know. Let him go to the bank and find out whatever is the amount payable.
Then counsel for the respondent shall get specific instructions. What is the amount payable? Excluding the amounts for the charges that are levied for declaring after the account is declared as NPA.
Interim order may kindly.
On 17th November, no coercive steps till then.
Interim order is there, must it may be
Got
extended. Okay.
Interim order earlier granted is extended till then.
Great.
Yes, next.
25, Girish Baldare. Pass on.
Application, your lordship directed to,
Hmm.
while they are undertaking affidavit.
Give that.
Your Lordships,
Outstand-
I have
I
given
make
them
a
a copy
submission.
of the statement. I've given them a copy of the statements.
In this case, my
Statement of
lordship,
accounts.
the outstanding amount is 33 lakhs 14,000.
No, have you seen this undertaking affidavit?
After the issuance of the sale notice, I have paid the 7 lakhs, my lordship, on
Son and daughter.
26/9/10/2025.
Outstanding loan amount is 33 lakhs.
33 lakhs. After that, after issuance of sale notice, I have paid 7 lakhs, my lordship, on 9/10/2025. Sale notice was issued on 25/9. Thereafter, I paid the amount of rupees 7 lakhs, my lord.
Outstanding amount is 20. According to you, what is outstanding?
As
It is
on
6
today,
lakhs
it
as per
is,
the sale notice.
as on today, it is 28 lakhs 33,834. After adjusting the 7 lakhs they have paid.
2 lakhs he paid, it seems.
7 lakhs.
That is
my
also
lord.
adjusted. The sale
7
notice
lakhs I have paid,
says
my lord.
the outstanding is 33 lakhs 14,000 as on 31st March 2025. Lords, now they paid on 9/10, 5 lakhs plus 2 lakhs, 7 lakhs.
7 lakhs I have paid.
7 plus 2, 9 lakhs.
No,
No,
5
no, no.
plus 2.
7.
Total 7 lakhs.
Yes.
Total 7 lakhs. my lord.
So
if
as
you
on 31/3, it was 33 lakhs.
Hmm.
Later, they paid now 7 lakhs. After adjusting everything, as on 9/10, the outstanding is 28 lakhs 33,834.
But how you have arrived at 26 lakhs?
As per the sale notice dated,
But that is on 31st March, the outstanding.
as per the sale notice,
It should be 20?
It's 28 lakhs 33,834.
As
Even,
on today.
even otherwise, my lords, the affidavit says that they'll pay it after, by March 2026.
now I am ready
Who
to.
gave you this time?
No, my lord, I have taken some reasonable time by the permission of this court. I am ready to.
Months.
4 months. I
Sale
only
is
put 4
tomorrow.
months, my lordship.
Sale is
Sale is
scheduled
tomorrow, my lord. I am ready to pay 5 lakhs tomorrow. And remaining amount in 2 installment, I will
So now it is
undertake
coming
to
to
pay.
30? What did you say?
28 lakhs
28 lakhs.
33,834.
I have calculated as per the sale notice.
My instructions are that the bank is not agreeable for till March 2026, my lords, because the account became NPA in March 2024. Because he already approached
It
the
is
bank
only
for
acceptable
OTS.
to- It is only acceptable to the bank to go around the world.
Let's, he approached the bank before coming to court for an OTS. He did not
Thereafter, I
comply.
paid the amount.
He did not comply.
On 28/3/2025, I have paid 3 lakhs. Again, I have paid
It's
2 lakhs
already-
and 15
October is over.
2025.
November, December, January, February. We'll see that, we'll grant time till
My
February.
lords, not till February, at least by December, if he's repaying, at least I can convince the bank, my lords, if it's February.
Don't convince the bank.
My lords,
It's an order of the court. Let him not convince. You don't have to. How much it is? 28 lakhs, you said.
28 lakhs 33,834.
As per their.
Now again, if you have a dispute on that,
No, no,
go to
my
the DRT.
No, no, my lord. As on today. As on today.
As on 9/10, my lords.
So it comes to 7,08,546, 4 equal installments.
Then the interest and everything till.
Last one. In the last one, he'll
He'll
plus
have to
that.
every.
Yes. So By tomorrow, you need to pay this.
How much, my lord?
First installment,
5 lakhs.
7 lakhs.
Make it 6 lakhs, my lordship.
It is not, it is not making it. First, one installment is 7,08,446. Provided you will pay it, the auction will stop
Yes, my agree, my lord.
before the auction time. We'll dispose it off with this and whatever are the interest and other this thing in the last February installment. You can give him the details. He has to pay that.
My request is January can be the last month. My only request. It could be by January. If it could be 3
Small
installments.
amount, you leave all
Okay, one additional
crores of rupees.
month time.
Some indulgence has to be shown for these kind of small amounts. Please come. The present petition is filed. Questioning the sale notice dated 25/9/2025, where the auction is scheduled to be held on 31/10/2025. It's a case of the writ petitioner that he is the owner of the agricultural land measuring 14 acres 6 guntas situated at Mattavara village, Kaspa Hobdi, Chikmagalur Taluk. And by mortgaging the said properties, he has availed a loan from the bank. As the petitioner had failed to, what is the amount taken? What is the amount, loan amount availed?
Loan amount nearly 20 lakhs, my lordship. I don't know the
He has
exact
taken an
amount.
amount of rupees 20 lakhs from the bank. As the petitioner has failed to pay the amounts, the bank has initiated the proceedings on the Surface Act and the possession notice was issued on 5/12/2024. Later, they issued the e-auction notice. When this matter came up before this
Homework
court
section,
on the
huh?
last occasion, then counsel for the petitioner submitted that he is ready to pay the amount. And this court is conscious of the fact and the interference of this court in these matters, but still considering the fact that he is ready to pay the amount, has asked him to file an affidavit of undertaking. Today, the undertaking affidavit is filed before the court, wherein it is stated that he has paid an amount of rupees 2 lakh and 5 lakhs on 9/10/2025. And now, according to him, the outstanding amount is 26 lakhs 14,605, 55 paise. Land council, and it is stated in the undertaking affidavit that he will pay the first installment on or before 1/1/2016 of 10 lakhs and remaining balance of 11 lakhs 14,604.55 on or before 1/3/2026. Land council appearing for the bank submits that the outstanding amount as on today is 30, as on today.
As on 9/10,
As on 9/10 is 33 lakhs, 28 lakhs.
28 lakhs,
33,824.
834.
834. It is submitted by the counsel to the respondent that the petition is seeking time till March and that's not acceptable to the bank. The amount, if he deposits the entire amounts by January.
That may be noted that I don't agree to the
It is submitted that the bank, it is not acceptable to the bank. The petition, the petitioner acceptable to the bank that he pays some amount in the month of March, as they've already initiated the proceedings and the sold sale notice is also issued. What purpose the loan is obtained?
For agriculture purpose.
For the petitioner by mortgaging the properties. Why it is a coffee estate?
Yes, my lord.
The mortgaging the land, which is a coffee estate. They have mortgaging the properties, so they have obtained the loan. And the loan amount is also, is only 28 lakhs or not.
30 lakhs, sorry, my loan amount security is 30 lakhs.
The outstanding loan amount, it is 30 lakhs.
30 lakhs, not 20.
20 lakhs, he said, make it 30 lakhs. Considering the fact that now the outstanding is 28 lakh 33,834. And the affidavit of undertaking that is filed, considering all this court is passing the following order. The auction notice dated
25/9/2024.
the sale notice dated 25/9/2025, where the auction is scheduled to be held on 31/10/2025, is set aside on the condition that the petitioner shall pay an amount of rupees 7,08,458 before the auction starts tomorrow, before the auction tomorrow, and shall pay. Tomorrow is, what is the date?
31/10.
31st, man.
31/10. 31/10.
31/10.
Then the next installment of 7,08,458 is on 31st, is on 30th of November, 31st of, again 30th of December, and January. It will be complete by January.
I'm seeking.
Four.
I'm seeking for 4 months, my lordship.
January and January, by January 30th, it becomes 4 months. February it is by January 30th. So what you want, what he want, both are by 30th of January. If any of the installments.
The 30th of
And
February.
in the last installment, whatever the interest and other further amounts are, basing on the amount, the bank shall inform the petitioner, and that shall be included in the last installment. Next condition. If any of the installments are not paid by the petitioner, if there is any default on the part of the petitioner, the respondent bank is at liberty to initiate further proceedings.
I make one submission.
Disposed
I
of.
make
Yes.
one, up to, if lordship has granted time up to January, it is only 2 months, my lordship.
No.
This month is 29th, November and December.
January 30th. 30th of January is February. Yes, next.
And delivery for the operative portion,
Yes.
otherwise.
She will inform. Yes.
It's post. Cell number 26.
Appear for petitioner in this case, my lord. Lord, in this case, the petitioner questioned the order passed by the land magistrate under section 14 of the Surface Act, my lord. Lord, the petitioner has availed the housing loan of 44 lakhs.
Please wait.
44 lakhs.
Please wait.
Sir.
The respondent bank shall get instructions on service of notice under section 13(2) and 13(4) of the Surface Act, and about the fact that as stated with the petitioner, the account has not become NPA. If any of the facts that are stated before the court are incorrect, the writ petition would be dismissed by imposing exemplary costs of rupees 10 lakhs. What are your instructions?
My lord, as on date, the outstanding loan is 51 lakhs.
No, it's not about outstanding loan.
Lord,
I've
as
asked
on date, not
I've asked
55 lakhs.
about 13(2) and 13(4) notices, whether they're served on him or not.
It is served on. It is
Have you
served.
produced anything?
No, my lord, I have just brought, today I have received the
Yes,
copies, my
please
lord.
give it. Let's see.
Acknowledgement for serving that notice, whatever is there.
But not that copy, my lord. That is not stapled properly, my lord. I beg your pardon.
ಅದನ್ನ ತಗೊಳ್ಳಿ ಅದು. Copy.
Working in water also is not put in this. Yes. Yes.
Lord, there is no postal share, it is only a postal receipt. With regard to that, I can file an affidavit before this honorable court that.
This is.
That postal receipt, Lord, that is not a acknowledgement, that is
Next.
only a postal receipt.
Next page.
Next, Lord, that is not there that I can file an affidavit before this court that I have not received that any notice under section 13(2). Because for even in my statement, that's a writ petition. Even in my writ petition, I stated
Show
before
him
this
that
honorable.
page. He's
My
seeing
lord,
only at.
I received it now, my lord, so only one set, I couldn't take a copy for him.
I have not received for that reason only, Lord. Even when I demanded that they are paid, that at that time they paid the some amount. Thereafter they have not issued. That is also a
This is
specific.
all the general normal denial in
Lord.
every case under the surface.
Lord, in this
Act.
case, Lord, the property is residential property, Lord. He has availed the loan of 44 lakhs, Lord. On 9/10/2023, from 9/10/2023 to 5/1/25, I have produced the statement, Lord, that have paid the regular EMIs.
When was it declared NPA?
Lord, that the last payment was made on 5/1/2025, Lord. That I have produced the statement also before this court. Page 53, Lord, in my.
But I have to take instructions on that. My lord. I only received copies of
Lord,
demand
one
notice and
submission, one
receipts.
submission, Lord. It is a residential house, Lord. That petitioner accept this property, no other property is there, Lord. If some breathing time is given, Lord, is because for this loan has taken for 30 years. That each installment is 43,000 and add.
List is marked on Monday.
If this some time is given, Lord, that 4 months or whatever is there, I'll pay this entire amount and close the loan because this loan is for 30 years, Lord.
We'll see on Monday. Yes, please. Please, sir.
But interim order is there, Lord. Not to precipitate, the interim order is there, Lord, in this case.
This is a matter on 12th of November.
My lord, on submission, copies, it may be returned, I'll place it before the
Give
court
it to
along
him.
with the
Give
memo,
it-
my lord.
give it to him.
Clear copies.
The papers which he has given now.
Still number 27.
Lord, there is an interim order, Lord, not to precipitate.
Interim order, look at it. If it is there, extended.
Yes, Lord, that is there, Lord.
If it is there, it will be extended.
Yes, definitely.
Yes.
Challenge notice of physical possession, my lordship. I have sought for OTS, my lordship. I'm ready to pay lump sum for time being, my lordship. After that, let them consider OTS.
This court is not for, negotiating between both of you. Whatever you want, you please approach the bank. On that ground, we will not interfere.
They're not even a principal borrower, my lordship, they're GPA holders. After our mortgage, they are GPA holder and sale agreement holders.
You that?
2006 was the original sanction, my lord.
Hmm.
They have entered into GPA in 2010
Hmm.
and following a sale agreement. And in their own sale agreement, which is unregistered instrument, they have undertaken that they will clear the bank loan. In 2010, your lordships may come into annexure
ready
G-
to clear
annexure
the
C.
loan.
He will pay the OTS.
Entire, not OTS, entire outstanding. That is their sale agreement.
I'm ready.
Undertaking.
We have to accept.
Accept it. They are telling it.
Please
Annexure
come.
C, my lords, page number 25.
Please come. The present petition.
My lordship, I'll withdraw and
Yes, better.
I'll approach.
Dismissal is withdrawn.
Still number 28, Carter.
Petition in this case.
Narendra is.
Petition is ready to close down the outstanding balance, my
Opponent
lord. He's going to file the affidavit also, my lord. There are death in the petitioner's family. He has gone to his native, my lord. In 4 equal installment, he's ready to close down the entire loan account, my
What
lord.
is the entire amount?
My lord, 39 lakhs, my lord, approximately. The outstanding balance as on today.
He's ready to close. I'll file an affidavit because he's not in station, my lord. He has
When
gone
will you
to.
file?
It may take 6th or 7th, my lord. I'll file the affidavit on that day, my lord. Outstanding amount is 39 lakhs. As per that,
So on 6 for filing an undertaking affidavit by the petitioner. Yes,
please, my lord.
whatever is this passed over matter in this
Passed
case.
over
Amount may be
matters-
mentioned in the order sheet, my lord, so that bank should not.
It is submitted at by the land counsel for the respondent that the outstanding balance is
39 lakhs, my lord. Approximately 39
Approximate-
lakhs.
approximately 39 lakhs.
Please,
Yes.
obliged.
Passed over matters in list number 2, serial number 15. List number 2, serial number 15. Mohammed Saeed.
It is your contention that for an amount of 50
55
lakhs, that is, I have seen they are placed before this court. How the debt is assigned to them, it doesn't refer to that. They have with that, several loans are assigned. A particular amount is so and so.
Should kindly see this section 5(2)(a) of SARFAESI Act. It is very speaks about the whatever the remainder, the tenancy has to be assigned to the ARC as per section 5. They cannot say that we have purchased 10 properties, 8 properties we made a loss, 2 properties they are recovering.
They have given all the properties.
Yes,
What is, now how can you say that it is not 50 lakhs, it is something else?
It is 55 lakh, Lordship. I presented the statement, Lordship. The bank with the respondent of one statement clearly shows that they have received 55 lakh rupees from the ARC and they had closed the loan.
Where is that?
Page number 18 of my.
Yeah, that's what he is referring to yesterday. Mr.
Correct.
Srinivasan.
I've seen that.
18, page number?
Page entry number from the down, Lordship. Page 19. Page 18, Lordship. Statement of account. 18. It is on 28/3/2025, Lordship. The payment received from NFT. Entry is on 28/3/2025. NFT. ACRC proceeds 55,22,522.
Then what is that rule?
So what then not kindly see the section 5(2)(a) that specifically deals with the acquisition of right in the interest of financial assets, Lordship. 2(a) is the amended provision, Lordship. If the bank or financial institution holding any right, title or interest upon the tangible assets or intangible assets to secure payments of any unpaid portion of the price of the purchase, price of such assets or an obligation incurred or credited there otherwise, provided to enable the borrower to acquire the tangible assets or assignment or license to intangible assets, such right, title or interest shall vest in the asset restriction company on acquisition of such assets under subsection 1. Subsection 1 speaks about that. Actually, there is a guideline laid down in 2024 by the RBI. Lordship, there they speaks about the elaborate guideline of functioning of ARC was been given, Lordship, in this. Lordship, before adverting to the guidelines, Lordship, I'll request this honorable court.
No. From this 5(a), what is that you're trying to?
Unpaid portion of the purchase price.
Where do you get that?
2(a), 5(2)(a), Lordship.
5(2)(a).
5 subclause 2(a).
If the bank or financial institution.
Yes, if the bank and financial, it is in respect of secure payment of any unpaid portion. So they can entitle only for the unpaid portion, whatever the unpaid portion.
No. If the bank or financial institution is holding any
right, title or interest upon any intangible assets or intangible assets to secure payments of any unpaid portion of the purchase price of such assets or an obligation incurred or credited otherwise, provided to enable the borrowers to acquire the tangible assets or assignment or license of intangible assets, such rights, title or interest shall vest in the asset reconstruction company on acquisition of such assets under subsection 1. So only the assignment will be in respect of the unpaid, not for the whatever it is meant. But kindly appreciate, after receiving the assignment deed, they had the respondent number 2 has communicated with the borrower, with the petitioner.
Where is that?
Yeah, this is the communication email they have sent it. Type copy, fair copy I had.
Give them a copy.
It is their own copy only. Okay.
Council should have, even if it is their own copy.
This is the communication they sent to the petitioner on 27/5/2025. But you kindly appreciate, there is no dispute that NPA has happened in August 2023 itself. They have taken the position also. Subsequently, the petitioner and the bank has negotiated for the 1 crore for the amount for 1,35 lakh rupees. For that 1,35 lakh rupees, he has paid 95 lakh rupees. In February, 2nd February, from 30th January till 2nd February 2024, he has paid 95 lakh rupees to the bank toward the OTS amount. The remainder was 40 lakh rupees. Subsequently, Lordship, after a period of 1 year, in March 2025, they have assigned this entire loan amount for the cost of 55 lakh rupees. And why this 55 lakh rupees? Because they already received substantial amount. It is not that there was huge amount.
In their statement, the debt is, the outstanding is shown as 1 crore 37 lakhs.
So I will come back how it is there. Lordship, this is a statement which we received from the bank. I already pointed out from the entry. It is 55 lakh rupees. Sold it to the respondent number 2. We serve the copy to also respondent number 1. He is now before this honorable court. Now, Lordship, after that, receiving this particular assignment in 23/9/2025, the bank has contacted within a 2 month to the petitioner, and there has cited a principal amount.
Mr.
Total
Senior
is-
Counsel, instead of asking all this,
Yes.
why don't we ask the bank itself? Let the bank say, what is the debt assigned to you in respect of this? Let them come out.
To Piramal, my lords.
Yes.
And NBFC.
My lords, I can do that, my lords, but the only question is, should it be done? I asked myself, my lords, should it be done at the behest of this petitioner, given the prayer that they have made before your lordships in this writ petition? The prayers in this writ petition are, don't proceed with the auction. Now, my lords, now can the scope of this writ petition now be expanded to say, I should ask the bank, or whether he can.
No, but looking at the,
No, and that also, my lords,
looking at the conduct of all these financial institutions or banks, they appear to be like any other litigant. There is no fairness from their side which the court is not able to find.
In light of yesterday's matter, my lords, I can't possibly
Even I
take a
point
different-
out from the guidelines,
possibly
Lordship,
take a
RBI
different
guidelines.
view. But that said, my lord, on the lighter note, when I said that. But in this case, I think there was possibly some confusion with regard to the numbers. My learned friend, my lords, earlier today, Mr. Tahir was not there. My learned friend said the OTS was for 1 crore 80, of which some 95 was paid. Now, my lords, of course, the interest will keep ticking. So as when the loan was assigned to me, the loan specifically said it was 1.3 crores approximately.
When did you pay the amount?
January, February.
OTS was when? When they say that this is so and so, 1 lakh 50, what is
Lordship,
that?
kindly
1 crore
see
50
my page number 17, Lordship.
Page number?
17.
Hmm.
There is an entry on dated 24/1/2030, Lordship.
Hmm.
From 24/1/2030 till February 2nd, 2024, Lordship.
No. When was the OTS? That you please tell.
Lordship, OTS is, Lordship, they had not given us a document to give an.
The amount is specified in which month?
It is on same month, same time, Lordship. February,
It is
January.
what?
In the
January
month of
2024.
January 2020.
2020, Lordship.
January?
2024. When the
25 January 2024, my
Lordship,
lords.
when the
23rd January.
25 January.
25 January 2024.
24.
So
That
on
was
that day,
it was 1 crore?
1 crore 82 lakhs, my lords.
82 lakhs.
Lordship, it was a
When did you pay that 70 lakhs?
95 lakhs. Lordship.
95 lakhs when?
24/1 till 2024. 4 entries are there. 4 installment I have paid it, Lordship.
By
30
2
lakh.
2024, you paid the,
Yes. By
90
February 2000,
lakhs.
I paid 95 lakh rupees. Lordship.
when is the debt assigned to you?
The debt was assigned in March 2025. Little more than a year later.
So even otherwise,
My lords.
so by March 25, that is after a year, this 1.82 minus so and so.
About 90 odd, my lords. Again, with interest of another year, it would have gone up again to 1 point, which is, my lords, in fact, the principal amount also is mentioned in that assignment deed. Principal amount actually is only 1 crore 7.
1 crore 7
1
lakhs.
crore 7. That was, of course, an OTS offer that it never fructified. I think possibly to show his bona fides, he may have paid that 95 lakhs. But my only concern is this, my lords. Now, if petitioners, frankly, my lords, I understand the difficulties going through. But my lords, if writ petitions like this are permitted to expand the scope and now going behind contractual agreements, my lords, then what will happen is anytime any assignment is done, the borrower will come and say, I was ready to pay this much. It should not have been assigned. Frankly, my lords, it's as far as the regulatory mechanism is concerned, I am answerable to RBI. If RBI feels there is anything illegal or untoward in the assignment deed, RBI can certainly hold both of us up, not just me, both the respondent number 1 and respondent number 2. But my lords, at the behest of petitioners, now, which is why I submitted, my lords, whatever amount we have received in addition to what we feel, what we have computed, not we feel, we have computed to be the outstanding amount. The excess amount we have recovered from the auction, we are duty bound to return it to the petitioner. But that is all that his right is right now. There's frankly, Manoj, I asked myself, what other right does he have? At this stage, the 13-2 notice was issued way back in 2022, doesn't challenge it. Finally, Manoj, when the property is put to auction, of course, he paid it in January, February of 2024. Now he says on, if I may use the word, on a slightly extraneous ground, saying that the assignment seems to affect my right. Assignment cannot possibly affect his right. On the ground that I was ready to pay this 90 lakhs, I paid 90 lakhs. It could not have been sold at, let us assume it is 55 lakhs. I could not have, I'm sorry, he could not have sold it to me at 55 lakhs. But that can't be a ground, my lords, to reverse the entire auction. The auction can be reversed on specific grounds if there is any violation of the SARFAESI Act or the rules. But not a single violation is pointed out. And if there's any violation of those RBI guidelines, I'm answerable to RBI. In case it is felt that all of this is done contrary to what the RBI has mandated me to do, RBI certainly can hold both of us up, but not at the behest of the petitioner. Now, the consequence, my lords, may kindly see, the auction will be set aside. Now, of course, there's an auction purchaser. The lordship said not to confirm the sale. We have not yet done anything. We have not even collected that 25% amount in light of your lordship's order. But my lords, the sanctity of the auction process will go merely because of the happenstance of an assignment in the middle. Now, let us assume, my lords, there was no assignment at all. Could the petitioner have come forward? I asked myself. The petitioner could not have come forward. So he cannot take advantage of the fact that the respondent number 1 felt it commercially expedient to assign the loan to me. If the assignment did not happen, what would be the ground? No other ground under the SARFAESI Act. Now, taking advantage of the fact that there is a entry in the statement made by respondent number 1, the entire auction, I would respectfully submit, cannot be set aside unless he shows an infraction of law under the SARFAESI Act or the rules, which I would respectfully submit has not been shown, Manoj, which is why this petition itself, I understand his concerns, but legally, my lords, I don't think he has much of a valid ground at this stage.
If the bank would have been there in their place, we would not have been there. See, assignments are made. So they have to follow certain procedure after receipt of assignment. That is in respect to settlement. They have not approached us for settlement.
Does it mandate?
Oh, no, not under the RBI guidelines, not the RBI.
About all these policies.
So once the debt is assigned to you, you will continue with the proceedings from
As I step into the shoes of the lender in every respect.
We are not disputing NPA, we are not disputing what the position. Once the position was taken, subsequently they have received the money. If they have not have received the money before that, even after receipt of money, they have done all the procedure, then I would not have any ground at all. They have completed the procedure, they have taken over the property, then they had given us an offer to pay. We paid substantial amount from that offer. In spite of that, they had sold it without giving a further opportunity. They had sold it to the assigner. Then assigner receipt by receipt.
That OTS is in the month of 2024. I mean,
Proposed
in the month
OTS,
of January 2024.
Proposed OTS, it never fructified.
Proposal. So from then, you have already paid the amount in the month of. Correct. What were you doing from there? OTS means that is one-time settlement.
There are some 3 months they were given. They had just
We are in 2025 in the month of October. We are.
What has happened? In March 2025, they had taken it. Then subsequently they had sent an email to us to pay 1 crore. So we had sent them, we had given a reply. The reply is also there. Then we have specifically said that he would like to pay 50 lakh rupees to the.
I'll pass orders on Tuesday. No intermod.
And that email also was of May 25 months. Another 5 months have elapsed.
No intermod. Just list this matter on Tuesday.
So whatever protection lordship has given, let it be continued because RBI guidelines are there. Otherwise, I have to direct. Kindly hear me in the RBI guidelines. The RBI guidelines is like that.
Yes.
What will happen?
If RBI guidelines are not followed, give a complaint to the RBI.
Correct.
They will take action against them. Now at this stage, Mr. Counsel, I was not at all convinced only on one point about this 55 lakhs amount. And when they are selling it for 1 crore and odd, that was only, that was the only concern of the court. I've looked at that assignment date. I'm convinced with what has been stated. You can't look at it. Entire, there are so many NPA accounts in that, that's not you. Assignment DDs are consisting of some 160 or
168.
168.
How much amount paid what that is also
Not there. That is not there.
It is 55.
Altogether it is given. Yes.
Cell number 6.
Grateful.
Devi Lokesh.
Otherwise, I will hear me and dispose the matter. So I will have some other video.
Monday, Monday I'll pass orders. Or tomorrow I'll pass orders.
Very,
Tomorrow I'll pass orders. List this matter tomorrow. Till tomorrow, don't do anything. Tomorrow I'll dispose of the matter.
very well.
Yes, list it as part on the top of the list.
Could I actually accept that 25% because I don't want another ground tomorrow saying because Lordship recollects yesterday under Rule 9(3) I'm required to collect that 25% on the date of the auction. I did not collect it. So I don't want that to be 25%. Grateful. I'm grateful.
Yes.
Serial number 16.
For
KB
respondent,
Lopez.
1 year.
Serial number?
Passover matter.
Yes.
For respondent.
Huh? Why? Where is he? I will, now what I do is I will dismiss it without liberty because he has not turned up.
Section 14 order, but petitioner respondent number 224 is borrower. Kindly.
You filed a writ petition. Now you want to withdraw with a liberty. Court should know why you want to withdraw. What is the liberty you are seeking? Just like that, court will not grant liberty. For such a simple thing, you can also tell the court. This is not on Tuesday. Yes, call the list.
List number 3. For orders matter. Hearing on interlocutories.
We are praying for recall, my lord. In fact, we had taken steps, my lord. The very address to which, my lord, we have sent. She has filed a criminal miscellaneous against us from that very address, my lord. She is evading the address. In fact, my lord, the memo also was on record. That was her parents' address, my lord. We took as abundant caution. We served there also. We have served the same cause title also. It came, my lord, unclaimed, not unserved, my lord. And the address also we have served. Now, my lord, yesterday, I'm told, my lord, that the criminal miscellaneous has been filed against me, alleging that, my lord, this is dismissed. Kindly see, my lord, the address mentioned in the, of course, my lord, I should have produced it in a proper manner. Yesterday, I got it, my lord. I have not received an official copy. My advocate there on record says she has filed a criminal
So
miscellaneous.
what has happened in RPFC? Notice is not served on you.
Yes, my lord. Not served. She is not claiming it.
What
Her
is this to IA 1/25 to recall the order dated 21/7?
Yes, my lord. Lordship said that within 2 weeks, within a week's time, if we don't comply with the service, my lord, the petition will be dismissed. We had, my lord, served copy as abundant caution. We served it to her parents' address also.
I number 2 of 25 is filed to condone the delay of 38 days in filing the recalling application. I 1 of 25 is filed to recall the order dated 21/7/2025 for the reason stated. The delay is condoned, and consequently IA number 1 of 25 is ordered.
Grateful.
What happened to the notice?
Notice is unclaimed, my lord. Unclaimed. I will, my lord, in fact, she
The
has
petitioner
served.
submits the notice to respondent as returned as unclaimed, and he'll file the same before the registry.
Yes.
Yes, next.
Serial number 2.
Interim order will be restored, my lord.
Look at it, if an interim order is
There
there
was.
earlier, before. It's
DPO.
there. Yes, 2.
Serial number 2.
Petition, vice petition also.
Mallikarjun.
Maintenance, there is delay of 69 days.
Notice?
Please, emergent
Yes,
notice.
3.
Serial
Emergent
number-
notice to the respondent.
Serial number 3.
Notice to the respondent. 660 days.
For 4 at this court. Serial number 5.
File appearing for petitioners, my lordship. There is no interim order, my lordship. The,
Why you moved the memo?
my lordship, there is FLW has been issued, my lord, against the petitioner, my lordship, and
We'll dispose it of. I will not grant interim order in a 2022-24 matter.
okay, my lordship, but date may be given, my lordship.
I will dispose it of right
Now only, yes, my lordship. Well,
Give
at that
the,
time.
give the file.
Yes, my lordship. My lordship. Kindly peruse, my lordship.
What is the impugned order?
Impugned order at page number 37, my lordship. The order asking this petitioner to pay, my lordship, 15,000, my lordship, as a maintenance amount, my lordship. The petitioner number 1 is,
5,000 to the first petitioner.
yes, my lordship.
3 and 2. 5,000 to the petitioner's number 2 and 3.
Yes, my lordship.
That is 5,000 plus 6,000, 11,000.
Not 11,000, 3,000 for the first petition, second petitioner, and another 3 petitioners are there, my lordship. For them, 2,000, my lordship.
Per month each.
Yes, my lordship.
What are the other petitioners?
My son, my daughter, my lordship.
Who is the petitioner number 2?
Petitioner number 2 is also my daughter, my lordship, elder daughter, my lordship. 3 to 5,
6,000, 12,000 plus 3,000, 15,000.
yes, my lord, total 15,000 amount. My lordship, kindly peruse, my lordship, the order copy of.
What is your income?
My lordship, 15,000 as it's shown in the, this my lordship, as per day, I am a tempo driver, my lordship. I am earning around 500 to 600, my lordship, hardly, my lordship. And
Have 4 children.
yes, 4 children, my lordship, yes. 5 earning that much only as a tempo driver, my lordship. In that amount also, my lordship, I supposed to pay 150 rupees for the rent amount, my lordship. I used to rent my tempo, my lordship. In that I have to take my, apart from that, there is diesel and whatever it incurs, my lordship. My expenses, my lordship. My son and my daughter, they are now major, my lordship. And she's, last time I was ready to pay, my lordship, when I had a tempo, my lordship, my own, my own, my lordship. But my children are not ready to take that amount, my lordship. Kindly peruse, my lordship, at page number 29, my lordship, at paragraph number 20 and 21, my lordship.
Why did you not file documents in support of your income?
My lordship, I have filed it, my lordship. I have no document, my lordship. I had one tempo, my lordship, that is sold, my 1 lakh rupees tempo I had, that I have sold, my lordship, for 50,000 rupees, my lordship. After that, I don't have anything, my lordship. I know driving only, my lordship. Then that's why, my lordship, I started driving what I was doing earlier, my lordship. Apart from that, there is no.
Get 25-30,000 being a driver.
No, my lordship. No, my lordship. That the coolie work I used to get, my lordship. Some work I used to get. Then I used to go and I used to deliver the goods and all whatever.
What do you expect the court to do now?
My lordship, may I allow to pay whatever it is there for my children's, my lordship, and I don't have money, my lordship. 15,000 is my income, my lordship. Out of that 15,000, if I.
My lord.
Huh?
Senior is not present. Senior did not.
Execution is filed, it seems.
Yes, my lordship.
This is
Rest
matter
time.
on Thursday. Till such time, the respondents are directed not to take any, not to precipitate the execution.
Much obliged, my lordship.
Yes.
List number 4, serial number 1, for dismissal.
Respondent number 2, Mala. I have filed wakalat today in this
For
matter.
appellant, my lord, memo for dispensation.
Memo for?
Number 2, my lord.
Memo is filed seeking dispensation.
Respondent number 1.
Notice to R1.
Dispense with, my lord.
Have you served papers on them?
I have filed wakalat today, my lord.
Papers are served.
Please, my lord.
It is submitted that the papers are served on the respondent. Admit post of file hearing. I number 1 of 24 to condone the delay of 333 days condoned on condition. It is, his format is there for that. It's I number 1 of 24 is filed to condone the delay of 33 days. For the reasons stated in the accompanying affidavit, the delay is condoned on the condition that they will not be entitled for interest. Admit post of file hearing, call for the DCR.
Serial number 2,
Third respondent, today,
Nadi.
my lord, today, the third respondent, today issued the appeal memo. Seek
And
time.
counsel for the petitioner submits that the needful is done. Counsel for the respondent submits that the papers are served. List this matter after service of notice on respondent number
3.
1 and 2.
1 and 2.
1 and 2. Yes.
Number 3,
Well, I am for appellant, my lord. Immediately when the notice was ordered, I sent the copies to
Memo is
the.
dispensation of notice to R1 dispensed with. It is submitted
And
that the papers were served on the counsel appearing for the respondent.
Already-
What about your cost of 300?
That is for if non filing, send the copies to the respondent counsel. But I have to pay 300 rupees within 1 week. My lord, immediately on 15/9, I sent the copies and he admitted also.
I number 1 of 25 is filed to cut on the delay of 50 days condoned in all the matters where there is delay above 100, then cost. Below 100, no cost. So this is 50, no cost. Admit file hearing TCR 4.
serial number 4, R2 Tata AAG.
Appearing for the appellant, my lordships filing dispensation for
Memo is
R1.
filed seeking dispensation of notice to
R1.
R1.
R1 dispense with at the risk of appellant.
R2 Tata AAG.
Tata.
AAG.
Mr. Muldidhar N is directed to take notice on behalf of the insurance company Admit.
Delay of
Notice to the other respondents. Dismissal she has given. The I number 1/25 is filed to condone the delay of 14 days condone. Next 5.
Number 5.
Subject matter of the appeal is 70,000. Subject matter of the appeal is 70,000. Accident is in the year 2017. The office raised objection regarding maintainability. But as per the prior to amendment, it was 10,000. Now after post amendment, it is 1 lakh. Is in order to maintain the appeal.
When is the post amendment?
Post amendment is 2022.
No,
1/4/2022 is the amendment date. Post amendment, it has to be below 1 lakh. Appeal will not be maintainable. A prior accident occurred in the year 2017. Therefore, appeal is maintainable.
Is it so? Mr. Krishna Kishore, say.
Yes, sir.
Office objection with regard to the maintainability is overruled. It is submitted that the impugned order is dated.
Impugned order is dated.
Accident is dated.
Accident is 2017. Exact date is 27/1/2017.
And this is much prior to the amendment. And as such, the appeal is maintainable. Who are the respondents?
Owner and respondent. Both respondent notice.
Notice to the respondent, list of the service of notice. Yes.
Serial number 6. Serial number 6.
The appeal is valued more than 15 lakhs. The registry is directed to place this matter before the division bench. Yes, 7.
Serial number 7. Harish Bandaretti.
List this matter on 17th of November.
That is.
A week's time.
Serial number 8.
Default order in 8, a week's time.
My lord, I am for the appellant, my lord. The respondents have already filed, yes, my lord.
PF for R1 and R2.
Yes, once I have given the notice, I paid the PF also, but I don't know what has happened.
When did
My
you
lord,
pay?
my lord, it was on 18/9/25. 18/9/25.
Line counsel for the petitioner submits that
That I sought for stay, my lord.
needful is done. There is submits that the needful is done. What is this case?
My lord, it's an expert judgment against the insurance company. I am ready to deposit 50% of them.
What is it's a case of death or injury.
My lord, it's a case of injury, 5,42,000 is
How much is granted?
5,42,178.
It is submitted that it's an ex parte order. No need is served on the insurance company. They shall be stay or fall for considering the submissions. They shall be stay or fall for the proceedings on the condition that the petition shall deposit 50% of the amount within 4 weeks from the date of receipt of the copy of the order. And on such deposit, the respondents are at liberty to withdraw.
My lord, he's an occupant in the private car, my lord.
Huh?
Occupant in the private car.
We will see.
No,
With all, next
subject to
time,
result of the appeal, it can be.
which is always subject to the result. Yes,
Serial
9.
number 9.
Now for dispensation of notice to R1.
Memo is filed for dispensation of notice to R1 dispensation.
New India Assurance Company.
I 1/24 is filed
New
to
India
condone the
Insurance.
delay of 54 days condone, which is the company?
New India Assurance. New India.
Mr. R.J. Prakash is directed to take notice on behalf of the insurance company. Land counsel says the copy of the appeal memo on the council. Yes, 10.
Delay.
54 days.
Condoned already. Yes, sir. Yes, next 10.
Serial number 10.
Notice to the respondent. 11.
R2 is related India.
We will see. 11 notice.
Serial number 11.
Notice. 12.
Number 12.
Let's this matter on 18th of November. 13th. Notice.
13.
Notice.
Serial number 14.
Notice.
Serial number 15.
Notice.
Serial number 16.
Notice.
Serial number 17.
My lordship's appearing for the appellants in
17.
17. We are filing dispensation.
Memo is filed seeking dispensation notice to R1, which is insurance company.
Cholamandala.
Cholamandala.
Who appears for Cholamandala?
B. Pradeep.
So B. Pradeep is, you appear. Mr. Vijay Kumar is directed to take notice on behalf of the insurance company. I number 1/25 is filed to condone the delay of 540 days. But the reason stated condone on condition that they'll not be entitled for interest for the delayed period. 18 notice,
Serial number 18.
19 notice, 20 notice.
I appear, my lord, I filed an
Serial number 18, my lord, I seek for stay, my lord. There is a delay, I am aware of it, my lord. The 18, because they have filed the execution, my lord.
Who are you?
I'm the owner of the vehicle. There is no insurance in the case, insurance in the.
Then, if there is no insurance, what are the grounds for filing appeal?
Not the thing is, he could not contest the case in the trial court. my lord.
Okay,
That is
let's
the-
forget that you couldn't. Now,
Yes, ma'am.
before this court.
Yes, my
what is
main,
the-
main contention is that, my lord, the vehicle was, in fact, it was not involved in the accident at all, my lord. It was falsely implicated. That is the main ground, my lord. Then the amount, salary has been taken up at 74,000.
Why you didn't contest it?
Lord, at the say of respondent number 2, because he was driving the vehicle, he said that he will take care. That is how it has happened, my lord.
The case of death or injury.
Injury, my lord.
How much is awarded?
10 lakhs, 54,000.
How much you will deposit?
25% of that amount I will deposit, my lord.
I'm thinking about 75%.
Lord,
25% no stay. No stay for the owner like this, without contesting before the court, coming here and telling all these excuses.
Lord, 50% I will do that, my lord.
And they will withdraw 50%. The 18, the petition, the appellant before this court is the owner of the vehicle. It is submitted that he couldn't contest the matter before the court. The vehicle is not involved in the accident, and the compensation amount that is awarded by the tribunal is on the higher side. Considering the same, there shall be stay of all further proceedings on the condition that the appellant shall deposit 50% of the amount within 4 weeks. And on such deposit, the respondent is entitled to withdraw. In all these stay matters, notice to the respondent. Yes, next.
Cell number 19, notice 20.
My lord, I appear for the appellant in this matter. The appellants are the drivers and owner, my lord. The insurance company has responsibility has been imposed on the insurance, my lord, to pay the amount, but permission has also been granted to them to recover it from me on false grounds that the A1 was driving the vehicle who doesn't have a driving license, my lord. In fact, A2 was driving the vehicle. I'm seeking for a stay, my lord, and there's a short delay as well.
How much is the amount granted?
The amount granted is 5,16,800.
That is submitted you're for the insurance company.
No, my lord, I appear for the owner and driver, my lord. The insurance company initial liability was imposed on the insurance.
The present appeal is filed by the owner of the vehicle denying the liability. They shall be same 50%. They're entitled to withdraw. Notice to the respondents. Yes.
Cell number 21.
Lord, anyway, the insurance, my lord, has already made the payment, my lord. Now the only question is whether the insurance can recover it from me. In that context, my lord, let them not. Because in fact, the initial liability was placed on the insurance to make the payment. Insurance company is respondent number 2 herein. And thereafter, liberty was granted to the insurance company to take it.
No. Only stay on the condition of depositing of 50% of the amount.
Please, my lord.
Yes.
21. Anumantappa bus.
Notice.
Cell number 22.
Notice.
Cell number 23.
Notice.
Cell number 24.
Yes, notice.
Cell number 25.
Notice.
Cell number 26.
Notice.
Cell number 27.
Notice.
28.
Just along with so and so take it.
See number 28, New India, R2 is the New India, my lord. Any
Notice.
Cell number 29.
My lord,
Notice.
it's filing
Cell number 30.
dispensation, my lord.
Memo is filed seeking dispensation of notice to
R1.
R1 dispense with notice.
30, my lordships will
Notice.
take notice to both.
Cell number 31.
In 30, my lordships.
31 R3, New United Indian Insurance, my lords.
In serial number 30, my lordships will take notice to both the respondents.
Notice to respondents, yes, 31.
Cell number
31 United Indian Insurance, my lords, R3.
Notice to respondents, 32.
32.
Appellant, my lords.
33.
Dispensation notice.
Memo is filed seeking dispensation of notice.
R1 too.
R1 dispensed with 33.
33 R2, my lord, United India, my lord.
Notice, next 34.
34.
Admit final hearing TCR, all 35, 36 admit, 37 admit.
38, my lord. Dispensation, R1 dispensation.
38. Notice, memo is filed seeking dispensation of notice to
R1.
R1 notice to R2, 39.
39.
Notice.
Cell number 32. 40.
Notice.
41.
Notice.
42.
Yes, 42.
42 I appear for the appellant. But the deceased was a bachelor. Instead of 50%, 1/4 has been taken.
How much is granted?
Pardon, my
How
lord.
much is granted?
29 lakhs 67,000 has been
So
awarded.
if that calculation is done, at least 20 lakhs, you will be liable to
My
pay.
lord, excessive by, I have given the calculation also.
How
9
much
lakh
it will come to?
45,000 is excessive.
And how much?
9 lakh 45,000 is excessive.
Insurance
So Lords may
company?
kindly order 18 lakhs and with
Insurance company shall deposit 19 lakhs.
accrued interest.
Then counsel for the appellant insurance company submits that the court had deducted 1/4 in case of a bachelor and granted amount under the head of loss or dependency. So considering the submission, they shall be stay all further proceedings on the condition that he shall deposit 19 lakhs within a period of 4 weeks in all the matters also 4 weeks.
Sovereign.
To take the format order will be there, take it, 4 weeks. And on such deposit, the respondents are entitled to withdraw the amount as per the conditions laid down in the award.
43.
As 43.
Contributing negligence, please, ma'am. 50% department.
50.
Award amount is
Then counsel
23
submits
lakhs.
that, appellant submits that there is a contributing negligence on the part of the appellant, on the part of the claimant, the same is not considered. Considering the submission, there shall be stay 50%, 50%.
Along with
4
interest,
weeks,
please.
4 weeks, permission to withdraw also. Yes,
Not entire, 50, out of 50%, please.
50% amount they can, yes, next.
Cell number 44.
Notice to the respondent.
Implication of the vehicle. Implication.
44, sir.
Yes.
Control.
Implication of vehicle, my lord. In this case, what has happened is, though he has sustained injuries on 12,
It is submitted that
12/3/18,
the vehicle, the counsel for the appellant submits that the vehicle is implicated in the accident. Considering the same, they shall be stay of all further proceedings on the condition that they should deposit 50% of the amount. No withdrawal permission in this. Notice to the respondent. Yes, all final hearing matters.
My lord, one submission in serial number 46, my lord. Your lordship permitted the claimant to withdraw the amount because of filing of recalling application by the appellant. We couldn't able to.
We will see.
45, 46.
46, Alison. In 46.
Till all these, please look at it, looking at the other matters which are coming. You bifurcate and give the dates. Yes, then what about,
5. List number 5.
yes,
For orders matter, cell number 1.
Appearing for the appellant, my lord, will comply with the office objections by tomorrow, my lord. The copies are ready, my lord.
shall comply with the office objections within a day on such completion. List this matter, this is matter of service of notice on respondent number 2, that is number 2. Next 3,
Cell number,
a week's time, default order.
cell number
4,
4.
also a week's time,
Cell number 5.
a week's time default order. Default order, yes, 6. It is submitted that the needful is done. Just after service of notice, 7.
7.
A week's time default order, 8.
I appear for appellant in this case. Whatever they mentioned in that
Serial number
judgment in
7?
this address, I taken step in the same address. Now they are filed an execution petition before the. So I sought for the stay.
Where is this? This matter on Monday, 8 on Monday, 9.
Cell number 9.
Objection shall be complied with within a week.
Cell number 10.
Memo is filed seeking dispensation of notice to R2 dispensed with I number 1025 to condone the delay of 37 days. Condone, admit final hearing TCR.
11. Gita.
I number 1025 to condone the delay of 456 days. Condone on condition. 12.
I'm appealing
Admit
for
post for final hearing TCR. 12.
appeal for appellant.
Cell
Acknowledgement is filing with memo.
The
On
I number 1025 is filed to condone the delay of 169 days in filing. Condone, admit final hearing TCR. 13.
Cell 13.
I number 1025 to condone the delay of 92 days. Condone, admit final hearing TCR.
Cell 14.
That is also I 1025, 85 days. Condone, admit final hearing.
60 days delay in filing appeal.
60 days.
Meanwhile,
Condone,
call parties here, man.
admit final hearing. 16.
16.
Appear for the appellant, my
Notice
lords.
to the respondent.
My lords, facts are such that, my lords, the amount of 6,61,000 was awarded, my lords. I'm disputing 5,51,000 as that has been awarded by the insurance company itself. And the balance 1,35,000 has already been deposited before the trial court and they filed an execution petition also, my lords. So I'm seeking a stay of the order, my lords.
If you're disputing also, you have to deposit 50%.
Let,
Only
but,
for
but
the,
including the 1,37,000 that has been deposited, my lord,
the, whatever it is, total amount I'll say.
please.
The petition, the land calls for the appellant submits, they're disputing the quantum of amount. There shall be stay of all further proceedings on the condition that he shall deposit 50% of the amount. In that, the respondents are at liberty to withdraw
1,37,000, my lord.
1,37,000 within a period of, in all these stay matters, 4 weeks notice. Yes.
17.
IA number 1/25 to condone the delay of 404 days condoned on condition.
It's not 1,37,000, my lord, it's 1,25,560.
25,000, they are at
560.
liberty to withdraw. Yes. Admit final hearing TCR 18. I number 1/25 to condone the delay of 71 days condoned.
Maybe disposal, the case of death, my lord. Maybe next.
Fourth. Yes, is this matter on fourth?
Please, my lord, much obliged.
Yes,
Cell number 19, admission matter.
admit.
Cell number 20,
20 also.
21.
Admit.
Appellants, my lord. It matters likely to be settled.
Which one?
21.
Yes, 21.
In respect of 22.
21.
21.
When do you want?
2 weeks, my lord.
Does this matter after 2 weeks?
Kindly see the order sheet, my lord.
22.
22, they have not deposited 50% of the amount, my lord.
Vijay Kumar TM. List this matter on Monday. It is submitted that
Not
the
deposited,
amounts
and
are not
also
deposited.
this court already ordered, my lord, to execute the award. Kindly see the order sheet of 27/2/2025.
This matter lists on fourth along with other matters. Yes, 23.
Hello. In this matter, my lord, owner is disputed. Ownership, I am transferred on online. It is covered by 3 judges of the Apex Court and also res integra. This court held so in say more than 6 decisions. Ownership is disputed. Tribunal held is the owner.
Yes, next 23.
23. Raju, yes.
Admit final hearing. TCR.
With kind permission, madam. Serial number 5 in list number 4. Respond number 2, the insurance company, panel advocate may be taken.
There is no time today. We'll see some other day.